it was them. We knew they were in Parsons.
Then why go get it?
Thank you
After-
for asking. Thank you for asking. So you hired a pseudo investigator slash forensic psychologist slash other thing. I shouldn't, does she still have her license? Because I know they were investigating. She intimidated a witness, Miss Britt, I don't remember her first name, who contacted TBI and advised that she'd been threatened. This is the same person who purchased domain names, my name, my election names, that you connected them to your client's website, so that if somebody looks me up
So sad.
and missed
So
my
sad.
actual, but it says Jennifer Nichols, Judge, goes straight to the domain name.
So I felt like we just needed to start with that throwback, because where we left off last, as we were going through the post-conviction relief filings, was the subpoena for Katie Spirko and the notice of appearance by Dana McClendon on behalf of Katie Spirko. So good morning, good evening. Hope everybody is doing well today. We are going to be going through the docket on these post-conviction relief motions. I think they're doing updates on the innocentbrothers.com website. There's like an access window now for the trial transcripts and a few other pages. It looks like they created user roles but didn't set any permissions. So we will be doing trial transcripts, but gotta wait for them. Working on websites isn't easy or fast. So, but that is still gonna happen. We are still gonna look at the sidebars. Whew, let me say hello to everybody. Let me be polite. Sorry for being late. Hey, Keith. Hey, YSL Kells, good to see you. We've got the name back. Hey, First Best Gigi. Hey, Sheriff Chuck, good morning. Cat and Chat, happy holidays. Right back at ya. We've got O'Bailey's here, bright and, well, evening-y for you. Good to see you. Hey to Christy. Hey to some guy with cancer. Keeping you busy on your drive. Christy also asked, is Dylan currently residing with Dennis Benjamin? He lived with Dennis Benjamin for a few weeks after his, do I need to look? Can we do the timeline? So he gets out of federal holding in August. Let's look at this timeline. So he gets out of this federal holding, gets a nice plea deal, gets probation, and he's sent in August of 2014 to live with Dennis Benjamin. And after he's been there for about 5 weeks, suddenly, and after Holly's skull is found, suddenly Dennis Benjamin is marching him in to speak with Booth and Jackson. And then we have that interview. So he's in custody. He's incarcerated. Remember, he ended up taking a plea after Zach Adams was convicted. His brother was convicted. And his sentence was like 36 years. So he is in custody. But yeah, apparently a very productive 5 weeks that he went and lived with Dennis Benjamin. Oh, what a trial, what a case. And thank you, Sheriff Chuck, for also jumping in with that context here in the chat. Hey to Philly. We've got, hey Gwennon, good to see you. Good to see KLB. Got everybody in the building. Hope everybody, if you guys celebrate the holidays, you guys are getting ready for the holidays, and you're getting past that stressful time of getting everything together, getting presents wrapped, and getting to enjoy the season. Jimmy has the day off. Love to hear it. DB must be reacting to the video we opened with. Just go, Snake, it's Janet, ma'am. Hey, Lady L. Hey, Jazzy Cat. Hey, Christy. Good to see you. Yeah, everyone's reacting to that clip. This is bad Jennifer, Brooklyn, what we were watching that clip of. That is bad Jennifer. Yeah, blessed Yule. I like that. Hey, Morel. Good to see you. We've got AB in the building, Lexi the Law Nerd, Linda. We got Debbie. All right. I think I got everybody. Oh, nope, I lied. We have Linda, and we also have Dramatis Persona. There we go. So guys, let's get into it. We last left off here we're just going to go straight through it. So we've got a scheduling order, and normally this wouldn't be too interesting, but I still think it's interesting that the judge wanted to set multiple hearings and have a chance to hear everybody, have a chance to digest a huge record. Usually I'm used to hearing courts be like, all right, we've got like one day, when can we get this moving? But this is how they slotted out 2024. And then in 2025, they are going to start doing the hearings. We didn't get to watch anything from the January hearings. We just saw that one little clip yesterday. And then let's see. No ex parte communication should be made absent exigent circumstances. I think a very good warning if you joined the stream yesterday and got to hear what we got to hear about ex parte communications. Yeah, very important to put this in here. All communications to the court or staff should be shared with all parties. Scheduling conversations may be made with staff with all parties aware of the communications. So, good reminder there, and this is all the way back in May of 2024. All right, the next one we've got is motion to dismiss the quorum nobis petition. So this one's going to be a long one, guys. We're going to get right into it. So this is the state writing this motion to dismiss Petitioner Adams' writ of error quorum nobis without an evidentiary hearing. Don't even give them the hearing. Well, judge gave them like a million hearings. So it comes down to the state of Tennessee, by and through undersigned counsel, moves this honorable court to dismiss Zachary Adams' writ of error quorum nobis without the evidentiary hearing. So what are their grounds? The procedural history. And we might know this background, but let's see how they write this up. Mavhawk says, can we make it Comic Sans? Can you even change the font in something like this? I could probably do it if I put it into like a proper PDF editor. We read all of the state's motions in Curl's MT font. Oh my goodness. All right, so we've got on September 22nd, 2017, the petitioner Zachary Adams was convicted by a Hardin County jury of first-degree murder premeditated, first-degree murder committed during the commission of a kidnapping, first-degree felony murder committed during the commission of rape, 2 counts of especially aggravated kidnapping, and 3 counts of aggravated rape. This court merged the first-degree felony murder convictions with the first-degree premeditated murder conviction. The court also merged the 2 especially aggravated kidnapping convictions and 3 rape convictions. Prior to a sentencing hearing, the parties announced a sentencing agreement, being an effective sentence of life imprisonment without the possibility of parole, plus 50 years. This court denied the petitioner Adams' motion for a new trial on August 11th, 2020. That was before Judge Creed McKinley retired. So when we're saying this court, that was still under the previous judge, not Bradbury. So the Tennessee Court of Criminal Appeals affirmed the judgment of the trial court on September 9th, 2022. I linked in the description. We listened to those oral arguments for the appeal like a week ago, but I linked it in the description if you missed that. Jennifer Thompson did not do an impressive job, if you ask me. That was denied on July 28th, 2023. Petitioner Adams filed a pro se petition for post-conviction relief in this court, so he's trying to do this on his own. On August 18th, 2023, the court entered a preliminary order, a colorable claim, for Petitioner Adams' post-conviction relief claims and appointed him counsel. And oh, what a turn of events. On January 22nd, 2024, Petitioner Adams filed an amended petition for post-conviction relief. On the same day, Petitioner Adams filed a petition for writ of quorum nobis, raising for the first time a claim of newly discovered evidence. On April 11th, 2024, Petitioner Adams filed an amendment to petition for error quorum nobis. All right, so now they're going to address what quorum nobis allows. So the writ of error quorum nobis statute, Tennessee Code and annotated section 40-26-105B. I should actually probably see what that says. Let's see. Yeah, okay, it's annotated. There we go. Requires that the basis for a petition for writ of error quorum nobis be, quote, subsequently or newly discovered evidence. The writ of error coram nobis is an extraordinary procedural remedy, filling only a slight gap into which few cases fall. Well, chat, let's take an informal poll. Just type out your answer in the chat. Do you think that this case should fall in that gap where we need an extraordinary procedural remedy to right an injustice? Because I'm fully there for like 10 reasons. Just saying. It is known more for its denial than its approval. The decision to grant or deny a petition for writ of error coram nobis rests within the trial court's sound discretion. A petition for writ of error coram nobis must relate to 1. The grounds and the nature of the newly discovered evidence, 2. Why the admissibility of the newly discovered evidence may have resulted in a different judgment had the evidence been admitted at the previous trial, 3. That the petitioner was without fault in failing to present the newly discovered evidence at the appropriate time. Yeah, maybe because they're sitting in a court during one of these hearings that was scheduled as a result of this petition. And they see their truck that they said, they've been saying, would have been their alibi if there was this ATM surveillance video footage, and then he sees his truck on the prosecutor's screen during the hearing. I would say that's the petitioner being without fault. And then 4, the relief sought by the petitioner, which we know they're seeking a new trial. And before we go on, I think, let's see, we've got yeses, absolutely. We've got a lot of yeses, lots of hundreds for sure. And DB says, I can only think of a handful of cases more deserving. So, yeah, Sheriff Chuck, let's not forget, before we read the rest of this motion, let's remember the most important thing here, that Jennifer Nichols says, I would never lie to a jury. So, Miss Nichols. The Tennessee Supreme Court has held that to be successful on a petition for a writ of error coram nobis, the standard to be applied is whether the new evidence, if presented to the jury, may have resulted in a different outcome. To be considered newly discovered, the evidence must have been unknown to the petitioner, not petitioner's counsel, not a hard drive, not somebody who talked with somebody that at one point may have been part of the team. But did the petitioner know? A petitioner cannot premise relief on evidence which is merely cumulative or serves no other purpose than to contradict or impeach. And then let's see. A petition for writ of error coram nobis is subject to dismissal on the face of the petition without discovery or an evidentiary hearing, and even prior to notification to the opposing party. Traditionally, a trial court has been expected to dismiss a petition which is insufficient on its face. Well, I guess we cleared that hurdle. While some petitions cannot be resolved on the face of the petition, the court need not hold a hearing unless it determines a hearing is essential. Accordingly, the contents of the written petition are of the utmost importance. Judges anticipate that the petition itself embodies the best case the petitioner has for the relief from the challenge judgment. Thus, the fate of the petitioner's case rests on the ability of the petition to demonstrate that the petitioner is entitled to the extraordinary relief that the writ provides. And I just think this is like crazy to read. We're in the middle of page 3 here. But so the 9th of May, this was filed. But we just have this scheduling order on the 1st of May. So, I mean, the state shall file their motion to dismiss by May 8th. So they were a day late on that. They're laying out all the times, but they're already scheduling these tentative hearings, right? So it seems like the court thinks there's enough reason to block off all of these dates on the calendar. Even before this motion to dismiss that was filed a day late. But whatever, it is what it is. But here they are saying, we hope you just dismiss this without scheduling a hearing. So we've got, of course, there will be instances in which the request for coram nobis relief cannot be resolved only on the face of the petition. However, trial courts only need conduct evidentiary hearings when they are essential. Let's do like 5 sets of them. All right, so now we're getting to argument, you guys. This court should deny Petitioner Adams writ of error quorum nobis without an evidentiary hearing. First argument is that the timeliness. They're going to say it's untimely. A petition for a writ of error quorum nobis must be filed within 1 year after the challenge judgment becomes final. So they see Tennessee Code annotated section 27-7-103. Maybe over time I'll get used to what all of these mean. Like we got used to certain sections, certain statutes in the Georgia Code. A timely filing of a petition for the writ of error quorum nobis is an essential element of a quorum nobis claim. Petitioner Adams was convicted of the crimes at issue in Hardin County Circuit Court on September 22, 2017. On September 9, 2022, the Tennessee Court of Criminal Appeals affirmed Petitioner Adams' convictions. The judgments in the present case became final 30 days after the Court of Criminal Appeals entered its opinion on September 9, 2022, affirming the trial court's judgment of conviction. Because this petition was filed on January 22, 2024, it is undoubtedly untimely, as it is after the 1-year statute of limitations pursuant to Mixon and Nunley. Accordingly, the petition is time-barred unless the petitioner Adams demonstrates he is entitled to equitable tolling of the statute of limitations. So, I'm sure we'll see in something else on the docket that addresses that. Next argument is that petitioner Adams fails to allege any facts that would warrant equitable tolling of the statute of limitations. So to accommodate due process concerns, the 1-year statute of limitations may be tolled if a petition for writ of quorum nobis seeks relief based upon new evidence of actual innocence discovered after the expiration of the limitations period. And what's interesting, I mean, are they going to rely on the Autry recanting? Because I think that was December 2023. In the event of a quorum nobis petitioner seeks equitable tolling of the statute of limitations, the petitioner must allege the specific factual basis upon which equitable tolling is sought. So they say to be eligible, a prisoner must demonstrate with particularity in the petition, 1, that the ground or grounds upon which the prisoner is seeking relief are later arising grounds. That is, grounds that arose after the point in time when the applicable statute of limitations normally would have started to run. And 2, that based on the facts of the case, the strict application of the statute of limitations would effectively deny the prisoner a reasonable opportunity to present his or her claims. A prisoner is not entitled to equitable tolling to pursue a patently non-meritorious ground for relief. Furthermore, actual innocence means nothing other than that the person did not commit the crime. Okay. All right. I mean, yeah. Is this like, it's no big deal. It's no big deal if someone was actually innocent. Tolling supersedes. And that's why you get, someone has an egregious sentence. They could have the option to take the habeas route, right? And say, hey, there's new evidence that we think supports actual innocence. Maybe the quorum nobis vehicle won't be the right vehicle for that. But this kind of leaves people in a gray area where, habeas might not be an available avenue. So, I don't know. It's kind of like they're laughing like, haha, too bad, too sad if you're actually innocent. Petitioner Adams' petition for writ of quorum nobis does not contain facts to support the equitable tolling of the statute of limitations to avoid being summarily dismissed. Well, I love reading this knowing that Judge Bradbury was not with it. Like, all of these arguments, ultimately the judge said, no, we're going to have hearings. The evidence contained in the petition filed on January 23, 2024, which petitioner Adams asserted supported his contention of newly discovered evidence, consists of the unsworn statements of Lisa Carroll contained in a video recording. Oh, there's a video. Exhibit 1 to the writ. Now remember, Lisa Carroll is the one who I think she was describing seeing like a dirt bike on the morning, maybe thinks that she saw Britt, like when she saw pictures of Terry Britt in the following weeks after the abduction, she was like, that's who I saw, and I told my friend about it. So that's the Lisa Carroll statement here. And then 2, the unsworn statements of Jason Autry, Petitioner Adams' co-defendant, contained in a video recording recanting his trial testimony, and a signed affidavit of investigator Katie Spirko, Exhibit 3 to the writ. Also, I think it's worth saying here that Lisa Carroll had put in a tip, had put in some type of information closer to the time of the abduction. So if that wasn't the case, I'd say, hey, maybe this Lisa Carroll situation is no different than someone coming out now and saying, I was on a boat on the day of the abduction and I heard a gunshot. Because that's apparently the state plans to call a witness now that they're going to be presenting their side of arguments on the 29th. That's for the first time ever going to come and say this stuff. Where did they come from? Why didn't they say anything sooner? But Lisa Carroll had tried to say something sooner. And nobody did anything with it. So we've got, let's see. All right. Importantly, Exhibit 1 and 2 are not affidavits from an individual with personal knowledge to substantiate Petitioner Adams' claims of newly discovered evidence. Are they just saying that Lisa... Are they taking issue with it not being in the form of an affidavit? Meaning it's not sworn? Okay, I think they're taking an issue with it not being sworn because they're providing the videos rather than a sworn affidavit. So I think that's the point they're making here. Although Katie Spirko's statements in Exhibit 3 are set forth in an actual affidavit, many of the statements contained in the affidavit lack any personal knowledge of the declarant and simply restate the unsworn statements of Jason Autry, Lisa Carroll, and others. The same is true of Petitioner Adams' amendment to his petition filed on April 11th, 2024, which includes an affidavit signed by Jennifer Thompson, Petitioner Adams' trial counsel. Neither the amendment nor the signed affidavit contained in Exhibit 4 contain any facts evidencing that some newly discovered evidence was discovered after Petitioner Adams' conviction. Because Petitioner Adams has failed to request equitable tolling with a sufficient factual basis to support such a request, the court should summarily dismiss the writ as time barred. All right, so there we go. Let's see. Now we're going to get into out of the time and statutes, the tolling, and we're going to move over into, well, it's not enough evidence to make a difference. Shout out to Jimmy for becoming a member. I swear you've been green before, but maybe I've just known your name for a while. Thank you for supporting the channel. Whew. And let's see, let me go back over here and see what you guys said so far. Hey, Take It to Trial, wishing us all a happy holidays. Good to see you. Let's see, is Dennis his cellmate? Uh-oh. Uh-oh. Yeah, Sheriff Chuck says, look how that timeline has grown, more and more coming to light. And really, that timeline was meant to just highlight how we get to Jason Autry taking a plea that, even though we know in 2017 before the trial, the court is aware, the state is aware, we have on the record that's acknowledged, that in February of 2017, everybody but the defense was aware that Jason Autry would not need a trial date, but everybody is also scrambling to say, well, there's no formal agreement in place, so you can't properly impeach Jason Autry when he's on the stand and you're cross-examining him. Sorry, Jennifer Thompson. Like, that whole timeline was about just crafting the conviction, getting details. Dylan's not going to work. We can't put Dylan on the stand. So now we need to shift to Jason. And then how do we make Jason look credible? Well, we feed the details to Victor Dinsmore. So if we did a full timeline of all the details, that would be huge. Hold on, wait. I can share a link to the timeline. I think. Okay, I don't see like a link that I can share where it would be hosted Oh, actually, yes, I can. Okay, so timeline link going in the description. And when I'm done with the stream, when I have some downtime, I'll like make it more accessible or find a way to make it collaborative. I don't know, maybe the viewer option, it's like a view option right now. Maybe you guys can like add comments. But we'll figure out something to do. I'll play with it off stream. We've got, let's see. Oh, we got some Christmas shopping. Heck yeah, one more day. You gotta get it done. Final hours. I know some stores like Target are open late on Christmas Eve. So last minute shopping, be nice to the employees. Be nice to the retail workers. Sheriff Chuck with the reminder that ex parte is fine if it only lasts 2 to 5 minutes. And you have to distinguish, because if it's 2 minutes, you can't just say less than 5 minutes, because 2 minutes is different than less than 5 minutes. Oh my goodness. Thank you, Gigi, here for the reminder to hit the like button. Also, we've got, let's see, I saw Amy in here. Shout out to the wonderful Amy E. Make sure you guys are checking out her channel. It should be linked in the description for easy access here. Hope you're doing well, Amy. Some guy with cancer says Jennifer Nichols would never mislead a jury. And Fani Willis is the best DA in Southeast United States. Yeah, that was a big claim. You know, just take a quarter of the country, a whole giant regional block, and just say, I'm the best. That's okay if you're late, Melissa. We love replay and speed up crew. Hey, Brett. Hey, Touche. Got everybody joining in. Lisa Carroll is the one mentioned in this filing that we're looking at, right? But Lisa Sanders seems familiar. Is Lisa Sanders like Autry's wife, but her maiden name? Lisa Autry? Or is that Linda? I gotta get my L names right. I've gotten good with the Jennifers, guys. And I've gotten good. We had Nick Barris and Nick Leonardo doing a lot of the reporting. I'm getting used to the Nicks. But now I gotta learn the L names, the Lisas and Lindas. So back over here, we've got, let's see. We were at this argument here. And hold on. Thank you, Sheriff Chuck. I see green in the corner of my eye here. Shout out to Sheriff Chuck dropping 5 gifted subs in the chat. Christmas is early. Let's make sure if you got a gifted membership, say thank you to Sheriff Chuck and check out the channel emojis. There's a Doug Bates emoji in there for you guys. And if you want, maybe I can make like a lean back Jennifer emoji. Let me know. Let me know. It'll be sponsored by Sheriff Chuck. We've got, even if the court finds that Petitioner Adams' writ sufficiently tolls the statute of limitations, the writ of error coram nobis is not supported by proper affidavits. Yeah, they had an affidavit issue. And is insufficient to establish actual innocence. And we've got a quote here that a motion or petition seeking a new trial based on newly discovered evidence must also be supported by affidavits. The affidavit supporting the grounds for relief should be filed in support of the petition or at some point in time prior to the hearing. Well, get the highlighter out. This seems very important. You guys are going to see how bad my my mouse highlighting is. I can't do a straight line without a ruler. But we have this very important phrase, or, not and, or at some point in time prior to the hearing. Look at that wiggle. So, if the hearing hasn't happened yet, and they have all of the room to file an affidavit before the hearing, that kind of defeats your argument that they didn't submit affidavits at this time. I don't know. Oh, wait, hold shift when I highlight? No. I've got to get whichever one you have, because this is horrible. I am a bad underliner. Maybe I could just use lines. Or how does this work? Oh, this is better. We'll do that next time. All right. So let me get out of this for now. Such an affidavit, like the testimony of a witness, must be relevant material and germane to the grounds raised in the petition, and the affiant must have personal knowledge of the statements contained in the affidavit. Affidavits of the witnesses through whom the newly discovered evidence is sought to be introduced must explain the materiality of the evidence and must state that the evidence was not communicated to the prisoner or his or her trial counsel prior to the original trial. An affidavit that fails to meet these requirements will not justify the granting of an evidentiary hearing, since the information contained in the affidavits, taken as true, would not entitle the petitioner to relief. If an affidavit is sufficient and therefore justifies an evidentiary hearing, then the coram nobis court should not determine the merits of the petition based on the strengths of the affidavits alone. Much like the error coram nobis petition itself, the affidavit supporting the petition must set forth with particularity facts showing that the petitioner and his trial counsel exercised reasonable diligence and were not negligent in searching for evidence prior to trial, and that petitioner and his trial counsel okay, let's break out the highlighter again, because this part is not in quotes. Namely, and his trial counsel is not in quotes. And then likewise, here, and his trial counsel is also not in quotes. So is Jones v. State saying that if trial counsel was aware, even if I don't know. Because the previous language said the petitioner, the awareness of the petitioner. And the petitioner in this matter is Zachary Adams. The petitioner does not include trial counsel. So I don't know. That seems kind of important. But anyway, they're saying here outside of quotes that petitioner and his trial counsel had no pretrial knowledge of the allegedly newly discovered evidence. For a petitioner to be entitled to relief through a petition for error coram nobis, it must be established, and the trial court must find, that the subsequently or newly discovered evidence may have resulted in a different judgment had it been presented at trial. This rule presupposes that the evidence A would be admissible pursuant to the applicable rules of evidence, and B is material to the issues or grounds raised in the petition. All right, so first they're gonna address the unsworn recorded statements of Lisa Carroll. And it's unsworn because we don't have an accompanying affidavit from Lisa Carroll. At least maybe we'll get one, but at this point in time, we don't have one. So, oh, DB says, I do appreciate your highlight instead of the people that highlight 95% of the document. If you heard me say yesterday, I couldn't do a stream on what's going on with the Fat Joe cases, really around what attorney Tyrone Blackburn is doing. It would be, the reason I can't do it is because I just want to highlight everything on the page. Like, what is this guy arguing? What is this guy writing? So that's why I can't do a video on that, because I would be that person with the highlighter. So we've got Exhibit 1 to the writ, the unsworn recorded statements of Lisa Carroll. The statement provided by Lisa Carroll in Exhibit 1 does not meet the Nunley standard for witness statements attached to a petition for a writ of error coram nobis. According to the standard, to warrant an evidentiary hearing, the witness introducing newly discovered evidence must submit an affidavit explaining the significance of the evidence and confirming that it was not disclosed to petitioner Adams. And here they're saying again, or his attorney prior to trial. So, and I guess the assumption would be, good faith. We would believe that if it was provided to his attorney, then the petitioner had access to it. The unsworn, unnotarized statement provided by Lisa Carroll in Exhibit 1 falls short of this standard. It lacks the necessary formality of a notarized affidavit as required by Nunley, is inadmissible hearsay, and should not be considered by this court unless properly authenticated and admitted pursuant to the Tennessee Rules of Evidence. Even assuming an arguendo that Ms. Carroll's statements captured in the video recording were in the proper form of an affidavit. Her statements still do not warrant an evidentiary hearing. Ms. Carroll's statement does not adequately set forth what is newly discovered evidence or explain the materiality of such evidence. Now, Exhibit 2 to writ, the unsworn recorded statements of Jason Autry. So this is the recanting. Likewise, and I had mentioned Miss Janet Demeanor was doing a video on the Jason Autry recanting. She also had Nicole Weisler? Yeah, I think it was Weisler is her last name. She's helping with the Trial and Error podcast. She's part of Dana McClendon's team. She did an interview for like about an hour of her time discussing the surrounding context, like why they went in, how they did this interview with Jason Autry, the vibe of the community, a bunch of different, it was a great conversation. So if you skip that one because you're like, well, I've already watched the recanting, there was a lot more. There was like a whole hour, totally worth the watch on Miss Janet Demeanor's channel, and she's linked in the description too. So while we're thinking about this Jason Autry recanting, just wanted to like add that extra bit about the interview she did yesterday. So back to this filing. Likewise, the unsworn, unnotarized statement provided by Jason Autry, and we spelled coram nobis wrong earlier and I didn't call it out, but now we've got the wrong Autry, lacks the necessary formality of a notarized affidavit as required by Nunley standards for witness statements attached to a petition. To warrant an evidentiary hearing, the witness introducing newly discovered evidence must submit this affidavit. Same argument. The unsworn notarized statements contained in Exhibit 2 lack the necessary formality like a notarized affidavit and should not be considered unless it's properly authenticated. And we know that Jason Autry was too dangerous to transport, so he wasn't going to come into court and authenticate this. And then if it's not an affidavit from an individual with personal knowledge to substantiate Petitioner Adams' claim of newly discovered evidence. And then also, at the end of our media deep dive, like we wrapped up watching the compilation of the different media coverage, Nick Barris got a new, I think it was 2022 around the time of the appeal, a new letter from Jason Autry. And Jason Autry, he expressed that, he didn't think things were done right, but he also said that he wouldn't be willing to help with an appeal or if there's a new trial, that he wouldn't want to speak to anybody. So I thought that was an interesting news update there. Again, that was around the time of the appeal. Even assuming an arguendo that Mr. Autry's statements, we got his name correct again, statements captured in the video recording were in the proper form of an affidavit. You know what's funny? To be honest, you probably could have had Jason Autry write everything out on a piece of paper. That guy seems like he loves to write his letters. So they probably could have had it all spelled out and signed off on. So his statements don't warrant an evidentiary hearing. Petitioner Adams was aware at the time of the trial that Mr. Autry initially denied any involvement in these crimes to law enforcement and to others. Mr. Autry's credibility was thoroughly impeached during cross-examination. They couldn't get into agreements because you guys played shady with how you were conferring certain benefits. Thoroughly impeached during cross-examination at trial by Petitioner Adams' counsel Jennifer Thompson. The jury was aware of inconsistencies in his testimony. Well, then we get to the... I don't know. Was Jennifer Thompson aware of the inconsistencies? If Autry's statements in Exhibit 2 were in fact in the form of an affidavit, it would be merely cumulative to the impeachment evidence that the jury already heard. All right. So and actually, hold on. This holding here says, they cite Keller v. State, but the holding says coram nobis claim was meritless when the evidence at issue was both cumulative and inculpatory. How would Jason Autry, because the coram nobis claim, the evidence at issue for this particular argument is this recanting video. How is that inculpatory? That case law, even the holding that they cite, doesn't support the paragraph, doesn't support their argument. Maybe cumulative, slightly, but inculpatory. Are they really saying that this applies to the Jason Autry recanting? How is that inculpatory to Zachary Adams at all? Anyway, you can write whatever in an argument, I guess. So we've got Exhibit 3, Katie Spirko's affidavit. Now let's watch. Is this going to be like longer than the rest? No, okay. They spend one paragraph. Although investigator Katie Spirko's statements contained in Exhibit 3 to Petitioner Adams' writ of quorum nobis are properly attached as a notarized affidavit, there are numerous statements included in the document that lack personal knowledge of the declarant, specifically paragraphs 6A, 6B, 6C, 6E, 6F, 6G, 6H, and 6I. The affidavit of Katie Spirko consists of hearsay and presents no personal knowledge whatsoever that amounts to newly discovered evidence or its materiality. Now, those were... I'm not crazy, right? Those were... Let's go back to the amendment. Was that sealed? Because I remember Thompson's. Let's see. So I remember we had Jennifer Thompson's. I remember there was one from Zachary Adams where he was saying that he wasn't aware of these things. All right. Nothing in the April 14th amended petition. Let's check the January one. Yeah, this is only 13 pages, so... Yeah, I don't think those affidavits... were public. I don't really remember reading this. And I don't think I've lost that much of my recall over the last 2 weeks since we would have done that first stream on these documents. So I just think it's interesting that they aren't spelling this out and they're keeping it short. I think the idea would be they know that unless they spell it out in a motion through argument, that the exhibit themselves aren't currently public record. So if they were to spell out and hash out the issues, the particular issues that they have with these statements or who they're from, and say things like, well, this is from John Doe, but we don't have an affidavit from John Doe. They're not going to spell that out because that would cue the public, anybody that access these public records, into, oh, who are these other people that are stepping forward and saying something? So the affidavit of Katie Spirko consists of hearsay and presents no personal knowledge whatsoever that amounts to newly discovered evidence or its materiality. I think it was very intentional that they kept this short. Exhibit 4, Jennifer Thompson affidavit. Similar deficiencies exist in the statements contained in Jennifer Thompson's affidavit. Although it was a signed affidavit by Petitioner Adams' trial counsel, Jennifer Thompson fails to set forth any newly discovered evidence, explain the materiality of such evidence, or state that the evidence was not communicated to Petitioner Adams prior to the original trial. Should we just reread what Jennifer Thompson's was? I think hers is pretty short. All right, so this was submitted as part of the amended petition in April. Affidavit of attorney Jennifer Lynn Thompson. I'm an adult. I was appointed to represent Zach Adams in his 2017 trial. On January 21st, I might have to add this to my timeline, guys. On January 21st, 2017, I received a call from attorney James Simmons. Mr. Simmons informed me that Jason Autry, a co-defendant in Mr. Adams' case, had reached an agreement to cooperate with the state of Tennessee against my client, Zachary Rye Adams. Mr. Simmons had spoken with Michael Scholl, attorney for Jason Autry. On January 27th, 2017, attorney Michael Scholl called me and we spoke for an hour by telephone. Mr. Scholl outlined the same basic facts that Jason Autry testified to at trial. Mr. Scholl did not include many details in the information that he provided to me. Mr. Scholl told me that Jason Autry would be testifying that he had seen Mr. Adams shoot Holly Bobo with a gun while under the I-40 bridge crossing the Tennessee River. Now, remember, they didn't have like the gun information turned over. They didn't have the 3 pictures at this point. Mr. Scholl told me that in exchange for his testimony, Jason Autry expected to receive no additional prison time beyond the federal sentence that he was already serving. Mr. Scholl explained that there were no law enforcement agents at the meeting, only attorneys for Mr. Autry and the state of Tennessee. I believe this. Oh, I believe this. I believe this. The significance of having no outside witnesses was that Mr. Autry's 3-day interview with the prosecutors had been constructed such that there would be no discoverable reports. So it was a 3-day interview, no discoverable reports. And let's see, by not including any law enforcement agents in the meeting, the entirety of Mr. Autry's interview would be considered the district attorney's work product and forever off limits to me. Yeah, and I don't think they're dumb enough to not realize that. That seems very intentional. One of the best ways to have impeached Mr. Autry's testimony at trial would have been to compare his trial testimony to his statement to prosecutors to show inconsistencies, lies, or omissions. And she could not do that. She could not do that. So I get it. You could point out some inconsistencies, but to be honest, I really think that the inconsistencies that were available at trial were because Jason Autry simply wasn't a credible witness in a bubble, let alone if the defense had been able to work with all this other stuff that we became aware of because of these post-conviction relief proceedings. But yeah, the jury could have then used these discrepancies to determine that Mr. Autry was fabricating his version of events, especially if she had been able to confront him with a formalized agreement, and that the jury was instructed that they could include promises of leniency in the things that they could consider, and not just immunity offers and stuff that was actually formally granted. Under typical conditions, there would have been a Tennessee Bureau of Investigation agent in the meeting to make notes and generate a report. And remember, Brent Booth is saying he has no idea what Jason Autry said during his proffer session. He is aware of the proffer session. He says he has no idea what happened during it, and yet he knows. I feel like that Victor Dinsmore recording probably has more information in it about what was said at the proffer than what was disclosed to Jennifer Thompson, defense counsel. And under typical conditions, the TBI would have made a recording of Jason Autry's statement. On January 27th, 2017, during the phone call, I asked Mr. Scholl if he would allow me to interview Mr. Autry. Mr. Scholl flat out refused to allow me to have any contact with Mr. Autry. Under the Tennessee Attorney Rules of Ethics, I was forbidden to speak directly Jason Autry without permission from his attorney. And then by keeping me from Autry, Mr. Scholl knew that it would be exceedingly difficult, if not almost impossible, for me to impeach his client, given the very limited evidence against Mr. Adams other than Jason Autry's testimony. And then the state did not provide me with any details regarding its 3-day meeting with Mr. Autry. So, yeah. What a time. What a time. And I know we've read that before, but it just seems like extra interesting to read after we see the state like, oh, Jennifer Thompson's affidavit is meaningless. The point of Jennifer's affidavit was to say as a whole that things we now know about Autry were not available to Zachary Adams to use at trial. And then they're going to take on the issue of all of the exhibits collectively. So collectively, Adams has failed to demonstrate to this court how these exhibits may have resulted in a different judgment had it been presented at trial. The statements contained in Exhibits 1 and 2 are inadmissible hearsay, while the affidavits in Exhibit 3 and 4 from Katie Spirko and Jennifer Thompson are wholly insufficient to establish Petitioner Adams' actual innocence. As such, this court should summarily dismiss Petitioner Adams' writ without an evidentiary hearing for failing to allege a colorable quorum nobis claim, and that Exhibit 1, 2, and 3 are not newly discovered evidence. And then we've got, considering the evidence of the other witnesses at Petitioner Adams' trial, this court should find that the alleged recantation of Jason Autry is insufficient to establish Petitioner Adams' innocence, or would have resulted in the jury reaching a different conclusion had it been presented at trial. And just as a sidebar, we've talked about the judge's decision to exclude the recanting video from the record for the purpose of these post-conviction proceedings. I don't remember him saying in his order that he doesn't think, that if accepted on its face, like if we accept what's in that recorded video as being true, I don't think he made a ruling saying it's insufficient to warrant a new trial, or that the jury wouldn't have concluded anything differently had they been able to see something like this at trial. His conclusion was just that without, there's no sworn under penalty of perjury, and Jason Autry is not coming into these post-conviction proceedings to attest under oath to the same things that he may have said in this recording and sit for the opportunity for the state to cross-examine him. It's just not going to be admissible. But the court didn't make a finding that it's not evidence, it's not new, it's not saying anything. So, a petitioner is not entitled to quorum nobis relief based on recanted testimony unless the quorum nobis court is reasonably satisfied that the prior testimony was false and the present testimony is true. And they're citing State v. Ratliff. They say recanted testimony is often looked upon with distrust by the courts rather than favor due to the great temptation to strengthen the weak points of the case discovered during the trial by perjury or subornation of perjury. I mean, if we're going to speak about perjury or the subornation of perjury, to me, that's the whole Jason Autry, Victor Dinsmore story. A trial court should only grant a writ of error quorum nobis on the basis of newly discovered recanted testimony if the following conditions are met. So 1, the trial court is reasonably well satisfied that the testimony given by the material witness was false and the new testimony is true. And 2, the defendant was reasonably diligent in discovering the new evidence or was surprised by the false testimony, or was unable to know of the falsity of the testimony until after the trial. I think the way they conducted Jason Autry's proffer gets you number 2 checked off. And 3, the jury might have reached a different conclusion had the truth been told. So, Mr. Autry has not given reason to be adequately satisfied that the statements made by Autry on December 22nd, 2023 have any indicia of truthfulness. And this is really what the court found and relied on, that we just didn't have Jason Autry under oath, either in the video through an affidavit or coming to the stand at trial. So this is where the state gets a win. In the form of a motion to exclude from the record, not to deny these proceedings. And then this long footnote describes this video. All right, so let's see. Exhibit 2 is a video interview of Jason Wayne Autry, created on December 22nd, 2023, at FCI Memphis. What is this, something correctional institute in Memphis? Where Jason Autry is incarcerated, awaiting sentencing on federal firearms charges pending in the United States District Court, Western District of Tennessee. During this video interview, Jason Autry makes unsworn statements recanting his trial testimony in the Holly Bobo case. It is important to note that on October 27th, 2023, 61 days prior to this video interview, Jason Autry, through counsel of record, filed defendant's supplemental sentencing memorandum that made the following factual representations to U.S. District Judge Thomas Anderson concerning his federal sentence. I think the context is important here. They're going to say that what he says here contradicts why he'd say something different on the 22nd. But I would say I'm going to predict that there was a motive for him to make promises or act a certain way for the purpose of the sentencing memorandum, but let's see what they say. It's Section 3 of this supplement, responses to upward departure or upward variance based upon criminal history. In arguing for an upward departure or variance, the government places great emphasis on Mr. Autry's guilty plea regarding his involvement with the Holly Bobo case. Mr. Autry is solemnly sorry and cannot express his regret deeply enough for his involvement in that case, and he fully accepts responsibility for his involvement in that case. While Mr. Autry? I think it's while Mr. Autry cannot change the past, he wishes to assure the court he will never again be involved in similar conduct in the future. And I have issue with this because when you fight these types of things, when you're asking for some type of consideration relating to your sentence, your counsel might be guiding you that showing remorse, taking accountability for what you pled guilty to. At this point, you can't change your plea. Your plea exists. And if you go into court and go, innocent man walking, your counsel's probably advising you that, hey, this judge isn't going to like to hear that, so you better show some remorse. You better tell them that you're accountable for your actions. So it's not surprising at all that he's saying, I'm solemnly sorry, and I was involved in this case, and that he fully accepts responsibility. So he wishes to assure the court that he'll never again be involved in any similar conduct in the future. While not intending to diminish in any manner whatsoever the seriousness of that offense, it is nevertheless respectfully requested that this court consider that Mr. Autry was sentenced for and has since fully served his custodial sentence in that matter. Well, you know what? Maybe this court was like, how the heck did you get time served? And, the judge maybe shouldn't be considering those things, but humans are humans. Maybe they were like, this guy had no court fines, no fees, no restitution, even though he accepted responsibility and testified to helping kill somebody that was still alive. Maybe the court was like, what the heck? Like, you weren't even punished enough. So they respectfully request that court consider that Autry was sentenced and has fully served his time. In so doing, Mr. Autry paid his department to society for that crime, as determined by the Decatur County, Tennessee Circuit Court. While the government correctly states that he was originally charged with especially aggravated kidnapping and first-degree murder in that case, he pled guilty to facilitation of especially aggravated kidnapping and solicitation of first-degree murder. Mr. Autry testified as a witness for the state in that case and detailed his involvement before the judge and jury. In approving Mr. Autry's sentence in that case, the judge determined that the sentence imposed was appropriate given Mr. Autry's involvement in the crime. Yeah, he said some of the most credible testimony I've ever seen in a court. Mr. Autry's testimony was clearly instrumental for the state in obtaining a conviction against the individuals who were found to have actually kidnapped, raped, and murdered Miss Bobo. In this case, that offense has been taken into account in the calculation of this guideline range, and Mr. Autry should not be given additional punishment for that offense. Jason Autry concludes his supplemental sentencing memorandum by reminding Judge Anderson that the court must weigh many factors in arriving at a fair and equitable sentence. While Mr. Autry admittedly has a very serious criminal history, it is a fact that in connection with the most serious prior offense, in bold, they bold this, his full cooperation with authorities resulted in bringing others to justice for their involvement in the offense. Innocent man walking. Like, oh, what a guy. What a guy. You got to do the little bobble with it too while you say it. So we've got moreover on August 10th, 2023, Jason Autry, through counsel of record, filed defendant's objection. Oh my God, it's going to go on to the next page. Oh, long footnote. Filed defendant's objection to the pre-sentence investigative report. So, I wish we could see the pre-sentence investigative report. Maybe that's available. I feel like DB or K-Riggs is going to be in the chat like, it is available. Objecting to some of the factual statements contained in paragraph 55 of the pre-sentencing report. regarding convictions in Hardin County, Tennessee Circuit Court. And this is the docket number. It's 2017. Let's see. Defendant admits that he pled guilty and was sentenced as indicated, and that this offense give him 3 additional criminal history points. Defendant objects to the extent the factual statements in this paragraph could be interpreted to be inconsistent with his trial testimony in that matter. Okay, so we're bolding this. This isn't a foregone conclusion, though, but this is just the defendant himself. This is Jason Autry saying, I'm objecting to the extent that the factual statements I'm making here in this plea, that they could be interpreted to be inconsistent with trial testimony in that matter. So it's basically just you're bolding the defendant saying, hey, I don't want whatever I'm saying in this filing here. I don't want you guys to say it's inconsistent with my testimony. I don't want you to hold them side by side. Jason Autry's federal sentencing hearing is set to be heard on June 25th, 2024 at 1:30 p.m. And the representations made by Jason Autry concerning his testimony in the Holly Bobo trial in federal criminal filings speaks for themselves. Yeah, I get it. I get it. They're going to say it's sworn and it's sentencing, unfortunately, and that they don't have something sworn to compare it to when it comes to this recanting. But what does common sense lead you to conclude? Because for me, common sense can differ. Right? For me, my brain says, well, I would expect most people that are dealing with some type of sentencing proceeding to check the boxes and say, yep, I got it. I got it. And just like before trial, I would expect even those that are guilty to proclaim their innocence. And then maybe after trial, or after a plea, they're like, yes, judge, I've changed my ways. I've got a career ahead of me. I've been training. I've had this vocational training. I'm going to do well when I get on the outside. I'm not going to be back here in front of you. The way you respond, the way you move, and your strategies change as you're in different stages of the criminal justice process. So this is not surprising to me. And it's also not surprising to me that when he's in a candid conversation that he knows is being recorded, but it's still candid, and he thinks that this might all be behind him. He says, I worked with the prosecutor and my attorney, we came up with the story. Like, you can't undo. You could discard most of that interview, but if you go down to the one line, well, hey, you got a detail wrong. He's like, I thought I did pretty good. And Jason Autry has something he says he thought he got wrong. And then Katie Spirko points out, you talked about Shane Austin's gate, but he didn't have that gate installed until they got a puppy. And then Autry laughs. Like, he had the light bulb moment go off like, dang, she's right. And I mean, you can't just, if you want to say that Jason Autry can't be trusted, that's fine with me. But his testimony was demonstratively imagined because he talked about that gate that didn't exist and any other number of reasons. Yeah, K. Riggs says even if he did, he would get destroyed by an even halfway competent defense attorney. Or even, I think there could have been a slight difference if Jennifer Thompson had time to prepare or had a break and was able to continue her cross-examination in the morning. I don't know. Hey, Nem. Or that part too. Sheriff Chuck says Autry may just be recanting to get back at Jennifer Nichols and law enforcement officers for the fact he'll be incarcerated for a long time. And it's weird, they don't really spell that out in their long footnote. And maybe that's possible. But there's parts of the recanting that line up with events that were happening. I got my discovery folder on a certain date and started working out a story, and then we did this drive. Well, the way I'm piecing that together, saying the math is exactly what the state did to say what they want to believe is credible was credible. So, And again, that gate, I know it seems so stupid, but that gate story, it's like all of these little things that are supposed to be your sprinkle of truth to show that you have a vivid memory of this, and you're just like inserting random details. Like the Brian Vitt was mowing his lawn. A gate at Shane Austin's property. There's probably something in a report where they went and visited Shane Austin's property 2013, 2014. And it's documented in the report that they had to wait for someone to open the gate. And he's just like, oh, I'm going to talk about the gate in my story. And it just contaminates his memory. So. Okay, so we had this long footnote. Mr. Autry's trial testimony in September of 2017 was, on the other hand, under oath and subject to vigorous cross-examination and thoroughly vetted. Was it? You guys didn't do the testing to hear the boom, boom, boom. You guys took him on a drive of the route, but you didn't stress test his story about the routes. And if it were even possible to go and get where he was saying that they were going in the allotted time. In fact, I'm kind of curious if they took him on that drive just to show him certain details wouldn't make sense and maybe adjust your story within the bubble of the cell tower range. While the video statements made by Mr. Autry to Katie Spirko on December 22nd, 2023 provided none of these safeguards. Because of this, the court should give considerable deference to his testimony given under oath. The statement given to Katie Spirko by Jason Autry do not carry the same reliability. Furthermore, Petitioner Adams' claims concerning Mr. Autry recantation, even if taken as true, do not fit within the category of cognizable claims. Petitioner Adams is not seeking to bring new evidence before this court, which might have had an effect on the judgment. Indeed, at Petitioner Adams' trial, Mr. Autry testified that he agreed to testify for the state, hoping that he might receive favorable treatment in exchange for his testimony. Mr. Autry's... Well, but this is different. This is different than that he reached an agreement. She was not able to get into, and I wish we had the transcript because we would sidebar right now and go to the sidebars on this issue. She was not successfully able to get into an agreement being reached. Mr. Autry's testimony was thoroughly impeached by Petitioner Adams' trial counsel, Jennifer Thompson, and the jury was well aware of Mr. Autry's criminal background, and that he had motive to lie, hoping that he might receive favorable treatment in exchange for his testimony. This makes it seem like Autry decided in a vacuum to lie, and this is wholly debunked. This is wholly debunked by the footage we were watching from January, February of 2017. It's also recited during his plea colloquy. Judge Creed McGinley makes a reference to the knowledge that the state had come up with some sort of agreement with Autry that they wouldn't need a trial date by the February 1st, 2017 hearing. Like, this is just crazy to see written on paper. Like, they're really trying it. Like, he hoped, everybody hopes they'll get leniency if they please the prosecutor. But we didn't offer him anything. Moreover, Mr. Autry acknowledged during cross-examination that he had not been truthful in prior statements about his involvement in the victim's disappearance and denied any involvement until Mr. Paris and Mr. Scholl, Autry's trial counsel, came aboard. And Jennifer Thompson wasn't able to get into the agreement, and why that would have been motivation for this sudden change. This is crazy. Again, Petitioner Adams' trial counsel extensively cross-examined Jason Autry at trial concerning his prior vehement denials regarding his involvement with the victim's disappearance. Prior to January 2017, Autry steadfastly denied any involvement in the crimes and made countless statements declaring his innocence to anyone willing to listen. Well, here we are, chat. At trial, Jennifer Thompson confronted and impeached Jason Autry's veracity over and over concerning his prior inconsistent statements. For example, these 4 trial transcript excerpts clearly indicate that the December 22nd, 2023 recorded video statement of Autry is merely cumulative and serves no other purpose than to further impeach Autry's trial testimony on the exact points that Jennifer Thompson addressed during her cross-examination. So Jennifer Thompson says, and you said it at the time that it was a try to be to, let me sorry. Oh. What was it YSL where they said objection unintelligible? So Jennifer Thompson says, and you said at the time that it was a try to be to, let me sorry. You said it was a try to be a forced move to get me to bear false witness against Zach Adams, didn't you? Jason Autry, if your records reflect that, I said that. I mean, this is a mess of a question. All right, then, because at the time you were objecting to the fact that the state was trying to get you to cooperate, weren't you? I had not spoke to the state at no time during that period. You said, nor made any suggestions that would link anybody to believe that I wanted to cooperate with the state. Right. But this is ineffective assistance of counsel all the way. But you knew that there was pressure to have somebody cooperate, didn't you? I was under the assumption it was dealing. You know that those telephone conversations are being provided to everybody in Discovery, don't you? It tells you that it's being recorded, yeah. You told your mom, Mama, I didn't, I swear, right hand before. You said, I mean, I'll testify to what I know. I mean, and I'm going to, but Mama, I'm innocent. That's right hand before God. I'm innocent. That's what you told your mother on the telephone, isn't it? I reckon that's what I'm here doing. But you told your mother that on the telephone specifically? Yes. I mean, that's just one instance, but you told your mother that time and time again, didn't you? That's correct. You've written letters where you said, they don't have a case, I'm innocent, didn't you? If your records reflect that, that's true. And then there's no impeachment here. Like, at a certain point, if someone, even if they're like saying yes, but it's in a like, I'm not really sure, you can move to introduce the statements themselves. You've written where you said up front, I have nothing to do with Holly Bobo, no form, no fashion, right hand before God, that's the truth. You said that, didn't you? I testified earlier that I had lied multiple times in the mail and on the phone calls. And then now they're going to another section. And you said, Mr. John, there's no way they have a case. I'm an innocent man. It's awful funny, man. My attorney still hadn't got no motion of discovery. Jennifer. 11 months and still no evidence. Did you say that? At some point you did, didn't you? If your records reflect that, that's true. So what they're missing here, what the state's skipping over with these, yeah, you're saying that he's claimed his innocence before. Cool. But what you're skipping over is the pivot. This denied any involvement until Mr. Paris and Mr. Scholl, Autry's trial counsel, came aboard. Jennifer Thompson wasn't able to get into the underlying context of what happened when these attorneys came on board. And this is ineffective questioning. This is poor questioning. But she was blocked. She was blocked when she tried to get into certain agreements. I think to the point of even trying to introduce a business record, and the judge was like, no. So, let's see. Oh yeah, actually, Kay Riggs, you are the goat of the day. Hold on, let's find this. Where was the snake? Let me save this and pull this up, because I don't know how to... I'm like at my limit of things that I have preloaded into StreamYard, and before the stream started, I accidentally... They like have this little pop-up thing every time you join during the holidays. It's like, do you want to add these 6 holiday-themed things? And I accidentally clicked that, and it put me over the 100 count. And now I can't add any other pictures, and it's just a whole mess back here. So I've got to do this in this roundabout way. So Kay Riggs had screenshotted this part of a sidebar talking about the old snake letter. So we have General Nichols. This is bad, Jennifer. I would like to have a hearing on the relevance, but I don't want it on television because this is a letter from Jason Autry to Miss Thompson praising the Lord for the representation of Mr. Adams, saying that Jennifer Nichols is a hired assassin and talking about somebody I have sitting on death row from 2011 that's fixing to be overturned because I forged documents, all of which, of course, is not in the court. That's not relevant to this trial. Miss Thompson, it is relevant, Your Honor. The court, wait. And Nichols says, before we go any further, I don't believe it's relevant, but if it's determined to be relevant, that's one thing. But if the court thinks it's not relevant, I would prefer that kind of thing not be out there because it has absolutely no bearing on this case. And court says, all right, so it's a letter praising her, meaning Thompson. And then Nichols says, from him, calling me an old snake. Oh, so shout out to K Riggs with the great screenshot of the sidebar transcripts. I think very good timing. Very good timing to pull that one up. So, yeah, obviously some things were excluded. And it's the second volume of Jason Autry's testimony. All right, cool. And let's see. Let's see if they're back up. Yeah, they've got to fix the access. They did a little access kerfuffle over here. But when they're back, we'll take a look at the transcripts. So keep that in mind, guys. We'll get to read more of stuff like that. Yeah, so it's not a legal argument. Oh, I love the new picture. We have Sanctified Sheriff Chuck. So it's not a legal argument, but a PR argument. Did you get 5 more? Thank you. Sheriff Chuck also gifted 5 more memberships. He said we need new snakes in the chat, not old snakes. So 5 gifted subs. Big thank you here, Sheriff Chuck. Check out his new profile picture. He's taking the role of Chat Santa seriously. Love it very much. Oh my goodness. Crazy. So anyway, the state here argues that Autry's credibility was effectively questioned at trial by Petitioner Adams' trial counsel. I mean, I don't think she could effectively, and I don't think she did effectively question with what she had available, but okay. State wants to give her her props now. Let's see. Mr. Autry's testimony was a singular piece of the state's substantial proof, the mountains of evidence, of Petitioner Adams' guilt. Yeah, they didn't address the Zach Stupid Mouth folder. The state presented testimony from numerous witnesses at trial who testified that Petitioner Adams made incriminating admissions about his involvement with the victim's kidnapping, rape, and murder. The state also introduced multiple items of physical evidence that linked Petitioner Adams to these crimes. Oh, help me. This whole paragraph could make me go on. You know what? Tonight, I've got 30 minutes to air my grievances out on Miss Janet Demeanor's Festivus celebration. And of course, I'm going to talk about this case. Maybe I should be like, Miss Janet, can we just pull up one paragraph here and just let's riff for 30 minutes? Because I think this paragraph could do it. I think this paragraph could fill the whole 30 minutes. Oh my goodness. All right, so now see how they want to spell this out, chat. So if you're listening, to all my friends that are listening and not looking at the screen, earlier in this stream, I said, hey, this paragraph about Katie Spirko's really short. They just say, we're going to A, B, C, D, E it, but we're not going to specify anything. We're just going to let it be. Where was it? Well, look at me going too far back. Yeah, this little paragraph here. So, Katie Spirko affidavit, 1, 2, 3, 4, 5 lines. And they just say, we're not going to say anything specific. We're just going to say 6A, 6B, 6C, 6E. But when it comes to the voluminous, the mountains of evidence, we're going to spell it out for any member of the public who's going to read these public filings. We're going to make sure that even though the exhibits, a lot of the stuff is sealed, we're going to spell this all out. So this is Petitioner Adams' admissions. This is Zach's stupid mouth folder. Over the course of a 5-year period, Zachary Adams made numerous inculpatory statements acknowledging and confessing his involvement with the victim's disappearance, rape, and murder. The state has presented 9 and in parentheses 9 separate witnesses, who testified at trial concerning Adams' admissions about the victim from multiple and unrelated witnesses. So first is Victor Dinsmore. On April 13th, 2011, Mr. Dinsmore was remodeling a garage and kitchen at Miss Dottie's residence, which is a short distance from Zachary Adams' home. Around mid-afternoon, Zachary, Shane, and they spell his name wrong, and Jason Autry arrive at Miss Dottie's residence. Now they say admission, and they have 2 columns here, admission on the left and the citation of the transcript on the right. Within 2 or 3 minutes, Zach and Shane Austin were arguing and fighting, and I heard a few little spurts out of their mouth about who was going to hit it first, and I never even put it together at all. And I told them they couldn't do that there because this was my job and they had to go. So they loaded up and took off. Train, with a footnote, actually kind of broke them up, and they loaded up and took off. So Train actually kind of broke them up, and we have a long footnote that says Train was Jason Autry's nickname. Moreover, Jason Autry's own testimony corroborates Mr. Dinsmore's testimony concerning his physical altercation between Zachary Adams and Shane Austin. Mr. Autry testified around 2:30 p.m. on April 11th, 2011. Autry arrived at Miss Dottie's to purchase morphine from Victor Dinsmore. Autry testified that when I pulled up, the area was just thick with animosity. Should I do a transcript search and find his quote saying that? That was so weird. The air was just thick with animosity. You're in the car with them. Why would the air get thick? Because of them being about to fight. You could just tell there had been some fighting and anger amongst them. Autry further testified to hearing an exchange of words between Zachary Adams and Shane Austin. Shane told him, he said, "You didn't have to kill her." And Zach told him, said, "You're just as damn guilty. You hit it." And Zach told him, said, "You shut your fucking mouth. I am sick of it being discussed. We're here." We pulled up, and he told him, he said, "I'll whoop your goddamn ass." They got out of the truck at Dottie's, and 1 lick was exchanged. Zach hit Shane. This is not... In what world does a fight like this really happen and only one punch is thrown? All of this, and you just get 1 boop? I don't know. It gets more, it gets less credible every time I reread something. Rebecca Earp. Miss Earp is Zachary Adams' former girlfriend, with whom he lived at the time of the offenses. Petitioner Adams made inculpatory statements to Miss Earp's, multiples, in the aftermath of the victim's disappearance. So there's 3 paragraphs here from separate parts of the transcript. First says, the day after the victim's disappearance, Rebecca Earp was with Zachary Adams and Shane Austin, who smirked and laughed about a news report related to the victim. Zachary Adams stated that they will never be able to find her. This is a narrative. Did I miss that when they were doing the... So the first admission is a quote. For Zachary Adams, it's a quote from the transcript. But then this is now narrative. What are they doing? Another narrative for the second one, Zach Adams. So these are not quotes. There's quotes within this paragraph. But it says, Zach Adams attempted to tie Rebecca Earp up with a belt, telling her that, quote, "he would tie me up just like he did Holly Bobo, and nobody would ever see me again." That's the end of the quote. Rebecca Earp overheard a conversation between Zachary Adams and his friend John Mitchell, in which Zachary Adams stated, quote, "everything was in the truck ready to go," end quote. To, quote, "take the Tupperware, it was a blue Tupperware thing to birdsong." And that, quote, "they said it was the remains of Holly." Why are they doing okay. I mean, it's just weird because they're putting it under admission instead of just letting it be like a typical paragraph where you make your argument and you weave in quotes throughout the paragraph. I don't get why we're making this whole format if we're going to use a narrative instead of just block quotes. But okay. Carl Statler. Carl Statler. In 2011, Carl Statler knew Zachary Adams, as both lived in Parsons and were involved in the local drug scene. See how they refer to the transcript regularly in a paragraph here? At trial, Mr. Statler testified about several instances when Zachary Adams made incriminating statements concerning the victim's disappearance, rape, and murder. So again, we have 3 block admissions that are narrative. So Mr. Statler was riding in a truck with Zachary Adams during the summer of 2011 after Holly Bobo went missing, and Adams said, quote, "I let Shane hit it." Carl Statler understood the words "hit it" to mean rape. Mr. Statler was with Zachary Adams at Johnny's Bar and Grill in Parsons in 2011, the summer after Holly Bobo went missing, and he witnessed Zachary Adams threaten a bartender named Misty Tubbs, telling her, quote, "I'll kill you like I did Holly Bobo," end quote. Mr. Statler was with Zachary Adams at Johnny's Bar and Grill in Parsons, Tennessee, in the summer of 2011 after Holly Bobo went missing. Zachary Adams told Carl Statler that he, Zachary Adams, was responsible, saying, "I did it." So, yeah. Nice narrative blocks here. Jamie Darnell. Mr. Darnell was a longtime acquaintance of Zachary Adams. In July 2012, Zachary Adams came to Mr. Darnell's home in Decatur County and made admissions about a knife in his possession. So here's his blocks of narratives. So in July 2012, Zachary Adams showed Mr. Darnell, quote, "a knife that he had, and I was kind of like intimidated by it, since he was, trying to intimidate by it. I asked him to look at it, and I was checking it out and asked him how much he would take for it. He told me that if I knew what the knife had done, that I would probably be afraid of holding the knife," end quote. Now this one's just a quote. Quote, "I was like, does it involve what I think it does? And he just smiled, and I gave it back to him," end quote. Mr. Darnell later informed Zachary Adams that Adams was not to return to his home until he had, quote, "cleared his name," to which Zachary Adams responded with, "He couldn't do that. He was far too involved in it, and there was no way he could do that." Sean Cooper. All right, so Sean Cooper, and this one has a long intro paragraph. On March 4th, 2014, so this is right when we have the press conference with TBI saying that they've indicted Zach Adams and the Bobo family. They do that. That was March 5th. So March 5th, Karen Bobo does the press conference. March 5th, we have the indictment. Apparently on March 4th, Sean Cooper was incarcerated in Chester County. So Zach got arrested like 2 weeks ago, less than 2 weeks ago. Right? He was only just picked up. Because they do the search warrant issuance on February 28th. That's when Mark Gwynn is saying, all right, we got the search warrant for Zach's home. And they arrest him on a separate, like, assault charge. So let's say like February 28th to March 4th. He's only there for like a week. And he's not arrested and charged with anything relating to Holly Bobo. But apparently, the day before this indictment comes down and is announced, apparently Sean Cooper, he was hanging out with Zachary Adams at the courthouse for their cases. After his court hearing, Mr. Cooper sat on a bench speaking to court personnel about his bond. Mr. Cooper was advised by court personnel that he was going to be transported to the Obion County Detention Center, which was also a federal holding facility. Zach Adams was sitting on the same bench and overheard the conversation as well. When Zach Adams learned that Mr. Cooper was going to Obion County... Oh. Is that the sentence? When Zachary Adams learned that Mr. Cooper was going to Obion County. Okay, it's like a floating sentence. Prior to that day, Mr. Cooper did not know Zachary Adams. Adams asked Cooper to relay a message to Adams' brother/co-defendant, Dylan Adams, who was housed in Obion County. I feel like it's important to say that Dylan Adams wasn't his co-defendant at this time. But okay. That would be important context, but okay. Dylan Adams, who was housed in Obion County. At trial, Mr. Cooper testified about multiple incriminating statements that Zachary Adams made to him concerning the victim during this courtroom encounter. Zachary Adams told Mr. Cooper that he was Zachary Adams. I'm the Holly Bobo murder case. Zachary Adams told Mr. Cooper to communicate a message to his brother / co-defendant Dylan Adams. You tell him if he don't keep his mouth shut, I'm going to put him in a hole beside her. Zachary Adams went into court, then came back making jokes about his bond. Next, we have Jason Kirk. Jason Kirk was present in Chester County Jail March 4th, 2014 for his arraignment and witnessed the statement Zachary Adams made to Mr. Cooper. I think that was the kid with the curlier, longer hair. Mr. Kirk did not know and had never seen Zachary Adams. At trial, Mr. Kirk testified about multiple incriminating statements that Zachary Adams made in his presence. So he says Zachary Adams stated to Mr. Cooper, tell my brother in Obion, if he doesn't keep his fucking mouth shut, I'm going to plant him next to that bitch, which is very different than a hole beside her. Zachary Adams also told Mr. Cooper, my brother is telling on me, and went into a rant about it. Zachary Adams told Mr. Cooper his brother got caught with something, I wasn't sure what it was, with the feds, and to get out of it was trying to tell on him. After Zachary Adams' arraignment, Mr. Kirk overheard him stating, I guess you gotta kill a bitch to get that kind of bail around here. Zachary Adams stated, but I'm not worried. He said, don't have no body, they don't have no gun, they don't have a conviction because they don't have a body and they don't have a gun. Anthony Phoenix. Mr. Phoenix lived in Parsons around the time of the offenses. In 2010 through 2011, Mr. Phoenix had a substance abuse problem and often turned to crime to fund his drug habit. Mr. Phoenix knew Zachary Adams well and used to get high with him. At the time of the victim's disappearance, Mr. Phoenix was incarcerated. When he was released from jail, Mr. Phoenix continued to socialize with Zachary Adams. At trial, Mr. Phoenix testified about multiple incriminating statements that Zachary made. So Zachary Adams told Mr. Phoenix that he had met with the victim's mother, and Adams expressed concern about what he told Karen Bobo? It says Karen Adams. Yeah, it should be Karen Bobo. Zachary Adams and Mr. Phoenix were driving around when Zachary Adams made the comment about something along the lines of, let's rape this bitch. Mr. Phoenix asked Zachary Adams what that comment had to do with what they were doing in the moment, and Zachary Adams told him, I couldn't have picked a prettier bitch. Mr. Phoenix told Zachary Adams that he didn't want to hear about it, to which Zachary Adams responded with, it sure was fun. And then I'm pretty sure he continued his testimony, and they were like still friends hanging out after this. like imagine you're riding in a car and someone says this. I'm not gonna lie, in the instant moment, because this is weird stuff to be saying, if you're saying this in the moment, I might be like, what? The first time. But as you keep saying it, I might get uncomfortable. I might just rock with it until I can get out of the car and get away from you. And then I'm going to be like, you know what I mean? Like, maybe you don't want to confront somebody that's just starting to sound like a raving lunatic when you're stuck in a car with them. But as soon as we're apart from each other, it's go and gone time. But they were apparently still hanging out after this. So I just don't believe that this is going on. Or at the very least, I don't believe that Mr. Phoenix had this adverse reaction to it, this aversion to what he was apparently hearing. It just doesn't make sense. Chat. Yeah, and gross stuff. All of this is gross. All of this is gross. But I think it has major credibility issues. I see a ton of green in the chat. So shout out here. We got K. Schmidt dropping 10. Merry Christmas, K. Schmidt. Thank you for gifting so many. Let's get some W's for K. Schmidt. Thank you, thank you, thank you. If you just turned green, it's probably from Sheriff Chuck or K. Schmidt. So check out those channel emojis. Use them to your heart's content. And I've got a comment here sitting from StreamYard saying it won't send my WK Schmidt chat. Let me just try a W. There we go. Maybe StreamYard thought K. Schmidt was a way to censor SHIT and it blocked it. I don't know. StreamYard does its own thing. YouTube does its own thing. But shout out to K. Schmidt. We also had Sunshine for You. Thank you for the super. It says happy holidays. Love the hat, girl. And you know what's crazy? It's like super long. When I try to wear a regular hat, the ball sits here. It's just like not the same anymore. This is the only hat I feel right wearing. So this is the dedicated Christmas hat. So I'm glad you like it. Thank you for the super. And shout out to Sheriff Chuck for another 5. And we can see the transformation in real time here. We've got the historical Sheriff Chuck, and now we've got the Santified Sheriff Chuck. So love that we've got the archival footage here. And thank you so much. That's 15. So big thank you, Santa Sheriff Chuck, here in the chat. Oh, guys, we're getting to my favorite jailhouse witness, Corey Rivers. Corey Rivers. In 2016, Corey Rivers from Jacksonville, Florida, was driving through Tennessee when he was pulled over by law enforcement in Williamson County. During the traffic stop, Mr. Rivers provided the officer with false identification. As a result, Mr. Rivers was convicted. Well, I mean, we just jumped to a conviction. Oh, this is just dumb writing. During the traffic stop, Mr. Rivers provided the officer with false identification. As a result, Mr. Rivers was convicted. I mean, that is a jump in time. But anyway, and received a 60-day jail sentence. While serving the 60-day jail sentence in the Williamson County Jail, he met Zachary Adams, who was his next-door cellmate. At trial, Mr. Rivers testified about several instances when Petitioner Adams made incriminating statements concerning Holly Bobo. Furthermore, Mr. Rivers testified that before getting locked up on the driving charges in Williamson County, he did not know anything about the case regarding Holly Bobo, nor Zachary Adams, Dylan Adams, Shane Austin, or Jason Autry. But he said as soon as he got out, he went on Facebook and he started Googling and researching the case. So just because he didn't know this stuff at the time he claimed Zachary Adams was saying certain things, he was aware of those things before he said that Zachary Adams said these things to him. So we've got Zach Adams saw Mr. And again, it's narrative. There's no quote in this one at all. Zachary Adams saw Mr. Rivers reading the Bible. Zachary Adams asked him about forgiveness and whether God would ever forgive him. Mr. Rivers asked Zachary Adams what happened. Quote, him and a couple of his friends got drunk, and him and a couple of friends had went into, they got drunk, and they went into the woods with this girl. And, one thing led to another. And then he was like, I was there for the worst of it. And I was like, well, did you do it? And he was like, I was there for the worst of it. And he just left it like that. So this is very different from the idea that they went to a couch or barn. Zachary Adams told Mr. Rivers what happened to Holly's body. Quote, the bottom side was found in one part of Tennessee, and some other pieces were found otherwheres. They didn't find the bottom of her body. So, am I missing something? Did they find the bottom of Holly's body and I just missed all of that? Anyway, Zachary Adams told Corey Rivers that the body was chopped up. It had got chopped up, just passively on its own. Said it had been chopped up. Yeah, I don't know. Everything is fine, says, wait, what? Same. And I know it's like, I don't know if this is starting to leave. The grocery shelf is getting too full, right? Maybe some stuff that I might have heard. And I always wonder if there's things that weeks later, I'm like, I don't remember that. But if I were to go back a few weeks ago, you can see me reacting to it in real time, but you can see that I forgot it over real time. I wonder if I could see myself do that by looking at my old streams. But this little bit, I don't feel like when we were watching Corey Rivers' testimony, I specifically remember piecing together yet that they only had partial ribs, the skull, piece of the scapula, just not things that would be the body side. So maybe I wasn't aware of the context that would be necessary to be like, hey, that doesn't add up. So, but yeah, now that I'm reading it, after I've been able to digest the case more, that doesn't math. That seems like a lie. Even if Zach Adams said it, it's just not accurate. So Zachary Adams told Corey Rivers that the body was chopped up. Zachary Adams, that he had got it chopped up and then said it had been chopped up. Zachary Adams told Corey Rivers that Holly's upper torso was found. And if we take this at face value, if we're supposed to believe his admissions, who chopped it up? Jason Autry? Because Jason Autry says she was shot. And quite frankly, he's only able to say that after he gets his new attorneys, but after he gets the discovery packet and is starting to have these meetings with the prosecutors. So... Anyway, specifically, he gets a question. Specifically, did he tell you that they found her upper torso? Yes, ma'am. Zachary Adams told Corey Rivers that there's a video and that it was right under the nose of, the people who's looking into this, but that they haven't found it. So did they find it or not? What? Zachary Adams continued to talk to Mr. Rivers about his case, even though Adams said his attorney and his pawpaw had told him not to talk about it. Chris Swift. In 2016, Mr. Swift was incarcerated in the Williamson County Jail, and he and Zachary Adams were housed in the same area. During this period, Zachary Adams made multiple admissions to Swift concerning Holly Bobo's death. On one occasion, Zachary Adams noticed that Mr. Swift was praying. Zachary Adams asked him if he thought God would forgive him. Mr. Swift asked, "Forgive you for what?" And Zachary Adams responded, "My case, the Holly killing." Over time, Zachary Adams discussed his case with Mr. Swift. Zachary Adams told Mr. Swift that he wasn't involved in the killing, but was involved in the worst part of it. So, flip it and reverse it. I mean, it would kind of fit the state's theory, just with a little bit of reversal, that maybe instead it was Jason Autry that did the abduction and the worst of it, and maybe Zach Adams was just going with Jason Autry to go and get high at the bridge they always go and get high under, and Jason Autry did some messed up-ish. To me, that would make more sense within the theory with some of these admissions, and this is not the only quote that points to that. But Zachary Adams was never willing to play ball with the prosecution and make the trial easy. So, Autry, they were fine with Autry somehow being guilty and present for all of it, but not admitting to taking part in it at the same time. Zachary Adams also told Mr. Swift that some boy that hung himself and his brother co-defendant Dylan Adams was involved in the killing. Zachary Adams told Mr. Swift, which that contradicts Jason Autry. Zachary Adams told Mr. Swift that his brother and some boy that hung himself were in a back room having sex with her, and that something went bad wrong, and he said he was involved in the worst part of it. Zachary Adams told Mr. Swift that he would be going home after his trial because they didn't have a body, they didn't have the murder weapon nor a motive. On another occasion, after this conversation, Zachary Adams met with his attorney and afterward told Mr. Swift that it doesn't look good for him. I don't think that's incriminating at all. I mean, there's a lot of things, if you are the spouse of somebody that gets murdered, it's not going to look good for you just because you're the spouse. People are going to think that you are the first person. You have close proximity. You obviously have access. You probably were near the victim the day that they died. I could say it doesn't look good for me just because everybody's looking at me. And it could have no bearing. That determination doesn't stem from whether or not I actually did something. Oh yeah, what about the satellite guy? See, this is the grocery shop. I forgot about the satellite installation. They have to plan this whole itinerary for the day, right? No matter what trouble we get into, we're going to commit these heinous crimes. But we've got to make sure that we don't interrupt the satellite guy, because you guys know how hard it can be to schedule a time slot for that type of thing. If you miss the boat, you've got to call customer service. You've got to wait on the phone with them for 30 to 45 minutes because the online portal probably didn't exist back then, And you got to schedule another appointment, and then you got to make sure you're not doing anything else the next day. So we're not going to mess up that satellite installation that we pre-scheduled on the same day we're going to abduct a girl that's going to trigger the entire community to be on the lookout. So, just crazy. Just crazy. Totally forgot. Yeah, lots of people with the chopped up. Ooh. She chopped up before she was shot. And I mean, if we want to, that contradicts the medical examiner's conclusion. And I'm not speaking at Gwennon. Gwennon's saying something that's making me think. This contradicts, these admissions not just contradict other facts of the case, other things that Jason Autry is going to testify to that we're supposed to think is credible, but it contradicts the conclusions of the medical expert, who said that based on the way he was looking at the wound in the skull, I think he said it was pre-mortem. So, and I think that's something to do with, like, while the tissues are still live and blood is flowing, there's like reflexivity with the material, the matter, that prevents different types of like shattering had it been a post-mortem gunshot wound. I'd have to rewatch that, but I think it was something to that effect. The dang satellite guy. As far as brand accounts, I'm not sure if we can tell. Although I think maybe if you do you see the option to become like if you click the little like money symbol next to where you would chat, do you now see an option to become a member? Because if you see the option, you're not on a brand account. And as long as you click there's a setting in there to enable receiving gift memberships, that would make your account eligible to receive a gifted membership now. So that's the way I would check. And yeah, Gwen, and I knew you weren't like saying it concludes, but you really made me think that, like, for us to believe that these witnesses are credible, or that because they're saying Zachary Adams said something, that the things that Zachary Adams, if we assume it true that he said things to these individuals, now there's a separate issue of he said them, but is there any veracity behind what he said? Well, if we were to say, yes, Zachary Adams' statements that he gave these people were truthful, it conflicts with the other evidence and testimony that the state relied on. It's a whole rabbit hole. It just never ends. On another occasion, after this conversation, Zach Adams met with his attorney, says it doesn't look good. Zach Adams later told Mr. Swift that he was going to get the death penalty. And that was like June that they filed that notice. When were they in custody together? 2016. Okay, so they're not really that descript on the time frame. But I don't know. They just say 2016, and to me this is phrased as if he learned at some point between, hey, we start hanging out, I'm asking you to have these conversations with me, I want you to pray for me, and we only get housed together in 2016, but weren't the aggravating factors filed in June of 2015? So for this to make it seem like Zach Adams came back after learning he was going to be facing the death penalty, Zach Adams wouldn't have learned that after being housed with Chris Swift for the first time. So that doesn't make sense. After Mr. Swift was released from jail, he received a telephone call from Zachary Adams, who used another inmate's PIN number to call Swift. During the conversation, Zach told Mr. Swift, I probably wouldn't be talking to anybody else, and ended the call. Mr. Swift felt threatened. All right, now we're doing the physical evidence. We're going to see the physical evidence, what their argument that there's all this physical evidence breaks down to. So, A, the scratches on Petitioner Adams' body. Chris Hill. Mr. Hill was a park ranger employed by Natchez Trace State Park who encountered Zachary Adams during a traffic stop approximately 8 or 9 days prior to the victim's disappearance. Why can't you pinpoint this? Why can't you just say April 4th? Oh, because they're relying on his testimony. It's weird that they're doing this structure. And now here this says testimony, not admissions. So they're just going through this physical evidence. During this traffic stop, Petitioner Adams fled on foot from the officer into a wooded area. Mr. Hill into a wooded area where he could have gotten scratches. Mr. Hill testified he had occasion to observe Zachary Adams face-to-face, body-to-body after he was arrested. Mr. Hill testified that Zachary Adams did not have any linear markings on his left arm at the time he was apprehended inside Natchez Trace State Park. Mr. Hill testified that if he had seen bloody linear scratches on Zachary Adams, he would have absolutely taken note of it. Rebecca Earp. Miss Earp testified that she observed scratches on Petitioner Adams' neck on the evening of the victim's disappearance. Miss Earp testified that she saw 3 parallel scratches on Petitioner Adams' neck on the evening of the victim's disappearance. These scratches were not present when he left home that morning to go scraping. Scraping? These scratches were present after he returned from scraping. She described them as scratches on the right side of defendant Adams' neck, extending from under the jawline at the ear towards the Adams apple. So, my right, or like if I'm looking at somebody, what it would look like their right side to me? Because a left-handed scratch? Matthew Ross, FBI agent Matthew Ross, interviewed Petitioner Adams at his home approximately 10 days after the victim's appearance. During that interview, Agent Ross observed scratches on Petitioner's arms and legs and testified to the same at trial. No neck scratches. No neck scratches. Agent Ross noticed that he had some pretty visible scratches on his arms and knees, I think, or leg area. Agent Ross took photographs. I asked him if I could take photographs of him and the scratches, and he said yes. Zachary Adams told Agent Ross that he had gotten the scratches after he'd been arrested by the police somewhere, and that he'd run through the woods trying to escape and got cut up by a bunch of briars. Recovered gun. Oh, this is going to be painful to read. Victor Dinsmore testified that 2 months after the victim's disappearance, Shane Austin wanted to trade a pistol for drugs. Mr. Dinsmore knew Dinsmore was not supposed to possess a gun because he was a convicted felon, but he thought he could sell it. Jason Autry was present during the trade. Mr. Dinsmore gave the pistol to his wife for her protection, but later told her to get rid of it because he feared it had been used to kill someone. And actually, this sounds dumber reading it this way than trying to figure it out after listening to those recordings with Brent Booth. So he had to come up with a reason. At first, he knows he's not supposed to have this gun. He's getting it because he only wants to sell it. But then he has to come up with a story of why he has it. So he says, well, I had it for so much longer and didn't actually sell it. Because if he sold it, he couldn't tell you where to go find it. He couldn't provide it to the state in response to, you're facing 8 charges. So he has to come up with some type of weapon that he still could reasonably account for and suggest to where it is, while also having a story that makes it seem like it's not really in his possession. And this just makes it sound super sus, squishing it down into 3 sentences like here. Miss Dinsmore disposed of the pistol, and in 2016, Mr. Dinsmore told law enforcement where she disposed of it. What? Did they disclose this back then? Because I have the disclosure as being around Memorial Day. And we have a news report at the beginning of June saying that they had found the weapon 2 months earlier. So Memorial Day, May 29th, 2017, is when defense says the state notified them about the gun. But we have them here in this pleading saying that Miss Dinsmore disposed of the pistol and in 2016 told law enforcement where she disposed of it. And then they just say it was subsequently recovered. No additional time information. What I'm thinking here is this was the first time maybe they tried to point someone in the direction of the gun, but they had to have them change the gun because it wouldn't work with the story. But they don't they don't properly represent that here. But in the alternative, they're still saying that they learned this in 2016, and we know that they don't disclose this gun. They're not saying when they go and finally search for it and recover it. Or we have to go to the timeline chat. Because if they really were on notice, that makes this more weird. They try to turn something over in 2016. It's going to let me zoom in because this is, why is it? There we go. I know it's tiny, but every time I go into present mode, it like screws up StreamYard for whatever reason. So if they told sometime in 2016, and they're not really saying when, remember by November, we have Discovery being turned over to Autry only. We have February 1st, we know that Autry doesn't need a trial date. Then we have these proper sessions. In May, we have Booth's back-to-back days of visiting Dinsmore and like needing clarity on it's got to be a revolver. I don't want to put words in your mouth. And then the disclosure 10 days after this meeting to the defense that they found the gun. So if they first had Dinsmore, I think that this isn't true. Maybe this is a simple mistake of they meant to write 2017. I don't know. But this isn't accurate. This is not correct. So they go, law enforcement subsequently recovers it. We don't get an identification of when they recovered it here, which is really sus, from a creek-like area 3 to 4 miles from Yellow Springs Road. After its recovery, Mr. Dinsmore identified the pistol as the same handgun that Mr. Austin traded him for 12 morphine pills. All right. Maybe they're going to give us more and say, hold on, the firearm thing changes, but I don't think so. But Mr. Dinsmore identifies the pistol as the same one that was traded. He says a few months after the victim went missing, Sean Austin wanted to trade a pistol to Mr. Dinsmore for drugs. When Mr. Austin made this trade with Mr. Dinsmore, Jason Autry was with him. Mr. Dinsmore traded his drugs for Mr. Autin's pistol. Mr. Dinsmore later told his wife to get rid of the pistol because he believed that it had a body on it, meaning it had killed somebody. And I think that's the first quote that we have from testimony. In 2016, Mr. Dinsmore and his wife provided TBI with information concerning the pistol. So now it's 2016 again. Mr. Dinsmore and his wife assisted TBI in locating the pistol, specifically in the creek off Holiday Road. Okay. Mr. Dinsmore identifies the gun that had been previously marked as Exhibit 180, saying that's the gun. So they are saying this 2016 point was to what they use as the murder weapon, right? That Dinsmore obtained from Shane Austin in exchange for drugs. Mr. Dinsmore has no doubt in his mind that this is the gun that you bought or traded for 12 morphine pills. Jason Autry's trial testimony independently corroborates Victor Dinsmore's testimony concerning this pistol. Here we go, chat. Jason Autry testified that on April 13th, 2011, when he saw a gun holster to Shane Austin's hip when Autry arrived at 30 Yellow Springs Road, the same gun was in the Nissan Frontier 4x4 laying in the driver's side floorboard when Autry got into the vehicle with Zachary Adams. The next time Jason Autry sees the same gun is in Zachary Adams' right hand before he shoots Holly Bobo. Jason Autry next sees this pistol when Autry and Shane sell it to Victor Dinsmore. I was with Shane when he traded Dinsmore the gun for morphine. For meth or for morphine? All right, so so far we've gotten through the scratches and the gun. Mr. Din's morphine. Ah, chat. This is getting worse. And this is the state writing this, and it's raising more questions. It is raising more questions for me about the state's theory of the case and why they don't see glaring problems with it. Like, why are they writing 2016 here twice as when they're aware of this gun? That's wholly contradicted by the recordings that are from May of 2017. And it would be a more egregious violation that they didn't provide this information over to the defense. And this is supposed to be a motion where there's no new evidence that would warrant a writ of coram nobis petition to be granted by the court. So maybe not the best motion, the best motion to dismiss, to be doubling down, making misrepresentations, forgetting your own timeline. I don't really know what's going on here, but none of it computes with what we hear in the 2017 recordings. This is a lot. Yeah, Gwennon, I think this has got to be it. They think that the judge will just read it and deny. And that's seriously, like, I think we might not be here having these streams if it wasn't for Judge Bradbury, if it wasn't for Doug Bates, if it wasn't for Spirko and McClendon, and Kinsey. Like, there's a lot of butterfly effect going on here. If this was Creed McGinley, we might not be here even with Doug Bates. Crazy. Yeah, it's some guy with cancer. The case is so clear that the state can't even keep their own story straight. Hey, Rick says, I'll never believe the story about that gun and where they found it. I'm sorry, but that gun was planted. Yeah, and even if it was planted, it just seems like they just have like a like a Rolodex, if you will, of guns that they were willing to say to TBI, well, what do you need me to give you? What caliber? Like, what would match your other evidence so I can help you out here, buddy? And Booth like, well, that really helps me. Mister, this case haunts me. Long hours. Like, it's just crazy. Yeah, and I think Derek here was talking about the scratches. That's what happens when you collect metal. When I was a kid, my dad used to bring me to like junk days, driving around like trying to find like aluminum. And the thinner things of aluminum, you do pick them up and they kind of like flop. They're not as sturdy when they're so thin. And the thing just can come down and go boink. Or if you're holding it, carrying, yeah. So that very easily could explain getting lines on a neck. And not for nothing, but I think like scratches that come from an object are very different than fingernail scratches. Because with a fingernail, like an intentional grab, it's like that first point of impact, there's more of a puncture and then a more stringent, more abrasive grab before you start to let up and it gets lighter on the surface. The depth isn't as far down as you release from the scratch. It's very different than just like you're moving something and scrape it across your neck. So Tatum just says it was a blatant cover-up. Stop trying to make sense of it. You're right. You're right. It's a lot. I can't make sense of it. But I'm trying. It's the state's motion. So good to see you, Tatum. I Am Shout says the gun looks like it was buried about 10 years before Holly Bobo. It's crazy. Yeah, Sheriff Chuck says what's telling is that they used a gun that would have no value. And apparently his original story was he bought it to sell it. Listen, the more we try to make sense of it, the less sense it makes. Shout out to Derek for the super sticker. Thank you, Derek. Like, like, forgetting this whole thing, right? And then we have to talk about the shell casing. Who would use a revolver and then intentionally leave a casing? Their next evidence is going to be the fight between Zachary Adams and Shane Austin at Miss Dottie's house on April 13th, 2011, the I hit it conversation. So Zachary Adams and Shane Austin got into a physical altercation during the afternoon of April 13th, 2011, shortly after the victim's disappearance. The fight occurred at Dottie Cooley's residence and was witnessed by Jason Autry, Victor Dinsmore, and Debbie Doris. So Victor, in relation to this testimony, says on April 13th, 2011, Mr. Dinsmore was remodeling Miss Dottie's garage and kitchen. Quote, I was inside the garage doing some work. The cleaning lady had showed up, Debbie. Her and I talked a little bit. She went to work. I went back to work. And then Zach and Shane and Train pulled up in Dylan's truck. But remember, when he pulls up, they all pull up together. And when they pull up, Autry testifies, the air was thick with animosity. Like, it doesn't make sense. Wouldn't the air have been thick in the truck? Within 2 or 3 minutes, Zach and Shane Austin were arguing and fighting. And I heard a few spurts out of their mouth about who was going to hit it first, and I never even put it together at all. And I told them they couldn't do that here, because this was my job and they had to go. So they loaded up and took off. Train actually kind of broke them up and they loaded up and took off. This sounds exactly like they're fixing so badly to get high that they get this, whatever they're picking up from Dinsmore. Dinsmore's out at a job site and they're like, we need our fix right now. We need our fix right now. Where are you at? And Dinsmore's like, fine, I only got pills on me. But fine, come pull up. And they get there and they're trying to like start doing whatever right then and there. And Victor's like, this is, I'm working here. Don't do that here. Shoot. It sounds exactly like what one would expect if they went here to purchase drugs on the low. Debbie Doris. Miss Doris was the house cleaner who was cleaning Miss Dottie's home on April 13th in Decatur County, Tennessee. Miss Doris identified 3 individuals speaking to Victor Dinsmore. Of the 3, Miss Doris recognized one of them, Jason Autry. Miss Doris testified to the following. Arrived to Miss Dottie's house probably around 8 and 9. Mr. Dinsmore was also at Miss Dottie's house that day in the morning. Miss Doris and Mr. Dinsmore stayed at Miss Dottie's house all day to around 5 o'clock that afternoon. Around 2:30 and 3:30, Miss Doris sees 3 guys by a pickup truck talking to Victor. Miss Doris was recognized one of the individuals being Jason Autry. This is just horribly written. Jason Autry's trial testimony independently corroborates Dinsmore and Doris's testimony that Zachary Adams and Shane Austin got into a fight at Miss Dottie's house on April 11th, 2011. I need a drink. They're making me parched. They're making me parched. Yeah, seeing the scratches at trial was crazy. Like, linear scratches on the arms with what I'm gonna call pocks, like circle pock marks. Not what I would consider to be scratches inflicted by somebody trying to get away from somebody or defend themselves. So, wait, I can see you. Can you guys see Ariel? Okay, DB sees Ariel. And I think that's true, DB. I think I've run into the same issue on mobile. Where it acts like I was watching Andrea Burkhart's chat, and it was like, you must be a subscriber to chat. And I was like, did I unsubscribe to Andrea Burkhart? And it was just that. I had to get it just had to refresh itself. So if that's happening, Ariel, just try to give it a second and see if it lets you keep chatting. Yeah, I don't know what's going on with YouTube. Sheriff Chuck says, when you started the stream today with Jennifer Nichols, I was parched too, so I've already had a Bloody Mary. Dang, share with the rest of us. Oh, man. That's crazy. Jennifer Nichols. Miss would not lie to a jury and doesn't want a letter admitted or available to the media that describes claims of her forging documents in another case. I'll have to sleuth in on that. See what cases she was dealing with in 2011. Jason Autry, and hold on, that letter, if we can pin down when Autry whereabouts he would have written that letter, like maybe 2017, maybe it would be on the Court of Appeals docket. So, Jason Autry's trial testimony independently corroborates Dinsmore and Doris's testimony that Zach and Shane got into a fight at Miss Dottie's house on April 11th? April 13th, 2011? All right, we're on April 11th now. From Zach's house to Dottie's house, where we was headed, is less than 2 miles. I mean, you can be in there. I mean, it's less than 2 miles, probably 1.5 miles. I don't know exactly. We got in there and we pulled out of the driveway. Him and Shane started arguing. Yeah, Shane told him, he said, "You didn't have to kill her." And Zach told him, said, "You're just as damn guilty. You hit it." And Zach told him, said, "You shut your fucking mouth. I am sick of it being discussed. We're here." We pulled up, and he told him, he said, "I'll whip your goddamn ass." They got out of the truck at Dotley's, and 1 lick was exchanged. Zach hit Shane. Dinsmore pulls up. Oh, they put this in there? Oh, they did the transcript stupid. They put this part in here, Dinsmore pulls up, but what Jason says here is Dinsmore pulls up, comes outside. Oops. Should we run that back? Do I have that readily available? I think I have it in my little... Let's see. Jason Autry testimony. Let's see. Transcript. Let me search for it. All right, chat. We're back in 2017 to watch this.
And we pulled out of the driveway, him and Shane started arguing.
Who's him?
Zach and Shane.
Okay.
We pulled it in.
Arguing about what? Finish that thought.
Yeah. Well, Shane told him, he said, "You didn't have to kill her." And Zach told him, said, "You're just as damn guilty. You hit it." And Zach told him, said, "You shut your fucking mouth. I'm sick of it being discussed. We're here." We pulled up, and he told him, he said, "I'll whoop your goddamn ass." And they got out of the truck at Dottie's.
Dotley's.
1 lick was exchanged. Zach hit Shane. Dinsmore pulls up. Dinsmore comes outside, and this unidentified lady and stops it. Well,
so they forgot about that little oops in the transcript there. They let the first part in. The white Nissan truck. Testimony concerning Zachary Adams' white Nissan truck was significant evidence of Adams' involvement in the events surrounding the victim's disappearance and actions taken by Adams and Jason Autry on the day of the crime. Rebecca Earp testified that on the morning of the offenses, Zachary Adams woke Earp up, stating he was going off to haul off scrap metal. Miss Earp testified to the vehicle Zach Adams was driving on the morning of April 13th, 2011. Zach Adams was driving a white Nissan truck on April 13th, 2011. John Babb. There's issues with her, potentially based on her phone records, not even being at Zach's house when this is supposed to be happening. That she was actually located, her device was located at her mom's house. And it kind of makes sense because there's like posts from Zach Adams on Facebook and maybe some messages where it seems like he's fighting with her, but who knows. John Babb testified that he personally observed a white pickup truck near the victim's home the morning of the victim's disappearance. Well, I first heard something, a motor revving up loudly on the road. I looked over and a white truck came by extremely fast, probably faster than any car, any vehicle I've seen on that road before or since, probably traveling 55, 60 miles an hour. And I turned to my buddy and said, "Man, that white truck was flying." The vehicle was an actual pickup truck. The truck was going south, and just at the very north end of the Bobo property and my property, Swan Johnson turns into a gravel road. So I find it inconceivable that someone could have been going that speed with that made any sense whatsoever after coming off that gravel road, unless they were in one heck of a hurry. That's why it drew my attention. And there's no quotes around that, but okay. Victor Dinsmore testified that Zachary Adams hid his white Nissan truck in Dinsmore's pole barn after the Holly Bobo disappearance. This is so funny. They put one paragraph from him and we listened to like an hour of those audio recordings where Victor Dinsmore needs to figure out how to craft this story and help Brent Booth out about the details of what color truck, when it was happening, where they hid it, inside the pole barn or outside the pole barn. But we get this one paragraph here that Victor Dinsmore testifies about a particular pole barn on Dinsmore's property that Zach Adams hid his grandfather's white Nissan in on April 13th, 2011, after the victim went missing. Jason Autry's trial testimony concerning Zachary Adams' white Nissan truck corroborates the trial testimony provided by Rebecca Earp, John Babb, and Victor Dinsmore that Zachary Adams was driving a white pickup truck on the morning of April 13th, 2011. Jason Autry testified that on the morning of April 13th, Jason Autry met Zachary Adams at 30 Yellow Springs Road. Zachary Adams was standing at the door of a white 4x4 Nissan Frontier. This is like the most specific description we ever get of this truck. And unsurprisingly, it comes from Jason Autry. A few minutes later, I got out and walked back to the 4x4 Nissan where Zach was standing in the door, and he said, "I need you to help me bury this body." And I told him, I said, "God damn, I hate that y'all killed little JoJo." He said, "Jason." He said Train. He didn't say Jason. My nickname is Train. He said, "Train, that's Holly Bobo." Now the cell phone data. Michael Frizzell. Mr. Frizzell was a TBI special agent who testified for the state at trial as an expert in cellular telephone tracking. Mr. Frizzell's testimony and expert report were able to establish the movement and interactions of Zachary Adams, Jason Autry, and the victim on April 13th, 2011. And interactions. Movement, maybe, but I feel like Frizzell was somewhat... Like, he didn't really try to say that just because somebody's in the same range of a tower, that meant the individuals associated with those devices or those devices were interacting in any way. Although I guess maybe they could have just worded this better, because maybe they mean interactions between Zachary Adams and Jason Autry. Only those two? Because Zach Adams' phone isn't interacting with Holly's phone. And Jason Autry's phone isn't interacting with Holly's phone. Neither of them are calling Holly or texting Holly. They should have worded this sentence better. Let's see. Victim's phone. On April 13th, 2011, the victim's phone started utilizing towers to the north of her residence at 8:17 a.m. and 8:26 a.m. The phone then utilized the tower to the east at 9:06 a.m. AT&T provided 3 locations for this phone via latitude and uncertainty, showing the phone in the same general geographic areas from 8:57 to 9:10 a.m. These locations are consistent with being in the same general geographic location as Jason Autry and Zachary Adams' numbers at the same times. AT&T provided a final approximate location for Holly's phone. Wait. Hold on. That's Jason's number. They put Jason's number here as Holly's. So victim's phone, 7352, Jason Autry's phone, 7352, and last approximate location, 7352. Okay. In the general geographic area, as it gets dicey, the cell phone data gets dicey. In the general geographic area, as the victim residence and where the phone and SIM card were located. Yeah, I think so too, K-Riggs. The Jojo Bobo thing was put in there so he could later claim that he misheard Zach. So I heard that, oh my god, what was the guy's name that's running against Jennifer Nichols? Nicole talked about it quickly with Misdemeanor yesterday on the show. There is a guy running against her. And I meant to say that on the stream, so I'm glad you put this in the chat, that she isn't just running opposed, that there is someone running against her. So, but I've got to check the name, sorry. All right, so we've got like badly typed out phone number assignments here. Now they're going to talk about Zach Adams' phone. So, and they're giving his number here, the 0191, consistently utilize the AT&T tower located at 50 Cox Road, Holiday, Tennessee, which is near the I-40 Highway 641 intersection throughout the day, with 2 exceptions. The first exception occurred from approximately 9:50 a.m. to 10:37 a.m. on April 13th, when this target phone utilized the AT&T tower located at the Birdsong Road I-40 intersection near the Tennessee River. The second exception occurred when this target phone utilized an AT&T tower located in Parsons, Tennessee, which is approximately south of I-40 and Highway 641 intersection at approximately 11:16 a.m. through approximately 12:18 p.m. At approximately 12:35 p.m. through 11:36 p.m. on April 13th, the target phone then began utilizing the AT&T tower located at 50 Cox Holiday Road, which is near the I-40 Highway 641 intersection. No network activity was noted for target phone on April 13th between the times of 4:58 a.m. and 8:19 a.m. I think this is correct if you only look at Frizzell's testimony. But if you look at the actual data, do you guys remember when we were rewatching this part of the trial and we kept talking about 4:58 or maybe 5:58, which this would exclude both of those options. Frizzell kept forgetting when it was Paul Hagerman doing the questioning. And they kept Paul Hagerman in his questions kept leaving out that there was some activity around this time frame. I have to rewatch that to like recompartmentalize and refresh on that. But that was like, I think Frizzell was missing that in his testimony because of the way Paul Hagerman was asking his questions. Jason Autry's phone. On the morning, let's see, they're using 2073 now, so they're correct. I think that's got to be his correct number now. On the morning of April 13th, 2073 utilized an AT&T tower in Camden, Tennessee area. And he said he was at his girlfriend's that morning at approximately 6:50 a.m. This target phone began utilizing the AT&T tower located at 50 Cox Holiday Road, which is south of Camden, Tennessee, at approximately 8:19 a.m., where it remained until approximately 8:55 a.m. It was during this time frame that this particular target phone first had contact with target phone 0191. So Zach. The next network activity occurred at approximately 9:42 a.m., in which the AT&T tower located at Birdsong Road, I-40 near the Tennessee River was utilized until approximately 10:36. The next actively occurred at approximately 10:39 a.m. and again at approximately 10:48 a.m., in which the AT&T tower located at 50 Cox Road in Holiday, Tennessee was utilized. Jason Autry's trial testimony concerning his whereabouts and movements on April 13th, 2023 is corroborated by cell phone data analyzed by, well, no shit, because he looked at the discovery after you finally gave him 2 discs that were accessible and came up with his story to match the data. And so it corroborates. Alrighty. Victim's autopsy. Victim's autopsy. We're almost through this, guys. We've got like 9 pages left of 40. Dr. Marco Ross. Dr. Ross, a forensic pathologist, testified for the state concerning the autopsy of the victim. He also testified to ballistics. See attached Collective Exhibit A for a report of autopsy examination and photos. Dr. Ross testified that only bones from the victim's upper torso were recovered and examined by his office. Moreover, Dr. Ross testified that Holly Bobo's cause of death was a gunshot wound to the back of the head. What we received for examination included the skull along with the mandible, with some teeth present in there, as well as several individual loose teeth, the left scapula or shoulder blade, and there were 6 ribs here. There's a footnote that says Dr. Ross testified that only bones belonging to the victim's upper torso were recovered. This evidence is corroborated by Corey Rivers, whose name is spelled wrong, testimony at trial, that Zachary Adams told Rivers that Holly Bobo's body was chopped up. It had got chopped up, said it had been chopped up, and that the bottom side, see, but this is the part, it doesn't make sense. Who found the body? Who found the body? So now the state is saying we want to bolster, and I don't know why they want to bolster the medical examiner. We only looked at some of the body parts. It seemed, to me, that raises a red flag on what were we doing with the scene where we found this body? Why was there a 2-day window before we're doing the line walk? Why were knucklehead TBI agents over there by themselves in those 2 days before we had the group over there? To me, it seems like we're trying to counter that, because I don't see a reason for the point of this motion to both need to bolster for the medical testimony about the body being chopped up. You could just leave that only part of the body was recovered and maybe the other half washed away. I don't know. Like bones degrade and it was laying a certain way and water flooded up to where someone's hips would be and water carried that away, but the water didn't rise high enough to carry the rest away. I don't know. Why are we fighting this argument here? It's just weird. And then it contradicts. Corey Rivers also said that according to Zach. So if we're supposed to believe that Zach's statements are true on their face and thus inculpatory, he told Corey that the bottom part was found, and that's not true. Maybe it is true and the state's never disclosed it, but somehow Zach knows. Like, what do we have to believe all of the things that the state wants us to believe? So then they say some other pieces was found otherwheres. All right, so back up here, because we were at this footnote, back to Dr. Ross. Dr. Ross testified the cause of the victim's death was a gunshot wound to the back of the head. Dr. Ross testified that the bullet wound to the back of the victim's skull is consistent with a caliber bullet that was no larger than 0.36 inches or smaller. I mean, what, chat? That was no larger. Oh, I'm not doing the line. I expected that to be a line. Don't judge me for that underlining. That was no larger than 0.36 or smaller. I mean, why do we need to put both phrases here? That was no larger than 0.36 or smaller. Which includes a .32 caliber bullet. The revolver. Jason Autry's trial testimony corroborated Dr. Ross's testimony. Jason Autry acted as a lookout while Zachary Adams shot Holly Bobo. Autry testified Zachary Adams shot Holly Bobo once, and immediately afterwards, Autry heard a boat motor, which caused them both to quickly load Holly Bobo's body back into the truck and leave the area. And they've suddenly found this mystery boat guy that's supposed to come testify on the 29th. Has never been disclosed before. But he's coming to this December 29th hearing to testify for the state. Autry noted there was a blood pooling the size grapefruit. You know what? We might have to rewatch that today. So this weekend over in the Discord, I think it was K Riggs, DB, I think Jeevy was in there. We're trying to look at historical Google Earth images of the same area. And the problem with Jason Autry's testimony is the audio is out of sync by like 6 or 7 seconds. So quick questions and answers when he's pointing with the laser pointer, what we're seeing on the screen might not match what he's saying yes or no to or pointing at verbally as the visual. But he has this weird thing going on. Maybe I can just, did I drop the screenshots of the contradictions in there? Maybe I can just read it real quick. I think it's screenshotted. Let's see. We might need to do a stream just on like the Google Earth versus testimony. All right, I have one image. Let's see if we can get it on screen. So it's a bit tiny here. This one reads, and it's attributed to the prosecutor, but it's really Autry. I set the body down with the upper torso incline, like you would set. Look, this is right here. When I was standing over here, Mr. Adams was standing at the upper torso at this place. I could not see him. Yeah, I mean, it's pretty high of vegetation. All right, so you said he was standing here like this. I mean, he was up on the riprap looking down at her. It's correct, like this. All right. And like, again, I didn't really piece this together while he's testifying, but he's saying this vegetation in this area was so tall that even though Zachary Adams is standing upwards, he's up on the incline of the riprap, that he's apparently still being hidden from Jason Autry's view. Jason Autry is a very tall person because the vegetation is so tall. That was one part of it. That was one part of it that didn't make sense. Let's see. Well, let me just open these transcripts. Let me search for grapefruit and orange. All right, and shout out to DB for providing these transcripts. All right. So that should be on screen now with you guys. We're going to look right for the part about the orange and then the part about the grapefruit. So to contextualize here, they are just pulling up to this Tennessee River Bridge area. And they're getting the lights right. And they're like, all right, so with you, Mr. Adams, you're in this pickup truck. You back up to this pile of riprap that you just showed the jury. That's correct. We backed up to that pile of riprap approximately the distance of this to that. We didn't back all the way against it. When you say this to that, you just indicated the witness box to the jury box. Yes, approximately 5-6 foot room to get out. I got out of the truck with the right hand and grabbed the upper torso of Miss Bobo. And then they said, Zach came around, let the tailgate down. I brought the upper torso to the end of the tailgate where he grabbed the legs, and I set the head to the upper end on the riprap pile. Now, Nichols asks, did you notice anything about the blanket or the truck? The bed that tried to see anything? And then Autry says, in the bed of the truck, there appeared to be a small amount of blood. And then Nichols says, can you use your hands to describe what you mean by a small amount? And now this is talking about the bed of the truck when they first pull up. Before we would have shot and then the birds are flying away and there's this boom, 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 that there's already this blood spot. And Jason is consciously thinking of this blood spot in the back of the truck and says, well, the bed of the truck was reached like the bed of the truck, and it looked as if I just lightly skied it over, and the blanket that the upper end of the torso that I grabbed had a small blood spot. So there's already this blood spot. He says maybe the size of an orange, maybe the size of an orange. They never say they unwrap her. Then they get to this other part after they get through this long description of, oh no, does it not? Grapefruit. Okay, I don't think grapefruit is described. Let's see if we can find it by looking for blood. Okay, here we go. So then after this gun shot is fired, the boat pulls up, they're panicking, they grab the same spot at the upper torso. The blood spot was probably the size of a grapefruit at that time. Then we load the body back in the truck. So it's like he's visualizing this blood spot and so focused on talking about this blood spot, but the blood spot is both there before and after they fire this shot. But it's the same blood spot that's growing in size from the size of very small to like maybe an orange from the point in the back of the truck before they get Holly out. But it's also growing before they put Holly back into the truck. So it's like he just has in his head he needs to describe this pool of blood, but he's forgetting at what point in time she's supposed to be bleeding. And if she was bleeding because of an injury caused before they take her to this location and shoot her, then the blood spot, the same blood spot, shouldn't be growing because of the gunshot. Like, it's just weird. And it's almost more weird reading it and having the words on paper versus just hearing it and it kind of flies by you. So that was a weird one. That was a weird one, you guys. Also, shout out to Touche. Thank you for the 5. Says, Kat, I love where this trial is taking you theatrically. I just want it to make sense. I just want it to make sense. Like, I feel like there's no way to try to figure it out without a little drama behind it. So this is just, you're right. It's an amazing time. I've got to get into character to try to make it make sense. So they've got here that Jason Autry, this whole pooling the size of the grapefruit as their, and they don't use a quote here. They do a narrative. They say testimony and then they do a narrative across several pages. But the way they phrase it is Autry was acting as a lookout. Autry testified that Zachary Adams shot Holly Bobo once, and immediately afterwards, Autry heard a boat motor, which caused them both to quickly load Holly Bobo's body back in the truck and leave the area. Autry noted that there was blood. There was a blood pooling the size grapefruit. And that's just where they leave it. That's how they contextualize it. And they say that this testimony corroborates Dr. Ross's testimony about the gunshot wound being the cause of death. But they don't include the transcript where there was an orange-sized pool of blood before a shot was fired. Other witnesses corroborate Jason Autry's trial testimony. I feel like I need to have my little picture up. Because this is how I sound right now. Other witnesses corroborate Jason Autry's trial testimony. So we have Brenda O'Brien. Brenda testified that in April 2011, her parents lived in the Holiday community across the street from Kelly Ridge. Her parents' property was wooded and contained 3 ponds. About 1 week after the victim's disappearance, Miss O'Brien testified that she observed a silver PT Cruiser traveling up her parents' driveway. The individual driving the PT Cruiser came to the door of the residence and asked Miss O'Brien permission to fish in the ponds. And I gotta say, I really think this is a damning piece of testimony because it's weird. Why would someone come and ask this? But it makes sense if this is just some random thing Jason Autry was doing and Brenda O'Brien's statement was in the discovery folder. He's aware of it. He can sprinkle it into his testimony. And the jury is going to be like, wow, you wouldn't volunteer that information unless it's Jason Autry saying we went there because something sketchy was happening with Holly Bobo. So they have this testimony from Brenda here saying that she told the visitor he would have to talk to her dad. The visitor asked where O'Brien's father was, and O'Brien responded that her father was helping in the search for the victim. Quote, when I mentioned Holly, he became very stressed. He rolled his eyes, ran his fingers through his hair, just looked extremely stressed. At that point, he said, okay, I may come back later. He got in his car and backed out. Jason Autry's testimony at trial is corroborated by Brenda O'Brien's testimony. Autry was suspicious that Holly Bobo's body was in the area near the O'Brien property and went there to investigate. Jason Autry testified he owned a PT Cruiser. There was 2 ponds there on that property at the entrance of Kelly Road at Kelly's Ridge. I seen buzzards sitting in an old dead tree in the back of one of the ponds. There is a house at the entrance of Kelly Road. I got out and I knocked on the door, and I asked the person living there if I could go fishing down there. They told me no, that there had been some river otters or creek otters come through there that wiped all the fish out. They didn't want to go back on the... They didn't want nobody on the property. At that time, I got back in the vehicle and left. And now we're at a conclusion. So that's, when they say they had mountains of evidence, that's what it is. That's what it is. So we've got a conclusion now. Petitioner Adams' Coram Nobis petition fails to show that the evidence is newly discovered, as he had access to this evidence in prior to trial, and in a manner that would have afforded him an opportunity to assert a claim, if any, within a reasonable time. As such, this court should find that Petitioner Adams has failed to show facts on the face of his Coram Nobis petition that he is entitled to equitable tolling of the statute of limitations. While Jason Autry's testimony was helpful to the state, as the trial transcript reflects, Mr. Autry did not play the role of, quote, star witness in Petitioner Adams' trial. Petitioner Adams' own admissions to multiple individuals concerning his involvement in the disappearance, rape, and murder of the Holly Bobo are the most incriminating pieces of evidence the state of Tennessee presented at trial. These admissions came from Petitioner Adams himself, not from anyone else, including co-defendant Jason Autry. Mr. Autry's alleged, quote, recantation does not exculpate Petitioner Adams. And they cite here Carl E. Ross v. State, finding that not only was petition time-barred, but affirmed court's denial of Coram Nobis relief on basis co-defendant's recantation would have no impact on jury verdict. And then we also have Spadafina v. State, affirming court's denial of Coram Nobis relief where co-defendant's recantation lacked credibility. This court should deny Petitioner Adams writ of Coram Nobis without an evidentiary hearing. And then Jennifer Nichols can't sign on the line. I don't want to have anything in common with her. Don't look at that. And then what do we have? So as an exhibit, we have this narrative summary from the medical examiner. So this is coming from Charles Alderson. So remember we had Ross stand in, but I guess he looked at this. Let's see. This is still, it's under the Honorable Matt Stowe. Let's see. Reportedly, individuals hunting for ginseng in the area of County Corner Road in Decatur County last date discovered a human skull. 911 emergency was contacted, and Decatur County Sheriff's Office and TBI responded to the scene where several other bones were located. So they just lumped this all together as if it happened right away. And that's not how this played out. This office was notified by Special Agent Jeff Jackson, who requested his office perform the examination. That's who goes there first and is just punkering around. Who requested his office perform the examination. Chief Karen Chancellor was contacted by this investigator, and jurisdiction for the examination was accepted. The decedent was transported to the West Tennessee Regional Forensic Center by Special Agents Joe Wheeler and Brent Booth this date for examination. Identification and final disposition to the funeral home. Carl Fowler, investigator, 9/8/14. So they found on the 7th. That's Ginseng Hunter Day. And they're saying that the transport was the next day by Joe Wheeler and Brent Booth. And they determined cause of death, back of the head. And this is signed 1/21/2015. All right, so report of the autopsy. So date, September 8th, 2014. Body identified by dental records and x-rays. Pathological diagnoses, we have gunshot wound to the back of the head, skeletonized partial human remains. Cause of death is gunshot wound to the back of the head. And the facts stated herein are correct to the best of my knowledge and belief. Signed by Karen, the pathologist. We've got external description. The remains consistent of a skull, cranium, mandible, manubrium, 7 ribs, 6 right ribs and 1 left rib, left scapula, and several teeth. No soft tissue is present. The bones are weathered and demonstrate animal scavenging. Evidence of postmortem animal activity is noted on the cranium and on the left scapula. I mean, is there any evidence of sawing, of someone on the available bones trying to cut anything? Evidence of injury. There's a gunshot wound to the right side of the back of the head, located at the junction of the occipital bone and right parietal bone, at the lambdoid suture. This entrance defect is round and has internal beveling of the endocranium. The wound tract exits the cranium through the clivus of the occipital bone, forming a defect with external beveling. The wound tract continues through the left-sided facial bones. A defect with external beveling noted on the fractured edge of the left maxilla. Linear fractures resulting from this gunshot wound injury are described in the forensic anthropology report. This is a gunshot wound to the right side of the back of the head, with the wound tract passing forward from right to left and slightly downward. The range of fire is indeterminate. And let's see. They do x-rays of the remains. They collect, what evidence did they collect? A fiber-like strand of material is removed from the manubrium. This fiber appears to be a fragment of vegetation. A fragment of pink yarn-like material is removed from a right rib. Uh-oh. Pink fabric. So maybe the t-shirt, maybe they were hoping the pink panties. They don't collect any environmental stuff from around where the remains are collected. Like, are they able to compare anything to these fibers? Summary and interpretation. On September 7th, 2014, human skeletal remains were found in a rural area of Decatur County, Tennessee. These remains were subsequently identified as those of 23-year-old white female Holly Bobo by comparison of ante-mortem dental records and x-rays with the post-mortem dentition. Please see the forensic dental report. A forensic anthropology consultation is also obtained. At post-mortem examination, there is a gunshot wound entrance of the back of the head with exit through the basilar skull and left facial bones. In my opinion, the gunshot wound is the cause of death. The manner of death is homicide. And then they have the pictures of the remains. So, and it says 2 of 16. So there's more of this report, but that's what's included. There you go. So that is the state's motion to dismiss. That is the state's motion to dismiss. I think that was a mouthful. So that was May 9th. I think these are typos. These were filed in 2024, but for whatever reason, both of them say 2025 here. But we are in May of 2024. We're going to move forward to the 28th. And this one's nice and short. So this is just the petitioner's notice to strike exhibits to post-conviction relief. So comes now the petitioner, and without waiving any issue is repeated twice. So get it together, counsel. Come on, Doug. Regarding its admissibility at the evidentiary hearing at the post-conviction relief hearing, hereby strikes from the records exhibits 1, 2, and 3 filed to the original amended post-conviction relief petition. Signed by Doug. All right, now June 4th, I'll zoom in a little bit on this because this is kind of tiny. We've got an agreed order. So what are they agreeing to? So the parties agree to the following. The state of Tennessee, and this is the 4th of June, 2024. The state of Tennessee has filed a motion to hold the petitioner's post-conviction relief petition in abeyance pending resolution of the state's motion to dismiss petitioner's writ of error coram nobis. The parties agree to temporarily resolve this motion by holding the post-conviction relief petition in abeyance until the court enters an order on the state's forthcoming motion to dismiss. This abeyance shall be reviewed by the court after it enters an order either dismissing the writ of error or denying the state's motion to dismiss the same. However, before this court reviews the abeyance, each party will be afforded an opportunity to be heard on their respective positions concerning the abeyance. All additional issues are reserved until further notice of this court, and this is signed by the judge. So, approved by Doug and... Oh! We had sign off. So this looks like Doug Bates is writing in print the names of Jennifer Nichols and Christopher Boiano by permission, which would mean Doug Bates is representing to the court that I discussed with these two individuals from the prosecution team, and they agreed to this order. And if you make a representation like that and it's not true, not a good thing to do. But that's why there's not a signature there. We've got next up more an order striking exhibits. So this is just the judge granting at the request that the exhibits 1, 2, and 3. We're granting Zach Adams' motion to strike those, and that the circuit court may destroy the thumb drive submitted to the clerk. Notice of appearance. Amanda Gentry, that's Dylan Adams' attorney, makes an appearance. June 10th, 2024, State of Tennessee's reply to Adams' response to the state's motion to dismiss writ of error coram nobis. Why don't we have... Did I miss it? I don't see the response to the state's motion to dismiss. All right, let's... Let's see, maybe they filed it in the 2025 on accident? No. Well, that sucks. Well, so this is the next one, though. So it's the state's reply to Adams' reply to the motion to dismiss we just read, but we don't have the reply, so that sucks. That sucks. I really wanted to read that. So, 10th of June, 2024. So it comes now the state of Tennessee by and through undersigned counsel replying to Zach Adams' petition as grounds not their petition, their response to the state's motion to dismiss. All right, the petition's time barred, so they're going to argue this again. As correctly stated in Petitioner Adams' response, the untimeliness of a writ is not an affirmative defense, but rather lies on the petitioner, who must show on the petition's face, that it is untimely or supported by facts to equitably toll the statute of limitations. In his response, Petitioner Adams conceded that his coram nobis petition was untimely filed. Therefore, to survive the state's motion to dismiss, Petitioner Adams' petition must contain specific facts showing entitlement to equitable tolling in order to avoid being summarily dismissed without an evidentiary hearing. While a witness's recantation of his prior testimony may be newly discovered evidence, before granting a new trial on the basis of newly discovered recanted testimony, the trial court must find: 1, it is reasonably well satisfied that the testimony given by the material witness was false, and the new testimony is true. 2, the defendant was reasonably diligent in discovering the new evidence, or was surprised by the false testimony, or was unable to know of the falsity of that testimony until after the trial. And 3, the jury might have reached a different conclusion had the truth been told. In other words, the court may grant a petition for a writ of error coram nobis if it determines that if the newly discovered evidence had been introduced at trial, there is a reasonable probability that the result of the proceeding would have been different. Petitioner Adams cannot show that Jason Autry's prior testimony was false. Nor has Petitioner Adams provided any specific proposed testimony of Mr. Autry that contradicted his trial testimony. Only unsworn blanket statements. In parentheses, he concocted the entire story by reviewing discovery material. He recreated his day and added Holly to it. General Nichols trained him to testify. Jason Autry's unsworn statement should be given less weight than is already applied to recanted testimony, which is looked upon with distrust rather than favor due to the great temptation to strengthen the weak points of the case discovered during the trial by perjury or subornation of perjury. So A, Jason Autry's unsworn statements are insufficient to establish Petitioner Adams' actual innocence. Petitioner Adams' response argues that his petition's noncompliance with quorum nobis law and procedure is simply a technicality, although Petitioner Adams seemingly acknowledges in his response that dismissal could be warranted due to this technicality. Post-conviction petitioners seeking a new trial based on newly discovered evidence must satisfy rather exacting standards. Let's see. The contents of a petition for a writ of quorum nobis are of the utmost importance. And I wonder if this is like coming down to the affidavits. So we've got, I'm peeking over here. Hey, trial and error. I see Sheriff Chuck saying here, hey, I've been researching water levels in Tennessee in April of 2011. Tennessee River was close to record level flooding. No way Autry's story is true. And I was looking at like a hobbyist's weather data in like the Savannah region, and it was specifically April 2011. That hobbyist website was documenting like historical flooding. So interesting, very interesting. Very, very interesting. Let's see what else we've got here, chat. Judges anticipate that the petition itself embodies the best case the petitioner has for relief from the challenged judgment. Thus, the fate of the petitioner's case resets on the ability of the petition to demonstrate that the petitioner is entitled to the extraordinary relief that the writ provides. In his response, Petitioner Adams identified several quorum nobis cases in which a non-affidavit petition ended up obtaining an evidentiary hearing. Well, that seems important. Because if I just went on what was in the state's motion to dismiss, I would have believed that all the case law says you need affidavits, only affidavits, nothing else matters. They say, however, many of the examples, which will be discussed below, cited by Petitioner Adams were not challenged by way of the state of Tennessee filing a motion to dismiss. Petitions for writ of error quorum nobis have always been subject to challenge by a motion to dismiss. Okay, so I'm not sure that really addresses that they're providing that it can be done without affidavits. It just means you can also respond, file a motion to dismiss. The only case cited by Petitioner Adams referencing the state filing a motion to dismiss is Pittman v. State. In Pittman, the state motion to dismiss the quorum nobis petition, arguing that it was untimely and that it failed to state a cognizable claim for relief. Yet nothing in this opinion indicates that the state's motion to dismiss was addressed prior to the final hearing. At the final hearing, the quorum nobis court ultimately dismissed the petition, finding that the proffered newspaper article did not constitute newly discovered evidence. None of the remaining cases cited by Petitioner Adams stands for the proposition that a non-affidavit quorum nobis petition is sufficient to justify an evidentiary hearing. Let's see. Their Freshwater v. State says, involved undisclosed Brady material concerning a written witness statement that implicated someone other than defendant as the shooter. The written statement was in the possession of the state at trial and was not turned over to the defense counsel during discovery, who had no knowledge of the evidence existence. The Court of the Criminal Appeals reversed the quorum nobis court's summary dismissal of the petition and ordered an evidentiary hearing. Then they've got Hayes v. State. Quorum nobis court denied the petition. While the defendant was reasonably diligent in securing an affidavit, the victim's recanted testimony was not likely to have changed the outcome of the defendant's trial, and the majority of her hearing testimony was merely cumulative of her trial testimony. Bland v. State. Quorum nobis court declined to grant the petition after expressing doubt about the veracity of the witness's testimony and finding that there was no reasonable basis to conclude that, had the recanting of his testimony been presented, the result of the proceedings would have been different. We've got Ward v. State. Quorum nobis court summarily dismissed the petition, finding that even if the information proffered by the petitioner could qualify as newly discovered evidence, it could not avail her of any relief because the evidence would not have led to a different outcome at trial. And not for nothing, but this is spelling out that it seems like the court is evaluating all of the facets in each of these cases. Like, we're not just saying, like, hey, we're denying everything unless you reach a super high bar. It's, some of them are, hey, we think that this might be new evidence, but we don't think it would have changed the outcome of trial, even if it had been available. Or, hey, we don't think that this is new evidence. So I really don't get the counter argument being presented by the state here. Because if you take these all at a sum, it seems like rather than granting a dismissal without an evidentiary hearing, that a lot of these courts wanted to look at what the petitioner was going to argue. So this last one, we've got petitioner denied relief, finding that the petitioner's post-conviction claims were time-barred and that quorum nobis claims were without merit. There is no reason for this court to be satisfied that Lisa Carroll and Jason Autry's statements, as referenced in Petitioner Adams' petition, have any indicia of truthfulness. Neither statement is in the form of an affidavit. Petitions for quorum nobis relief must be supported by affidavits that are relevant, material, and germane, and are based on the affiant's personal knowledge. And again, there was case law that they cited earlier that said the affidavit could be submitted before the evidentiary hearing. It does not need to be included in the initial petition. So if there's something that an affidavit needs to be provided for by somebody, or the affidavit, we need more information, there's time to remedy that outside of this motion to dismiss. But they're arguing anyway. They're going to try. We've got affidavits of the witnesses through whom the newly discovered evidence is sought to be introduced, must explain the materiality of the evidence, and must state that the evidence was not communicated to the prisoner or his or her trial counsel prior to the original trial. So there we finally have an or of his trial counsel. And that they really need the affidavit to state this. Given that Lisa Carroll and Jason Autry's statements are not in the proper form of affidavits, this court should not consider any reference to these unsworn statements in Petitioner Adams' quorum nobis petition. Now, notice that they're not making the argument, hey, even though this is something that Lisa Carroll, they're not disputing. They're not saying, we didn't have this information either. It's not that we could have disclosed it if we wanted to. The issue that they're taking is just, it's not being stated in the sworn affidavit that this information was not given to trial counsel before the time of trial. Okay, well, let me finish this section and I will check. So we've got, moreover, many of the statements included in Katie Spirko's affidavit. Shout out Katie Spirko. Lack her own personal knowledge. Specifically, why are we doing the parentheses this way? What is going on here? 6A, 6B, 6C, or maybe it's 6 and then A, 6 and then B, 6, all the way through. Spirko's affidavit contains inadmissible hearsay of others and does not contain information regarding any newly discovered evidence or its materiality that Katie Spirko herself has personal knowledge of. Similar deficiencies exist in the statements contained in Jennifer Thompson's affidavit. Although it is a signed affidavit by Petitioner Adams' trial counsel, Thompson fails to set forth any examples of newly discovered evidence, explain the materiality of such evidence, or state that the evidence was not communicated to Petitioner Adams prior to the original trial. Wait, does B take us to the end? Oh God, they're gonna make us read Jennifer. All right, give me a second, you guys. We're gonna take a little interlude. I'm gonna drink some water. We're gonna write at this subsection B here. That way we know where to come back. And I'm going to make you listen to, let me find Jason Autry's, where he's drawing on the diagrams. We'll run that back. Or using the laser pointer to talk about the diagrams. Where does he talk about this riprap? All right, so I've got that queued up a little bit. Sorry to put you through some Jennifer Nichols. I'll be back. Give me like 5 to 10 minutes, guys. I'll still be looking at the chat though. Why won't it play?
Can I move this?
We'll have the lights down just a minute.
Can I move this over a little bit? Twist around, see?
Yes.
It won't go, Your Honor.
Y'all have enough cord? Okay.
It'll be all right. We'll get her done.
Is this 177 or 9? I can't read.
177.
177. All right, Mr. Autry, I want you to use the laser pointer and explain to the jury what they are looking at in this photograph.
Right here is Interstate 40, east and west. Right here is the Tennessee River Bridge. Right here, this gravel road is the gravel road we entered.
I'm sorry, you said that's the gravel road you what?
We entered.
Okay.
I'm trying to get to the mic and to the... We come in this fashion here, down here, and this down in this general location right here is where the beach is that I was telling you about. Over to this side is where the other boat ramp is. Right here, this little white dot right there is the pile of riprap.
I want to ask you, have you driven over that bridge your whole life, basically?
I have, going to and from.
If you're on that bridge traveling,
Right here.
can you see, even though it looks like, can you see?
You cannot.
And I didn't finish my question. I think you knew where I was going. Can you see what's below you there, close to the riprap?
You cannot. You're lucky to see this right here.
And you're showing the water?
This would be the lake. This would be the lake.
Okay. Let me put the next one up.
I'm sorry about the inconveniences.
All right. What is this one?
This is a picture of Interstate 40, the bridge. This is the riprap. This is a trail that runs this way.
All right. And that gravel road that you showed the jury that you came in on?
Right there it is.
All right. And in the previous picture, it just showed that it went further, correct?
That's correct.
Okay. And the next one. Sort of a close-up.
That's correct.
Now, in this picture, you see the edge of the highway or the bridge. Is that right?
That's correct.
And there appears to be a barrier. In other words, where you won't go off of it
Right here.
if you're traveling?
Right here.
Okay. And is that part of what obstructs your view if you're traveling down that road?
It is that factored in with elevation.
All right. So do you see the pile of, let me ask you this, is this what it looked like then, or does it look different now in this picture?
It looks different in this picture.
All right. What is missing or what is different?
This right here was bigger and was green like that right there. Was green.
What do you mean bigger?
There was more rock there.
Okay. Show the whole area where there was rock back when.
It looked, you see how this looks tall. It was all in that fashion running out.
Okay. We can take pictures down and get the lights back up. So with you when Mr. Adams backed his truck up to the pile of riprap that you just showed the jury,
That's correct.
I want you to start there, please, and tell them what happened.
We backed up to that pile of riprap, approximately the distance of this to that. We didn't back all the way against it.
When you say this, that, you just indicated the witness box to...
To the jury box.
Yeah.
Yes, approximately 5-6 foot, room to get out. I got out of the truck with the right hand, and I grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down. I brought the upper torso to the end of the tailgate where he grabbed the legs, and I set the head, the upper end, on the riprap pile.
Did you notice anything about the blanket or the truck, the bed of the truck? Did you see anything?
In the bed of the truck, there appeared to be a small amount of blood.
Can you use your hands to describe what you mean by small amount? And your,
The bed of the truck was ridged, like the bed of the truck, and it looked as if it had just lightly skidded over. And the blanket at the upper end of the torso that I grabbed had a small blood spot, maybe the size of an orange.
hands up, because I don't think they can see it on here.
Maybe the size of an orange.
Did you look inside the blanket?
Never,
Did you unwrap?
never.
How were you able to swing her body around and you get the top part and Zachary Adams gets the bottom part without unwrapping the blanket?
I grabbed the blanket just like you would this shirt right here. The body didn't weigh very much. I was in pretty good shape. I'm a pretty good sized guy. I grabbed the blanket just like that right there and walked to the tailgate of the truck. At that time, he grabs the legs. We set the body down with the upper torso on that pile of riprap that y'all just showed, that we just discussed.
After you put Holly's body down on the riprap, what happened?
Mr. Adams goes to the driver's side of the pickup. I'm standing over the top of him with my hands on my knees. She being right here. And at that time, I see the foot move, a movement, and a sound of distress that sound like, come out of the voice, come from the blanket. At that time, I walked to the door, to the passenger side door of the pickup, and Mr. Adams was digging in a fanny pack. I told him, I said, this fucking bitch is still alive. We just stopped for a second. I walked to the front of the truck. I told Zach, I said, she's heard my name called and heard me talking and all. At that time, he wheels around, walks back to the driver's side pickup, out of the floorboard of the pickup. He pulls a pistol, the same pistol that was holstered on Mr. Austin's side at 30 Yellow Springs Road. And I said, whoa.
Now, let me ask you something here. Did you say whoa because you thought you were gonna save her life and stop him from doing something bad? Or did you say whoa for another reason?
I said, well, for another reason, to go look.
Where'd you go look?
As we showed you on them 3 pictures,
I'm gonna put back exhibit 177 up there.
I said, whoa, and I run all the way across here to about this area and looked that way to see if anything was coming.
How far could you see down there?
Maybe 250 yards. It's a long, pretty long stretch from right here to the next curve. I looked around, and when I looked back around, Mr. Adams was standing.
Let me stop. You said you looked around. Did you stay down there at the corner or did you come back?
I stayed right here working back and forth, watching.
What about looking the other way?
There was nothing coming. I looked back this way, and I told him there was nothing coming.
When did you look back the other way? The way that you came in on?
Just shortly after I noticed that I looked down here and wasn't nothing coming.
Okay. You can read the lights. Hang on. All right, you can keep going.
I looked around, and I told him that there was nothing coming, the coast was clear, something to that effect. And at that time, boom, the gun sounded, the gun went off. And it sounded like to me that it shot 3 or 4 times underneath that bridge. I had done made it back. I had done started my way back this way. And it sounded like boom, boom, boom underneath that bridge. It was just one shot, but it echoed underneath that bridge all the way down that damn river bottom. And when that gun went off, there was Martins went everywhere.
I'm sorry, didn't hear that.
Martins, bridge, birds went everywhere. Just all up under that bridge. And it just dead silence for just a second. I was still in this general location right here. And I heard a boat. Boat crank up, a boat running somewhere in either here or over here, somewhere there was a boat. Or either down the Tennessee River was right here. And I took off running, run back over to the truck, and I told him, I said, God damn, we have been seen or heard. And at that time, Mr. Adams grabbed the feet. I grabbed the same spot at the upper torso. The blood spot was probably the size of a grapefruit at that time. We load the body back into the truck in the same fashion, shut the tailgate, and tear out of there like wild Indians, just driving a racket. And I told him, I said, this is a federal refuge. There's no firearms supposed to be allowed down here. If they see us driving like this, we're going to be the suspects. So we slowed down.
Now, are those the exact words you used? Did you say it that calmly? This is the federal refuge, we will be suspects?
Of course not. I mean, that's,
What'd you say?
I mean, word for word, probably can't, you know, it's over 6 years ago, you know.
All right, but you told him to slow down.
Let him slow down, yeah.
I want it before we go any further about where you went, I want to back up a little bit. When you looked and saw and said nothing's coming, you said you turned around and saw Mr. Adams over Holly?
That's correct.
Your Honor, may this defendant come over here and demonstrate
Yes.
what he saw?
Yes.
Mr. Altry, would you,
Yes.
and come over here. I want you to stand here, facing the jury, and show them the position of Holly's body and where Zachary Adams was standing.
This is the riprap. The pile of riprap right there. We going. I set the body down with the upper torso inclined, like you would set, like this right here. When I was standing over here, Mr. Adams was standing at the upper torso at this fashion.
So he was
I
standing
could
up.
not see him. Yeah, I mean, it's pretty high vegetation.
All right, so you said he was standing here like this. You mean he was up on the riprap looking down on her?
That's
upper
correct, like this.
torso? All right. Did he have anything in his hand?
Yeah, the pistol.
Should you sit down?
When
What?
he got the pistol out of the truck, he got the pistol out of the truck before I ever went to here,
Right.
and didn't put it up over here.
So you loaded Holly back up in the white Nissan Frontier.
That's correct.
You told the jury to take off back down the road.
Back down this, come out this way right here, get back on this road right here, back on this little gravel here. We driving just erratic, just panic, just pretty much, right?
But what happens from there?
We travel back is, you want this back?
Not yet.
We travel back. We set a course back. I look at my cell phone and I told him, I said, man, I need to get to hell to Benton County and meet Angela for lunch.
When I asked you about your kind of routine with her, when you weren't working, was that part of the routine?
When I wasn't working, she expected me to be at Benton County Health Department for with lunch to spend with her through her lunch period.
She had, what, half an hour or so?
She had a half an hour. She wanted me to get her something to eat and meet her there.
Well, let's be honest, is that the only reason you wanted to get away at that point? You said,
No. When I realized, keep in mind, a few minutes before that, I had just shot one hell of a load of dope. And when I realized and heard the gun go off, I come pretty much to my senses. I realized that this old boy has made some bad mistakes, some bad judgments, and his ass was in a bind. And I was looking for a way to put some distance between me and that situation.
all right, so other than telling you to slow down so you guys didn't get caught on your way out of the refuge, did you have any discussion about what had just happened or what had happened before you got to Shane's trailer that morning?
I did. Approximately, just as briefly, I mean, after the most intense part of it got gone, I asked him, how did she get here? How did you know her? And he said that Natalie Bobo was working at a strip club at North 40, prostituting for drugs and stuff like that. She had been coming down there, fucking him, and left the idea that victim Bobo was going to be in a threesome with him. Been showing him pictures of her and stuff like that. He also said that the victim had been to his house before.
He said all this from the time y'all left, headed back.
That's correct.
Did he tell you how she ended up in the truck? Because that doesn't answer that question. How'd she end up wrapped up in a blanket in Zach Adams' truck?
Days later, he did. Not that day, it was days later.
Okay, so where did you go at that point?
We went back, I went back to the PT Cruiser and got back out. Got into the PT Cruiser, went to 641, realized that I didn't have enough time to make it to her lunch, and I sat north of Interstate 40, texting her through her lunch period. When I pulled out, Zach was pulling back in 30 Yellow Springs Road, which was Austin's.
So he dropped you off at your PT Cruiser?
Back at the PT Cruiser, where at that time I made an attempt to go to Benton County.
You said you came around, he was pulling in, so I don't understand.
He was pulling back in at 30 Yellow Springs Road, back where Dylan and Shane was.
All right. So he dropped you off at church, and then he goes back to Shane's.
That's correct.
And what's the distance from the church to Shane's?
Less than a mile.
When is the next time that you saw or spoke to Zach Adams that day, if you did?
At approximately 2:15, I established contact again.
Okay, that's mighty big words. I established contact. Who called whom?
I called.
Okay.
I initiated the call.
All right, tell the jury about it.
And I asked him,
I'm here, by the way, guys. I'm just putting together a bunch of different links that you guys have been sharing. Google Earth, a bunch of stuff. So give me I need 5 more minutes. Some more Jennifer for you guys. Shout out to the Dolly Talk community. Thank you for the raid. Also, I saw some gifts here from EDW Raptor. Let's get some, you have to type Rex. We don't have a raptor emoji. But we do have a Rex emoji. So let's get some Rexes in the chat. Thank you so much, EDW Raptor. Good to see you in this neck of the woods. Hope you are doing well.
was they together? Could I get another peel? And he said, yeah. That Dinsmore was over at Dottie's. Victor Dinsmore was over at Dottie's. We would run over there and get the peel. And I told him, I said, we're going to have to hurry up. I got to be back over here at the Quick Mart at 3:30. This was approximately 2:30 when I arrived back at 235 Adams Lane.
All right, so you called him, wanted more morphine.
That's correct.
All right. He said, okay, y'all were gonna go to Dottie's. Who's Dottie?
Dottie owns she owns a BP and Marine. Victor was working at her home,
Okay.
remodeling some cabinets,
All right.
I believe is what, don't take it that he was working in the home.
Okay. Was Zachary your connection to Victor Dinsmore? Is that why you?
I had 2 connections to Dinsmore. It was Zach and Shane.
Okay.
At that time, me and Dinsmore was not, I had never purchased nothing
He
directly
didn't
from
trust
him.
you.
And I was having to go secondhand to get the stuff.
So where did you meet back up with Zach?
235 Adams Lane,
And who lives there?
Mr. Adams.
And is there another house there at the top of the driveway, real close?
Grandpa.
And you had been over there before?
Yes, ma'am.
When you pulled up at Zach Adams' house that afternoon, you said around 2:30?
That's correct.
Who was there?
Shane, Dylan, and Zach were standing outside in front of Dylan's Silverado pickup.
Was the white Nissan Frontier there?
No,
So the car that you had been in, or the truck that you had driven with him to the bridge, it wasn't anywhere to be seen?
that's correct.
What did you see or hear?
When I pulled up, the air was just thick with animosity. You could tell that there had been some fighting and anger amongst them.
I'm going to object about any kind of speculation, Your Honor.
You can say what he observed.
Continue on.
You may.
We got in the truck. I got on the passenger side. Austin got in the middle. Mr. Adams got on the driver's seat. There wasn't a word said for just 30, 45 seconds.
Let me stop you. You talked about two Mr. Adams. Which Mr. Adams was in the driver's seat?
Zach, Dylan was in the back. It was an extended cab Chevrolet pickup.
So all three of y'all were in the front,
3 in the front, 1 in the back.
okay?
From Zach's house to Dottie's house, where we was headed, is less than 2 miles. I mean, you can be in there, and, I mean, it's less than 2 miles, probably 1.5 miles. I don't know exactly. We got in there and we pulled out of the driveway. Him and Shane started arguing.
Who's him?
Zach and Shane.
Okay.
We pulling in.
Arguing about what? Finish that thought.
Yeah. Well, Shane told him, he said, you didn't have to kill her. And Zach told him, said, you're just as damn guilty. You hit it. And Zach told him, said, you shut your fucking mouth. I'm sick of it being discussed. We're here. We pulled up. And he told him, he said, I'll whoop your goddamn ass. And they got out of the truck at Dottie's. And 1 lick was exchanged. Zach hit Shane. Dinsmore Dinsmore comes outside, and this unidentified lady and stops it. Well, Dinsmore comes out, and the fight stops. I look to my right, which is inside the carport, and there's this identified lady standing there. I didn't know who she was. They get back in the truck. Dinsmore walks up there. We purchased the pill. Dinsmore said, your wife said she spoke to you. And Zach said, I moved 4 rims in your shop to get my truck in. And he said, Jason's in a hurry. Train's in a hurry. He didn't call me Jason, he called me Train. He said, Train's in a hurry. We got to get him back over here and I'll talk to you later.
Did Dylan ever get out of the truck?
He never got out of the vehicle.
So let's back up a little bit about what the conversation between Zachary Adams and Victor Dinsmore. Who said something about somebody's wife?
Dinsmore said that his wife had spoke to Zach.
Okay. My wife spoke to you.
Yeah, my wife said she talked to you earlier today.
Okay.
Dinsmore said, yeah, I went over there and I moved four rims out of your shop and I pulled my truck in.
And who said that? Who said, I moved 4 rims?
Zach said I moved 4 rims out of your shop.
Right, you watch hitting the microphone because it makes a lot of
I-
buzz on you. I know you got some tight space there.
Well, I'm trying to talk in it and
I
be
know,
heard.
I know. So, you went there to get appeal. Did you get appeal?
I did.
Got a peel. All right, so I think I have my hot mess of links all together. So this might be a bumpy ride, but we're going to get through it, chat. We are going to look at, first and foremost, YP Kumshik said that there was a rule nisi filed in the civil forfeiture case for YSL. So hearing date is scheduled for January 6th. So I don't know if that will be something that there's a stream for, but I'm sure we'll see some type of order or update about that. So put that on your radar if you're following that. Thank you, YP. We have a few things to go through. So I think first I thought this was just interesting. DB sent this over. It's a SCOTUS case, but kind of an interesting issue. So this is Glossop v. Oklahoma. And, background story is Richard Glossop was sentenced for, let me move myself. Go back over here. To death for the 1997 murder of Barry Van Treese, the owner of the Oklahoma City motel where Glossop worked as a manager. Critical to Glossop's conviction was testimony from Justin Sneed, a handyman at the hotel, who told jurors that Glossop paid him $10,000 to kill Van Treese. After Glossop's conviction, he received information that Sneed had testified falsely about his mental health and whether he had seen a psychiatrist. Glossop asked the Oklahoma Court of Criminal Appeals to set aside his conviction, but the court rejected that request, and the state's Pardon and Parole Board turned down Glossop's request for clemency. All told, Glossop has spent 26 years behind bars, faced 9 execution dates, and had multiple independent investigations that raised serious doubts about his conviction. Ahead of his execution date of May 18, 2023, Glossop asked the Supreme Court to stay his execution and consider whether Oklahoma violated Glossop's constitutional rights when prosecutors suppressed evidence that their key witness was under a psychiatrist's care. The court granted his motion to stay and granted his petition as well. So the question is, may Oklahoma carry out the execution of Richard Glossop in light of the prosecutorial misconduct and other errors that affected his conviction and sentencing? So, quick decision here, 6-2. The court has jurisdiction to review the judgment of the Oklahoma Court of Criminal Appeals. The prosecution violated its constitutional obligation to correct false testimony. So I think what DB is getting at here, why this might be relevant, is this part here, right? We have a holding that the prosecution has an obligation to correct false testimony. So it goes on to explain further that the prosecution's failure, and I'm highlighting the whole page, sorry. The prosecutor's failure to correct false testimony violated the Due Process Clause under Nepew v. Illinois. A conviction that relies on false evidence, knowingly allowed by the prosecution, requires reversal if there is a reasonable likelihood that the falsehood affected the jury's judgment. Justice Sonia Sotomayor authored the 6-2 majority opinion of the court. The prosecution allowed its key witness, but remember, there is no key witness, Justin Sneed, to provide false testimony. And maybe this is why they're harping that they don't have a key witness over in the Zachary Adams trial. The prosecution allowed its key witness, Sneed, to provide false testimony about his mental health and medical treatment. The new evidence showed that Sneed was diagnosed with bipolar disorder and prescribed lithium, facts that were withheld from the defense. At trial, Sneed falsely claimed that he was never treated by a psychiatrist and received lithium mistakenly. This falsehood was material because Sneed's testimony was the only direct evidence implicating Glossop. An impeachment of his credibility would have influenced the jury's decision. The prosecution had prior knowledge of Sneed's mental health treatment and still failed to correct the misstatement when it was made to the jury. Correcting this false testimony would likely have changed the jury's assessment of Sneed's reliability. Additionally, the prosecution's violations extended beyond Nepew, so beyond this issue of not correcting this testimony. It suppressed exculpatory evidence, it interfered with witness testimony, and it allowed the destruction of key physical evidence. Seems pretty similar. Yeah, Sneed. I'm tripping up as I'm reading it. Sneed. And this makes me wonder, would the court have wanted to really weigh in on this? and come down with, whatever the majority opinion says in full, if this other stuff wasn't also happening. But when you pile the issues on, I think it's more compelling, the need to say something and address it. So, given these cumulative errors and their impact on the fairness of the trial, Glossop is entitled to a new trial. Oklahoma Court, what did I say? The Oklahoma? Oklahoma Court of Criminal Appeals rejection of the Attorney General's confession of error was based on a misapplication of federal law. And then Gorsuch didn't participate. That's the end of this summary. So, very interesting there, right? Duty to correct false testimony. And we saw Doug Bates asking questions that point in that direction during the post-conviction hearings. Can't wait to rewatch that. We're going to have to rewatch some Doug Bates on the 28th before the next hearing. So thank you, DB. Next we have, let's just do the let's start with the flooding. Let's start with the flooding, because I think I'm going to struggle with the flooding information. So DB sent over this, what looks like computer coding to me, because it's just nice plain font. Let me move myself because I'm blocking it. And it's all for this April, the month of April in 2011. And I don't know if this is like the cumulative measurement of rainfall for the year, maybe this column here. But whatever it is, they're warning that some of this data from the U.S. Geological Survey database may not have received director's approval. Any such data values are qualified as provisional and are subject to revision, right? So a bit important to know. I thought, although this is from a hobbyist site, I thought this was a bit easier to digest. So how do I get back to 2011? I did this the other day and now I'm forgetting. Historical. Well, maybe I'll put a pin in this. Maybe river summary? Because this is just an image. I swear there was a nice, easy way to just switch to what date I was looking at. Trends? Summary over year? Maybe it was this. Okay, yep, because they do give us the monthly breakdown. So this is what it was. All right, so if we go down to 2011, this is temperature. Where's rain? All right, so precipitation. 2011. Look at the month of April. It is like 1/5 of the rainfall for the total year falls in April. So that's just looking through the year 2011. And I can't easily highlight. I can draw. Can I make a shape because my drawing sucks? I'm just going to make a line. Follow the line here to April trends. We have April 2025 has a lot of rain. But other than that, the only other time we hit double digits is 2011. So when we hear like unprecedented rainfall, I mean, it's a comparison left and up and down here, both within the year, month to month, and year over year, comparing one April to another. So, oh, okay. And then DB says that was the water level. Fourth column was the water level on the other thing. Thank you. I grabbed that from the chat and just wrote rain level. But you did say in the chat water level, but in my notes I put rain level. So water level. Alrighty. And then let's see. And K Riggs also has the summary putting the rainfall into better context. So from in the Western Coastal Plain region, This spring, so April timeframe, was marked by extreme weather conditions. March was close to normal, but April and May had higher than normal temperatures and rainfall that reached record or near record levels throughout that region. The Mississippi River crested just inches below the all-time record flood levels at Memphis and caused major flooding throughout the western counties as tributaries backed up. Violent thunderstorms had adverse effects on birds and birders alike. Many traditional hotspots were flooded or access limited due to road closures. Shorebird numbers were very good, as were long-legged waders. So were the bridges... Does this help Jason Autry with his story of the birds hanging up in the raptures of the bridge? Oh, good times. But yeah, so this I think is important. Because I think it's very important, DB, that you pulled this data, like this report here. But in a bubble, I don't know the significance of what this water level at a specific place means over years, because there's nothing comparative. This is just looking at April as a snapshot in time. So put that with what K. Riggs sent over. That really boxes it in for me. That puts it all together. That gives me the context here. So DB also says, so that's why all the DNA is gone. Too much rain, too much rain. We've got, let's see. Yeah, DB says, think about how many times Bates gets on the record that there was false testimony. And then even if the state denies it, Bates then goes into things that were signs of it being false. Because there's no way that things can be true. I mean, you cannot reconcile those Dinsmore recordings. The next thing, we have a bit of... I'm going to share the topographical... I'm going to call it topo in the chat. I'll update the video description with links after I'm done streaming. I don't trust myself to multitask right now. I'll like accidentally end the stream or something. But I want to go over to this Google image stuff. So we're going to be looking at... Oh, come on. Load and play nice. It's a nice big blur right now. I clicked something before I switched over to you. Oh, because it went to 1985. That's what I must have clicked to go to 1985. So I believe there were different increments that just don't exist now. And the reason I say that is Kay Riggs had found a Facebook post, and it's kind of stupid if you ask me. But nevertheless, there was a post made on Facebook at the time of the trial, so we're talking 2017, and someone took the screenshot that appears to be like a Google image screenshot of Google Earth. And there's no date on it, but the Facebook post devolved into, I spy with my little eye, is this the white truck backed up, coincidentally. So this Facebook thread thought that this Google Earth image, that there's no indication that this was captured in 2011, actually kind of presuming it was captured towards the time of the trial. They see this truck and they're like, oh my gosh, is that the truck backed up to the riprap? And it got me wondering, like, like, did Jason Autry get Google Earth images before his testimony and start describing, like, he points with the laser pointer over here, but then he's also talking about this area here that looks like there's vegetation. But in the pictures he's showing at trial and in some of the historical Google Earth, there's no vegetation it's not green. And he's pointing over here with his laser pointer as well, this like little island that sticks out. So a lot of that was confusing. Kay Riggs really had me trying to figure it out. And if we go back to the historical images, 2010 is not very good quality. And you can see that that's the same pattern prior, working backwards. Maybe I should close some of my 700 tabs. But yeah, not very good. So it doesn't let me jump incrementally to 2011. I have to go between 2010 and 2012. But for what it's worth, this November image from 2012, everything is like just grayed out. And I know we're looking top down and that there's some blurring, but it does seem consistent with what I'd expect from an area that was completely washed away by historic flooding the year prior. So we've got all of this gray area. And that leads me back to my question from earlier, where wherever we're supposed to have this riprap, my take from Jason Autry's testimony, because he has a laser pointer over here, even though he's talking about like pulling up over here at some point. I think it's over here that he's talking about pulling the body out. But even if it was over here, how can it be true that they put Holly's body on the riprap and the vegetation was so tall that he couldn't see what Zach was doing? It just doesn't make sense. Where is the vegetation? Where is the vegetation that would obscure the vision from the taller of the two individuals? Jason Autry is very tall. From seeing someone who's, according to Jason's testimony, standing at an elevated position. So that alone makes his story wholly incredulous. Like, I'm not stupid. Like, I know I can't figure out and make sense of it, but I'm not going to buy what you're telling me. And anyway, if we jump forward, you can kind of see over time you get some green back. This is 2015. You're starting to get some green back. And oh no, there's another truck in the Google image. Maybe someone else was committing a crime that day. And then now we have, I don't know if this is when we're getting some raining again. This is a horrible quality photo, but in 2020 we have like this blurry, and maybe it's the quality of the photo, but it doesn't look like there's much green. And again, this would be February, so maybe just everything died for winter. And then we're back with November of 2021. We're starting to have some brighter green, taller shrubs. We're starting to have some vegetation peek out within some of the riprap. That like block of riprap is gone over here now in 2021. And then I think the critical point is you guys are mentioning like, hey, there's access roads to get here. And if there was significant flooding, would you have even been able to access this? Would the roads that are very close to the water level and don't have much riprap barrier be drivable? This was federal property. If there's a gate of access either over here that was already in place or over here that would be closed if the roads were not safe to drive, how would they have gotten through? And I just don't see how it can be reconciled. The other thing was during the testimony, and I don't know if I grabbed a screenshot of it, but when Jennifer Nichols is showing some imagery, it looks like she shows him a picture where she's like, somebody took the picture as if they were standing on the shoulder here and pointing their camera down to take a picture, because you can see the barrier, the structure in the photo, and it's like a downward angle as if the person's standing, like when you hold your arms over the barrier at the side of the road and take a photo taking an image downward. Jason Autry says that whatever they were doing wasn't visible from the road. Yet they have someone standing on the shoulder of the road taking a photo of the supposed area. Oh, they do have a Google Earth screenshot in that Facebook post where there's a boat on the water. And they're also saying that that was the boat. So, but yeah, pretty sure wouldn't it be something if that was taken exactly on April 13th of 2011. So, and again, not for nothing, but the quality in 2010 was butt cheeks. So I'm not sure if I would expect that this picture would have been from 2011. But who knows? Who knows? I'm open to hearing it. Open to hearing it. So next up we have, and shout out to Trial and Error Podcast. Let's do autopsy remains first. Open a new tab. Oh my gosh, can I not rotate it? Okay, guys, I can't rotate it. I should have rotated it before I uploaded it, but here we are. So I think this table is what we're working with. This is probably another case over here, because we don't have that stuff recovered. But that looks like that's similar to the image. Like if you were to move the skull over here, that's like that one exhibit we keep seeing. So kind of interesting to see. And remember, they took this all the way. I think they went Brent Booth and what was the other guy that they said went with Booth to take the remains all the way out here to this lab, according to the narrative for the report from the ME. So that's interesting to see. We've also got, you guys have heard about this, but let's pull it up. Let's pull it up. Autry's PT Cruiser. We're talking about his credibility. Look how this thing looks. This thing is torn up. What are we doing? What are we doing? And I believe the backing context is this came from like incident on the day where law enforcement was trying to apprehend him. I do forget the full context. But holy moly, that looks like not what I'd expect from the choir boy, the most credible witness, the most credible star witness that isn't a star witness that ever lived. What are we doing? What are we doing? And then the next thing, which is blowing my mind, which is why I left it for last. Lokong says, I mean, everything is fine over here. Says all PT Cruisers look like that. All right, so this one, you guys. February 7th. Let me zoom. No, let me go up. All right, so February 7th, 2013. And yes, Sheriff Chuck, no vertebrae, but all of those ribs. What was keeping the ribs close enough together to be found, but no vertebrae? That makes no sense to me. I don't know. To whom it may concern, to the best of my ability to remember. Blois Jackson Wallace, 82, died on December 2nd, 2007, at his home located at 106 Peggy Mullins Road, Parsons, Tennessee. I was appointed executrix of his estate per his wishes in his will. So the executrix is the female version. You're in charge of administrating somebody's estate when they passed away. I had called Mr. Wallace early afternoon on that Sunday, and there was no answer at his home. So she's retelling, this is being written in 2013, but she's retelling something that was happening back in 2007. There was no answer at Blois Wallace's home. Terry and Jan, who Jennifer Nichols can never remember Janet's name. She's such an insignificant character in this whole story, cannot remember Janet Britt's name. Terry and Jan were supposed to be there, but no one answered. Later that night, around 6 or 7 o'clock, they called and said he had died. I told them I had tried to call earlier to check on him, and there was no answer. They told me they had made a quick run, in quotes, to Walmart, and when they got back, they found him dead in the bathroom. I did not have a list of the inventory of his belongings, but according to his son, Edward Wallace, and his wife, Peggy, there was some type of handgun missing. So we have a handgun missing from Blois Wallace's house. At the time, she gave me the type of gun, but I don't remember now. I did not have a key or access code to the security system of Mr. Wallace's home, but Terry and Jan Britt did. According to Mr. Wallace, he had hired Terry to drive him places, and Jan cooked and helped around the house every day. So I talked with Jan about the gun and asked if they had seen the gun at the house. She told me that Mr. Wallace had given Terry the handgun as a gift. I told her the family wanted it returned. She again said it had been given to them. I relayed the message to Peggy, who had power of attorney for Edward, and she said that they wanted it back. I discussed the situation with Mr. Wallace's attorney, Mike Ivey, and he suggested that I go talk with the sheriff. I later went to the sheriff's office to ask what I should do. I don't remember if I talked to the sheriff or the deputy, but whomever I talked to told me to tell Terry and Jan that Terry had a felony record and that he could not be in possession of a firearm and to retrieve the gun, or that they would have to come and get it. I called and talked with Jan and told her what the sheriff's department had said. He knows that Jim enters the chat, Happily Angry Lawyer enters the chat, and all of a sudden we've got to deal with felon in possession of a firearm. So let's see. Calls and talks to Jan, tells her what the sheriff's department had said. Jan calls me back later and told me that they had gone back to the house and left the gun on a dresser in the bedroom. Somebody wants you to return something, you just go and leave it somewhere. You don't like meet up with the person that wants you to return it. You decide we're gonna go and put it somewhere and then call you and say we left it there. Now, we didn't work that out in advance. It's not like this says we agreed that next time she went over to the property, which I don't know why she'd still have to be there, she would just drop it off. This is just, that was sua sponte. That is what Janet and Terry Britt decided to go do. With a firearm. I called Peggy and told her that they said it was left on the dresser. Edward, Peggy, and Mr. Wallace's granddaughter said they searched all over the house and did not find the gun. Is anybody surprised? Yeah, Kinsey, shout out to Kinsey, the intern says, make it make sense. I can't. I don't think I can. So they don't find this gun. I called Jan back, or whatever her name is, and she said she didn't know what happened to it, but still insisted that they had left it on the dresser. I'm not sure of the exact time, but this is as close as I can remember. And this is signed here. This is Rhonda Mitchell, again, February 7th of 2013. So we've got this other thing. This is going to be from Ricky Inman. We heard his name a few times. And now I really want to go back and single out any references where Doug Bates was asking about Ricky Inman. But we have here from the Decatur County Sheriff's Office. This is a write-up from Ricky Inman. It says Rhonda Mitchell said that she handled the estate for Boyce Wallace. She said that Terry Britt and Janet Britt were the ones that found Mr. Wallace deceased in his home. Rhonda said that Terry Britt said that he and Janet had left Mr. Wallace's home and went to Walmart, and when they came back, Mr. Wallace had died. Now, I know it's not that weird, like someone could go to a store and this could genuinely happen, but it's adding to the stories that we're hearing. Terry and or Janet Britt are, something weird is going on, and it just seems like they always have, oh, we were at a store, see, we're going to have a receipt to show you. And just very coincidental. Cumulative coincidence. And when they came back, Mr. Wallace had died. Rhonda said that Mr. Wallace had a lot of guns and that Peggy Wallace and her daughter had taken a lot of them with them, but Terry Britt had one of the handguns that the family wanted back. Rhonda said that Terry and Janet said that they had taken the gun back to the residence of Mr. Wallace and left it, and they did not have it anymore. Oh. Rhonda said that she came to the sheriff, Roy Wyatt, and gave him the information about the gun, that Terry had the gun. Rhonda said that the sheriff told her to tell Terry to give the gun back. She also said that and this is just so weird to me, like, I'm so used to these bloodthirsty law enforcement officers that if you tell them that somebody has a firearm and they're a felon and they're not supposed to be in possession of that firearm, oh, they're going to look at it as a chance to yoke somebody up. But here the sheriff's like, lady, here's what you do. I'm the sheriff. You're a regular lady. You go handle business on your own. You go confront somebody and tell them, give the gun back. Go confront a felon and tell them to give this gun back that while they're telling you somebody gave them as a gift, there's reason to believe that's not a credible excuse. But just go as a regular person, go confront this person and be like, felon, give me that firearm. Like, it doesn't make sense. It doesn't make sense. Rhonda said that Terry and Janet would stay with Mr. Wallace at times. Oh, wait, I missed a line. Rhonda said that the sheriff told her to tell Terry to give the gun back. She also said that she could not remember what kind of gun it was now. Rhonda said that Terry and Janet would stay with Mr. Wallace at times and would drive him places that he wanted to go. Rhonda said that at the time she knew of Terry, that he had a ponytail in 2008. Rhonda said that she knew Janet from the news leader, that Janet went to work there when Danny bought, this is brought, but it's probably bought, the news leader. Rhonda said that she worked for the Jason Scott when he owned it. Talked with Sheriff Roy Wyatt on February 3rd. So Ricky Inman is saying, well, according to Rhonda, she talked to Sheriff on February 3rd, 2012. And this is why this is crazy to me. Because if she's trying to recover a firearm and the Brits are saying, yeah, we left it on the shelf for you, if they don't have it to return, is there a reason that by 2012 they don't want to return a firearm? Maybe they can't because they already had to get rid of it for another reason. Maybe they can't because they know it would be hot. But so Ricky Inman goes and talks to Sheriff Roy Wyatt, and he says that he does not remember talking to Rhonda Mitchell about the gun or Terry Britt. Blois. Wait, the full name was Blois Jackson Wallace. Yeah, so I don't know why it's written as Boyce Wallace up there. But over here it says Blois Jackson Wallace. So, oh my goodness. Some additional context. Let me make sure I get this contextualized. If that wasn't enough on its own to make you raise your eyebrow, we've got, let's see. All right, so the date that Inman talked to her and the date the letter was received was February 2012 and then 2013. Then the same week Zach was arrested, so jump to 2014. Those computers from Decatur County Sheriff's Department were cleared. There's no record in their system of Rhonda Mitchell's call to Roy Wyatt. She says she remembers making a police report. Now, I have a bit of a suspicion here. What were we reading earlier today, chat? Maybe, and maybe not. Maybe not. But in this motion to dismiss earlier, this very oddly short paragraph where we don't want to get into the specifics of anything. Let's see. Right here. Like, none of this stuff, just like whatever this is, the state is very careful to never let any of this stuff become part of the public record, public access. And what else did we see today? Where is the letter that K. Riggs screenshotted the discussion about? Let me pull that up. And we'll run it back. We'll run it back for good times. So Jennifer Nichols says, I would like to have a hearing on the relevance, but I don't want it on television. This is a sidebar. Because this is a letter from Jason Autry to Ms. Thompson, Zachary Adams' defense attorney, praising the Lord for the representation of Mr. Adams, saying that Jennifer Nichols is a hired assassin, and talking about somebody I have sitting on death row from 2011 that's fixing to be overturned because I forged documents. All of which, of course, is not the court. That's not relevant to this trial. Ms. Thompson, it is relevant, Your Honor. The court, wait. Then Jennifer Nichols says, before we go any further, I don't believe it's relevant, but if it's determined to be relevant, that's one thing. But if the court thinks it's not relevant, I would prefer that kind of thing not be out there because it has absolutely no bearing on this case. So we don't want the public to be aware of any of this stuff. Like, I think it's more likely than not. I think it's easier to believe that they wanted to get rid of any record of this conversation with Sheriff Roy Wyatt, just based on the way the state and law enforcement seem to be approaching everything else that they don't think is good for them. There is no transparency. The only time we get to hear things and that the state is willing to spell it out is when they can say things like, here's the mountains of evidence of a jailhouse snitch saying what they heard Zachary Adams supposedly say. Then they're going to spell that out in detail. It's the only time. It's the only time. So, but yeah, they're pissing me off. They're working up my patience here. With that being said, guys, let's get back to these motions. Thank you guys, everybody, that all of those little pieces of information, like, again, it just gets crazier and crazier the more you learn about it. But it's cool that everybody's here, like, trying to figure it out together. I don't even know where we were. We were in the response somewhere in the petition, right? Let's see. I think we were on section B of this, and I scrolled a little bit when I walked away from the computer. All right, so we are back to, again, the state's reply to Zachary Adams' response to their motion to dismiss, but the response to the motion to dismiss isn't part of this little docket thing. And we're on this. So even if Jason Autry's statements from the December 22nd, 2023 video interview were in the form of sworn affidavit, his statements are cumulative. Newly discovered evidence that is merely cumulative or serves no other purpose than to contradict or impeach does not warrant quorum nobis relief. When impeachment or cumulative evidence does not establish grounds for showing that it may have resulted in a different judgment, it cannot serve as the basis of relief. Petitioner Adams' response unfortunately misconstrues the state's position as to cumulative evidence in the context of a quorum nobis proceeding. To clarify in the simplest terms, Jason Autry denied any involvement in Holly Bobo's disappearance, rape, and murder until roughly January 2017. Yeah, what happened in January 2017? At trial, Jason Autry acknowledged that he previously denied any involvement in Holly Bobo's disappearance, rape, and murder, and was thoroughly cross-examined by defense counsel on this issue. Jennifer Thompson confronted Jason Autry with example after example of his previous denials. In his December 22nd, 2023 video interview, Jason Autry once again claimed that he wasn't involved in Holly Bobo's disappearance, rape, and murder. Jason Autry's video interview is merely cumulative to the evidence and arguments already presented to the fact-finding jury at trial. Yeah, I don't agree with that, but okay. Like, I know that the recanting isn't coming in because it's not, like, sworn under oath and Jason Autry didn't show up to these proceedings. But the argument that it was cumulative, there were things discussed in that even if Jennifer Thompson had a stronger trial strategy, that she wouldn't have been able to ask about. And the jury could have reached a different conclusion just based off that recanting statement. Or things that were said in that recanting statement, if it was in front of a jury. Not only is Jason Autry's video interview not newly discovered evidence, but any potentially useful statement from Jason Autry have already been elicited by Petitioner Adams' trial counsel during his cross-examination at trial, and argued to the jury during closing. So now we're going to get transcripts from Jennifer Thompson. So we've got, and so Jason Autry was able to sell his death penalty to the government for a tall tale. And what that means is he's arrested in the spring of 2014 on this crime, and he had years and years. He had 3 years to sit from 2014 until January of 2017 to sit and perfect his story so that he could finally sell it to the government. This is a misstep because this is so ineffective assistance of counsel or missing a confrontation, because it's not the 2014 to 2016 time period. It's specifically November of 2016. And maybe if you want to take it back to the notice of aggravating factors being filed in June of 2015. But this is incorrect. This is incorrect. This is not a good argument, because he wasn't changing his story or trying to concoct a story by anybody's evidence or testimony or arguments in 2014. I think everybody agrees he was walking around saying innocent man walking. So she's missing the argument that she's saying in closing arguments, that he maintained his innocence until November 2016 when suddenly he gets his discovery folder. Then we have more from closing arguments. So let's talk about Jason Autry and some of what he did. And as you can see, Jason Autry, and it's weird. They make it seem like this is separate. Maybe there's some sentences in between, but it goes from line 6 through 11 and then 6, 12, and 19. And to me, that kind of makes it seem like 2 different points in time, but this is really the same thought all in one. So let's talk about Jason Autry and some of what he did. And as you can see, Jason Autry, he's trying to come across, sitting up here on the witness stand as we looked at him, he comes across as all, shucks, I'm just a good old boy and just trying to do the right thing, and I was lying when I said I was innocent, and now I've come to you and told the truth. The other thing he says, and now this is jumping ahead 3 pages in the transcript, the thing to keep in mind also is that when Jason is developing his story, he has access to the discovery. Okay, that's important. And that's the evidence in this case. Now we jump another page ahead. Well, remember, Jason Autry had access to all the evidence in the case. And then we jump ahead a few lines, if you think about it, and I'll try to go through some of it as we go along. And remember, this was like, I feel like this was like 20 minutes into her closing argument. She's saying, I'll try to go through some of it as we go along, but she's already been going for 20 minutes and she's been talking about Jason Autry for like 10 at this point. But a lot of the, quote, evidence that Jason Autry talks about, the things that he's using that are going to bolster his story, are things and information that would have been available to him as he was going through the evidence. Now, this might sound like something I'm arguing here, but I'm only arguing it with a timeline. I'm not saying that this was, he's sitting from 2014 to 2017 to perfect his story. That's not going to make the same point to a jury. Let's see. And then several pages ahead, but Jason Autry was very well coached when he was giving his story, because 3 times he used the word allegedly. If you're really telling a story about what you saw, you would never use the word allegedly. And then we're back to the argument. These trial transcript excerpts, coupled with Jennifer Thompson's thorough cross-examination of Jason Autry's previous denials of involvement, set forth in the state's motion to dismiss, pages 12 through 14, demonstrate that Autry's trial testimony was attacked and impeached through the jury trial. Simply put, Petitioner Adams is not seeking to bring new evidence before this court that might have an effect on the judgment. Jason Autry's denials of involvement in Holly Bobo's disappearance, rape, and murder were already litigated and at length. As such, Petitioner Adams' Coram Nobis petition does not contain a cognizable claim. So, apparently that's Jennifer Thompson fully fleshing out all of the considerations that the jury would have had to consider, hey, maybe Autry's not credible. So, and O'Bailey, thank you, with the update here, it says Kelsey Fitzsimmons has been granted bail. So that was pretty swift, right? Because I think a higher court said, hey, you know, not really an issue that we can decide, but we can say that, hey, if there's been a change in circumstances where the lower court, like the magistrate court, could reconsider or consider information that was unavailable before. I know that could warrant a reconsideration of bail. And the point being, so Kelsey Fitzsimmons was shot in a way that she's dealing with lung issues. And one of the terms of release would have been, all right, we think that you meet the factors to be granted release, pretrial release. But one of the conditions would be you submit to breathalyzer tests. But she couldn't blow while she was healing because she got shot in or around the lung area. And now she's had some time to recover, and I believe now that she can actually commit to those terms, is that the process, factual Lyle Bailey's? She was able to tell the court, hey, there's been a change. I can now provide these whatever cadence of testing. And they're like, okay, they grant the bail. I'm pretty sure that's probably the issue that was argued this morning. That's pretty cool to hear. And then we've got, let's see, different conclusion. To demonstrate that Jason Autry's testimony was only a part of the state's substantial proof of Petitioner Adams' guilt, the state's motion to dismiss identified numerous witnesses at trial who testified that Petitioner Adams made incriminating admissions about his involvement in the victim's kidnapping, rape, and murder, along with multiple items of physical evidence that linked Adams to these crimes. In his response, and this is like really the little bit of context that we're going to get, Petitioner Adams focuses on attacking the credibility of these trial witnesses, characterizing them as circumstantial, unrecorded, subjective, immunity agreement laden, and otherwise impeachable and or unreliable. I mean, I agree with each and every one of those characterizations, at least as it would pertain to different witnesses. Any attempts by either party to discredit trial witness testimony outside the established post-conviction procedures is inappropriate as the fact-finding jurors who heard the proof and rendered a verdict. I wish we could see Zach Adams' response, because I feel like the argument would have been framed more of, we're not attacking the jury's presumed assessment of a particular side story witness. We're arguing that Jason Autry was the key witness. He was the only one that gave direct testimony with firsthand knowledge of witnessing these crimes occur. And he's such an integral part of this case, because he's the only one with the direct evidence, that if you remove him, the jury might not see that the other witnesses were enough. And that's a different argument than just, hey, we think Zach Adams needs a new trial because Statler wasn't reliable. Or, hey, we want you to grant this writ because we think Corey Rivers was unreliable. The argument is more, if you take away the key witness that has the direct knowledge, why would Jason Autry incriminate himself on the stand? The jury might not have given the same type of weight to these other witnesses because none of them offered direct information. So, oh yeah, All Eyes on Delphi says, did he really say allegedly on the stand while giving his testimony? A few times. He also said, I didn't have time to rehearse, repeat word for word. He said a lot of an unidentified woman, the victim, Miss Bobo. Like, he used a lot of language that seemed like he'd been reading a lot of the reports, the investigative reports available in his discovery. So, yeah, and if your records reflect that. We should do like a montage compilation of Jennifer Nichols answering during the PCR and the way Autry would answer, and then put like the quote argument. Oh my goodness, what a time. That reminds me, I'm always going to look for the excuse to play this. This little like 2-day trial or 3-day trial was the Ogletree trial. Dolly Talk and Hella were watching it. I love this clip because this witness gets on the stand and just says, this is how I knew what to say today. It's not my own firsthand knowledge.
And you said it's been so long since you saw the video. No, I just seen a video the other day. I just seen
Who showed you the video?
the prosecuting attorney. That's how I know what to say today, because I just saying what I got on camera. And that's the only thing I did.
I got you.
So, I mean, you know, it happens. And I think it happened in a big way with a star witness in this case. Oh, my goodness. Just a time. Shout out to Dolly and to Hella. Let's see. Where am I? I don't remember where I was. He's attacking the credibility of these witnesses, and it's inappropriate. The 12 jurors, we heard Amy Wyrick yelling, and you know, I almost forgot about Amy Wyrick as we were going through watching the blocks of testimony. I almost forgot how much she was yelling during like the opening statements in the first few sets of witnesses. Because Jennifer Nichols, her behavior when she was testifying on the stand just so far overshadows the demeanor of Amy Wyrick during the PCR. And I think that's such a high level to reach. Yeah, Australia is not a real place. Oh my goodness. Crazy. And all eyes on Delphi. I mean, you probably know the drill. You got to watch things at least 3 times. Just keep watching it. Be crazy. Here I am watching trial testimony for the 4th time. I'll see factual lie pop in, DV will pop in, and we're watching the same thing like 3 times. And every time there's something new. Yeah, the Dylan with his shirt off story was another one. So they're going to cite here, we have in a quorum nobis proceeding, got section 40-26-105. We have it explicitly identified the subject matter to be litigated by the parties under a quorum nobis. The relief obtainable by this proceeding shall be confined to errors dehors the record. What does dehors mean? Other than. All right, so errors other than or outside the record into matters that were not or could not have been litigated on the trial of the case, on a motion for a new trial, on appeal in the nature of a writ of error, on writ of error, or in a habeas corpus proceeding. Upon a showing by the defendant that the defendant was without fault in failing to present certain evidence at the proper time, a writ of error quorum nobis will lie for subsequently or newly discovered evidence relating to matters which were litigated at the trial if the judge determines that such evidence may have resulted in a different judgment had it been presented at trial. Trial witness credibility is within the province of the fact finder jury, which must assess the weight and the proof in light of the applicable law and arrive at a verdict of guilt or acquittal. And I really wish we could see Zach's response, because I don't think this was just a standalone argument. You know, we want a new trial because the jailhouse witnesses aren't credible. No, I think they wanted a new trial because Zachary Adams didn't have available to him what he would needed to have available to properly cross-examine Jason Autry and show that his testimony was false, and that without his testimony, you would only have these 12. And it's a very different question. I know I said it 5 minutes ago, but the state can't just assume that the jury would reach the same conclusion, undoubtedly, with just the jailhouse witnesses. You're removing a star witness, the only direct testimony of Holly Bobo getting, pulled, taken to this river area, getting shot, saying that we need to get rid of this body. You wouldn't have that, and that's major, major testimony. Oh, that's really sad. Tatum says Melody, that's so sad. They just found the body of Melody Buzzard. Well, they got her mom. They arrested mom. Horrible for holiday season. That's really sad. That's another one to watch, I think. There's some weird stuff. Like, that one seems odd. Mom seems odd in that case. Maybe it wasn't her, but it's one of those things that's just kind of like, you're moving a little weird. You're moving a little sus. All right, so trial witness credibility, we're down here. The Coram Nobis Court cannot reweigh or reevaluate the trial evidence and questions regarding the credibility of witnesses and the weight and the value to be given the evidence are resolved by the trier of fact. So this is why we heard Amy Wyrick screaming about the jury in her openings. I really think she's missing the argument that Doug Bates was making. And I don't think she doesn't understand the argument that was being made. I think she's pretending she doesn't get it so she can address it as if she's only addressing a different argument, a weaker argument, and hoping that the court will foolishly just jump to match the way she's reframing the Doug Bates argument. Petitioner Adams cannot go outside of the record and reweigh and reevaluate the trial evidence and substitute his opinion for that of the fact-finding jury. To reiterate, Petitioner Adams' own admissions to multiple individuals concerning his involvement in the disappearance, rape, and murder of the Holly Bobo are the most incriminating pieces of evidence the state of Tennessee presented at trial. So they're arguing here, they're really making the argument that the most incriminating pieces of evidence, they're deciding for the jury. They're saying that Doug can't assert his opinion, substitute his opinion. But they're asserting here, they're saying to reiterate that the jury determined that these statements were the most incriminating pieces of evidence. So their opinion's fine. His admissions came from his own mouth, not anyone else, including co-defendant Jason Autry. Mr. Autry's alleged recantation, in quotes, does not exculpate Petitioner Adams, and he cannot show actual innocence, which in plain language means nothing other than that the person did not commit the crime. So conclusion, for the reasons stated in the state's motion to dismiss and this reply, this court should summarily dismiss Petitioner Adams' Coram Nobis petition without an evidentiary hearing for failing to allege specific facts showing entitlement to equitable tolling, and or alternatively, because the information contained in the petition is not newly discovered evidence. So there you got Jennifer's signature. And back to our little informal docket. Next, on June 20th, 2024, we have the notice to remove the state of Tennessee's motion to issue subpoena to Katie Spirko and issue protective order from docket. So, comes now the state of Tennessee, by and through undersigned counsel, to provide notice to the Hardin County Circuit Court clerk that the state's motion to issue subpoena to Katie Spirko and issue protective order will be removed from this court's docket. So, and we've got Chris Boiano signing this one. Next up, all right, state of Tennessee's post-hearing request to the court's request for additional information. Or post-hearing response to the court's request for additional information. So court wants to hear more. Uh-oh. Uh-oh. So this is back this was filed on the 21st of June in 2024. Crazy. You said this so much better than I did, Sheriff Chuck. I said it in it took me 5 minutes. Sheriff Chuck's like, she's trying to reframe so she can mislead the court to address her reframing of the argument. Nice and succinct. We've got, comes now the state of Tennessee by and through undersigned counsel to file this response to the court's request. So I don't see that filed here, but apparently on June 14th, the court filed a request. Maybe it was not in writing, maybe it was at the hearing orally, for further information on whether the unsworn statements attributed to Lisa Sanders in paragraph 7 of the petition for writ of error Coram Nobis were reported to the TBI tip hotline. Oh, I wish we could watch this. Because I just feel like this is the first time that they've had to deal with a judge in this case pumping the brakes and say, hold on, well, tell me more about what the defense, the petitioner, is saying. Did TBI know about this? Because that's your responsibility. If they knew about this, that's on you. I wish we could watch this hearing where the judge, I can picture Judge Bradbury saying, Well, was this reported to the TBI tip hotline? So let's see. This is where we're going to hear about, oh, there were so many documents, so many leads. The state would state as follows. TBI's tracking of leads. Initially, a virtual command center, VCC, leads management system, was utilized to track leads concerning Holly Bobo. The VCC is an FBI database that allows leads to be easily entered and updated in an Excel spreadsheet format. So they're saying this was initially? Initially when? They're going to lay it out for us? This system is organized to track what has been done and what needs to be done. The layout consists of one spreadsheet that shows all leads, who cleared each lead, any follow-up needed, and when the lead was closed. The first VCC was open from the date of the abduction, so April 3rd, 2011, through April 28th, 2012. Why the gap? Why the gap? Why the gap? You guys remember the news coverage? How there was like a super gap in news coverage between like this timing, 2012, for like a year and a half? Yeah, Dr. Katie Sapirko. So anyway, they say the second VCC was open from February 26, 2014 through May 9th, 2014. Are you serious? Do I need to update the timeline? So they reopened this. You're lying. So they get this call. So Jason Kilzer, Dylan Adams are picked up on those federal gun charges. By January 2014, Sheila Kilzer, Jason's mom, is calling Brent Booth like, hey, I've got some information to give you from 6 to 7 months ago. And then we're going to find out that even though this VCC tracking database, they're not using this like efficient database tracking system for almost 2 years, they reopen it on February 26th. Second VCC opened. And I'll put the first one up here. We'll just go back. They said it closed when? April 28th, 2012. And I should specify what this is for anyone that isn't going to see this specific motion. Virtual Command Center Leads Management. All right, so then they reopen this February 26th. So February 6th, Booth goes and meets with Victor Dinsmore for the first time. 10 days later, they open the second VCC. 2 days later, TBI Director Mark Gwynn announces search warrants are issued. Are you kidding me? Are you kidding me? Are you kidding me? So 2 days after Dinsmore, we open up this second VCC again. And we close it as soon as we've got everybody arrested. We might as well put that in the timeline. And then we'll get back to reading these motions. We're making good progress, chat. So May 9th, 2014. Closing up shop. Closed. All right. So we've updated the timeline. That is wild. That is wild. So the second VC was open from February 26, 2014 through May 9th, 2014. Leads continued to come in at a lesser volume after each VCC was closed. How much of a comparison is that if you only have 2 opens and closed? The sample size is 2. And if you're only comparing 2 things, there's only 1 difference. So what do you mean leads continued to come in at a lesser volume after each VCC was closed? What are you comparing this to? They say, however, tips came in a variety of ways. TBI used the following system to track, organize, and verify leads during this investigation. So 1, phone calls arrived at the hotline, the tip line 1-800-TBI find. Only 1-800 number established during this investigation to receive tips. And emailed to tips@tbi at tn.gov. Tips were then recorded in the VCC and assigned to be investigated by agents. A physical lead sheet was created and given to the agent, or an email of lead/tip was sent to an agent from analysts in the Fusion Center, TIES, TIES, or other intelligence areas at TBI headquarters. If a new lead was then generated as a result of the first lead, it would be assigned a new lead number, recorded into the VCC, and then assigned/worked/resolved. Okay. Each lead would be worked until a resolution was reached. The resolution of the lead would then be documented in the VCC. Some leads were reported directly to TBI agents or law enforcement agencies outside of TBI. Like who? Like who? Does that include retired members of a law enforcement agency? When this occurred, a lead sheet was created and a new lead number was assigned and recorded in the VCC. An agent worked to resolve each lead and the resolution was recorded in the VCC. After the VCC was closed, tips continued to come in through the above listed means. However, no lead management system was used. No matter how the tips came in, they were forwarded to the investigative team for assignment to be worked, resolved, and documented in an investigative report. I don't know if I believe this. They say all leads worked were documented in the master case file. I don't know. And I'm thinking of Kathy Ferguson's testimony where she's like, this was a hot mess. We don't know. There was just so much going on. But now that they're being pressed to address the specific issue of the statement from Lisa, they're like, it's a leak-proof system. We've got it down to a T. We document everything. Everything has an assigned number. It goes to somebody that's going to work the lead. There's always a disposition and everything's always documented. Because there's no way that Lisa could be telling the truth that she sent in a tip to TBI. Because if she did, it's in our system. And we'd have to admit that we didn't disclose that to Zachary Adams at the time of his trial. So now everything, this is so contradictory to Kathy Ferguson's testimony. Yeah. All leads were documented, but, we don't take any notes or documentation or anything discoverable for the 3-day proffer session between Jason Autry and the state. Oh, my goodness. This is wild, and I cannot get over that time frame that they really reopened it after talking. I'm not surprised. I think I'm surprised that they didn't try to mush up their timeline a little bit better. See, if Terry Britt's out here finding ways to come across firearms, he's finding a way to get a firearm in like 2007 and then have no idea where it is in 2012 or 2013. That's enough time to create some distance where people might not notice and say, hey, if you do something sus and illegal with that gun, even if they find the gun, nobody would be able to pinpoint and identify unless they pull a Jason Autry or Dinsmore and say, that's the gun. Terry Britt is smarter than these people. So anyway, they document everything. Most leads have been documented multiple times. Oh, we're so good at documenting, we document leads multiple times. But okay. Why? That doesn't sound like good record keeping. you don't really want to have duplicate leads. But they're so insistent on trying to prove how good they are at documenting things that they think it's a good thing, and they're going to brag about documenting the same lead multiple times. So surely we didn't miss anything from Lisa. They say, for example, the second VCC was closed in May 2014. IR number 2537 references the closure, and the VCC spreadsheet is an attachment to that IR. The VCC spreadsheet was also on a CD, and a copy of that CD was provided as part of the discovery. So here we are, we're laying it out that we document everything, we document it multiple times, and we provided it. So there is no new evidence that warrants the court granting this writ of quorum nobis. Additionally, each lead from that VCC that involved an agent investigating the lead would have been documented in a separate IR. Interestingly, we had Terry Dykes. This makes his testimony more critical. Terry Dykes saying, the process is, as the agent, we write up like a draft version of what's going to become an IR. But it's actually like the lead case, not the lead case agent, the SA, special agent something in charge, special agent in charge. Like the supervisor of Terry Dykes is the one that would actually put it in and generate the official IR. And we have testimony on the record from these evidentiary hearings that, hey, I was investigating a lead and I wrote up everything that I was supposed to, and I gave it to, SAC. And I forget who it was at the time. Maybe it was Jack Van Hoosier. And it just never became an IR, and I don't know why. It never made it as a published report. So Doug has some very critical testimony contradicting this claim here. Lisa Sanders. In his petition for writ of error quorum nobis, Petitioner Adams alleges that Lisa Sanders can proffer testimony that amounts to newly discovered evidence. Furthermore, Petitioner Adams' petition alleges that Lisa Sanders told a friend named Bonnie Ham about the events set forth in paragraph 7, who then purportedly reported this information to law enforcement by calling the TBI hotline. Based on this court's inquiry into whether Bonnie Ham, in fact, called the TBI hotline and reported Lisa Sanders' allegations, the undersigned counsel instructed TBI to search VCC spreadsheets. The resulting search of the VCC spreadsheets concluded there is no record of Bonnie Ham calling the TBI hotline. So we've got argument. The state has previously set forth in its motion to dismiss and reply legal arguments questioning the validity and reliability of the statements attributed to Lisa Sanders and Jason Autry in the context of quorum nobis proceeding. The state incorporates those same arguments into this post-hearing response. Petitioner Adams has already conceded that his quorum nobis petition was not filed promptly within the statute of limitations. Therefore, this petition would have to contain facts to support equitable tolling of the statute of limitations to avoid being summarily dismissed. We're going to skip some of this. It's the same thing. Equitable tolling. It's got to be new grounds. It's got to impact the trial. Due process tolling is not warranted based on Lisa Sanders' unsworn statements. The reliability of any unsworn witness statement should be of concern to this court, especially considering Nunley's affidavit requirements in a quorum nobis proceeding. Furthermore, the petition's factual allegations attributed to Lisa Sanders are not new evidence of Petitioner Adams' actual innocence. The events described by Sanders fail to allege why Sanders observing a man driving a truck miles away from the crime scene. This is the type of thing that if it worked in the state's favor, they would think that this was a strong argument. But because it doesn't help them, they're like, it's a stretch. It's so far of a reach. So it's argued that Petitioner Adams is innocent. Likewise, his petition fails to state when Lisa Sanders' unsworn statements were obtained and why such evidence justifies equitable tolling. As established in Nunley, equitable tolling claims must be specifically pled in a quorum nobis petition. The petition fails to state a single piece of evidence that demonstrates actual evidence. Lisa Sanders' statements themselves are suspect. Sanders gives a general description of a man in a trunk that she indicated she was able to identify 4 years later. Well, that sounds like Clenny's testimony. Not Courtney Clenny. The other lady Clenny. So in conclusion, state wants the court to dismiss Petitioner Adams' Coram Nobis petition without an evidentiary hearing for being time barred for failing to allege specific facts showing entitlement to equitable tolling, and or alternatively because the information contained in the petition is not newly discovered evidence. Ultimately, Petitioner Adams cannot show actual innocence and is not entitled to relief from this court. So there's Jennifer signing off. And all right, so we have correspondence from Boyano to Tammy Wolf on June 21st, 2024. Doug Bates' email is dtbates4. Love it. So I'm sending the state, good afternoon. I'm sending the state of Tennessee's response, post-hearing response to the court request for additional information to this email. Can we have a stamp filed copy emailed back to us? Best, and it's Boyano. Why are we attaching this? Just to show that we emailed it? Okay. Just digital service receipt, I guess. All right, next we've got okay, this is all the way in July. This is all the way in July. So this is July 19th, 2024. State supplemental authority in support of motion to dismiss the petition or writ of error coram nobis without an evidentiary hearing. Is this because they asked for like a stay or whatever earlier? When was that? Okay, the agreed order was signed on June 4th, so that makes sense. So now they're filing the supplement. All right, so let's see. They're asking the court to consider additional recent authority. Thomas Edward Clardy versus State of Tennessee, which was decided June 25th, 2024, authored by Chief Justice Holly Kirby and issued on June 25th, 2024, which addresses the critical issue at bar and is submitted herewith in support of the state's motion to dismiss. The Clardy court reviewed the extensive case law on the issue, which was cited by the state in its motion to dismiss. The Supreme Court of Tennessee noted that we have not, however, elaborated on the standard of proof in coram nobis cases to support a decision to toll the statute of limitations. This case allows us to do so. Inasmuch as Petitioner Adams is seeking such relief in his petition for writ of coram nobis, specifically, tolling the statute of limitations because of alleged newly discovered evidence and untimely granting him a new trial, the Clardy opinion goes to the heart of the state's motion to dismiss. Clardy provides additional support to the argument set forth in the state's motion to dismiss and argued before this honorable court on June 21st, 2024. Still further, the state submits that the mandates set forth in Clardy make that which was clear in Nunley v. State, that Petitioner Adams' writ should be dismissed without an evidentiary hearing, crystal clear. So, underlying facts in Clardy. Thomas Edward Clardy filed his petition for a writ of error coram nobis many years. And what's the right way to spell this? Because it keeps switching between coram with the U and coram with an A. So, he filed many years after the expiration of the statute of limitations. Petitioner Clardy asked the court to toll the statute under the Workman v. State tolling exception adopted by the Tennessee Supreme Court. After hearing on the tolling issue, the coram nobis court in Clardy dismissed the petition as untimely. The court ruled that the new evidence did not show that Petitioner was actually innocent of the crimes of which he was convicted, thus not entitled to the tolling on the statute of limitations. The Court of Criminal Appeals subsequently reversed the coram nobis court on the untimeliness issue and remanded it for a hearing on the allegations of the petition. On appeal, Tennessee's Supreme Court reversed the Criminal Court of Appeals, reinstating the coram nobis court's ruling and elaborated on the standard of proof required to support a decision to toll the statute of limitations. In fact, the court said the coram nobis court's procedure and analysis was spot on. Because the Tennessee Supreme Court found that the procedure and analysis of the Coram Nobis Court was spot on, it is appropriate for the state to begin with the standard explicitly set forth in Clardy with respect to tolling and newly discovered evidence that demonstrates actual innocence. And I just want to peek. Do we get an order? Okay. So there are some orders on this. But it's just kind of weird. Like, we don't have the response from Doug's team. And it's just like, sometimes I wonder if we're going to see everything on this limited docket. And by the way, like, what they're uploading on this site, it only goes through July of this year. So anything that was filed isn't available if it was filed after July 1st of this year. So we were... Oh, wrong one. All right, so in Clardy, we're building on this. The court's going to hold as follows, that in sum, if a petition for a writ of error coram nobis, I'm just going to call it a coram nobis, is not timely filed, and the petition seeks tolling of the 1-year statute of limitations, the coram nobis court should first ascertain whether the petition cites new evidence discovered after expiration of the limitations period, and whether the coram nobis petition shows it was filed no more than 1 year after the petitioner discovered the new evidence. If so, the coram nobis court should assume arguendo the veracity of the new evidence cited in the coram nobis petition for the purpose of assessing whether to toll the statute of limitations. To grant tolling, the coram nobis court must find that the new evidence would, if credited, clearly and convincingly show that the petitioner is actually innocent of the underlying crime, that the petitioner did not commit the crime. If tolling is granted, the coram nobis court may then proceed to address the merits of the coram nobis petition under the standards in the coram nobis statute. So Clardy reinforces Nunley's requirement that equitable tolling be based on newly discovered evidence of actual innocence. It further clarifies that the coram nobis court must assess whether the new evidence, if credible, would demonstrate that the petitioner is actually innocent of the crime. Yeah, so if credited... Yeah, so, but with the tolling, if it's under the 1 year time, then the court should assume arguendo. But if it's after the tolling, the court must find, if credible, if credited, clearly and convincingly, that the petitioner is actually innocent. So that tolling, the timeline makes a difference. Petitioner Adams' petition fails to present newly discovered evidence, and I'm assuming what they're going to say is, you know, you didn't fall within the timeline, so now you have to meet that clear and convincing standard. So, additionally, Clardy simplifies this analysis by directing coram nobis courts to examine whether the new evidence contained in the petition, if credible, clearly and convincingly shows that the petitioner is actually innocent of the underlying crime. And they're going to argue here that the alleged newly discovered evidence consists of the unsworn statements of Lisa Sanders, the unsworn statements of Jason Autry, a signed affidavit of investigator Katie Spirko, who they're saying investigator here, and a signed affidavit of trial counsel Jennifer Thompson. We should pay attention to if they evolve, like how they characterize Katie Spirko as we go through these. As to the credibility of the statements made by Lisa Sanders and Jason Autry, the state would reference and incorporate prior arguments presented in what we just read that focus on the unsworn statements being paraded as credible by petitioner Adams. Additionally, the affidavits of Katie Spirko and Jennifer Thompson are completely devoid of any facts indicating any personal knowledge that petitioner Adams is actually innocent of the underlying crimes. All 4 exhibits fail to offer this court any credible new evidence that shows that petitioner Adams is actually innocent of the underlying crime. As cited above, Clardy requires significant, credible new evidence demonstrative of the petitioner's actual innocence be included in filing of a coram nobis petition. Petitioner's coram nobis falls far short of the threshold set forth in Clardy to achieve equitable tolling. Moreover, petitioner Adams' own admissions to multiple unrelated individuals concerning his involvement in the kidnapping, rape, and murder of Holly Bobo were the most incriminating pieces of evidence that the state of Tennessee presented at trial. The admissions came from the petitioner's own mouth, not anyone else's, including co-defendant Jason Autry. As was the case during his trial, Petitioner Adams' admissions are highly problematic for him in a quorum nobis proceeding. Clardy held to grant tolling, the quorum nobis court must find that the new evidence would, if credited, clearly and convincingly, show the petitioner is actually innocent of the underlying crime. In other words, that the petitioner did not commit the crime. Petitioner Adams cannot show he is actually innocent of the underlying crime, and that he did not commit the crime in light of his numerous admissions. And remember, we don't have subpoena gate starting yet with this ATM video, right? That's still further down the horizon. So every time they say he cannot show, I'm like, well, that ATM video. And as far as the state knows, nobody knows about it except them. So for the response stated, the reason stated in the motion to dismiss and everything else, the state requests that this court dismiss petitioner's quorum nobis without an evidentiary hearing. It's time barred, and ultimately petitioner Adams cannot meet the standard clear and convincing that he's actually innocent, that Clardy has made essential to trigger equitable tolling for untimely quorum nobis. So there we go. There's that one. And I want to make sure, I want to try to get to the order before we wrap up this stream today. All right, let's see. See how long this is. This one's a bit long. Give me a second. I'm thirsty. I'm going to throw you guys back with Jason Autry for a few minutes here. Right where we left off with, did you get a peel? I'll be right back.
Or through Dinsmore to Zach?
Dinsmore walked up to the window. They paid the money, and my money, and the appeal just come across from one hand to the other to me. And that was kind of the gateway that day that broke the ice that led into the future of me and Dinsmore being quote unquote friends. Once they made a drug deal with him, you know, he realized that.
I want to back up to the part where they were arguing about Holly. And I want you to use names instead of he said or him. Who said what about you didn't have to kill her, and then you're just as guilty, you hit it. It was unclear to me who said what.
Okay. Mr. Austin said, you didn't have to kill her. And he looked at him, Zach looked at him, he told him, he said, you're just as guilty, you hit it.
Are you using the word you hit it? You hit it?
Yeah.
Okay, what does that mean? What does that mean?
Fucked her.
So he said, you're just as guilty as I am, you hit it.
Yeah.
And then what happened after that?
They get into the fight. They get out of the truck, go to the front of the truck. Mr. Adams. And that ends it. By the time he lands that lick, Dinsmore's right.
Holly's house, is that correct?
That's correct. Went straight back to 235 Adams Lane.
And when you got back to Adams Lane, was the white Nissan Frontier back there? Was it still gone?
It was not there.
Did you hang around or did you leave when you got back?
I did not. As I testified that I had to be in another county at 3:30, and that was from where Zach lived to where I had to be. It was 35 to 40-minute drive. If you pushed it, you really had to go. So I didn't have enough meth left to supply, so I wasn't gonna stay anyway. I didn't have enough to get everybody high. I just had enough for me. I was an addict. I was looking out for me.
You used a phrase a minute ago, is that opened or broke the ice. We're talking about what had happened earlier on the 13th.
With Densmore. Is that what you're saying?
Well, no, I'm saying that what you heard on the way to Densmore's and at Densmore's sort of, well, okay. So you're saying that broke the ice with Densmore?
Yeah.
Okay.
As I testified, the reason that I didn't go directly to.
You guys don't have sound? Sorry. I got back and I see, plug it in, Fonny. Sorry, you got to watch Jennifer Nichols. Sorry. So let me do that thing where, well, I guess we don't need sound anyway. You can hear me, right? Oh, wait. So the sound cut out for you guys and then came back in? Maybe it's something, I don't know, it's happened to every single StreamYard thing. And I thought maybe it was something I was doing. But yesterday when I had Jim on co-hosting, I was still able to pull comments. It looked like I was off the screen and frozen, and then I was just a buffering circle. But I was still able to sit back here and flick the comments on the screen. So, hey, Turkisha. So that was weird. So I don't know. It has to be it's not my internet if I can still see and hear Jim in real time and pull the comments up. It's not a YouTube issue because the issue is happening before it gets to YouTube. So it's got to be StreamYard. But I don't know. I don't know how to fix it. And it just seems to be causing me grief. The next thing, so this was a bit longer, which is why I wanted to, get some fresh water and a cough drop. We're going to Glanville it. And this actually says it was 2nd of August. Yeah, 2nd of August. Okay. So petitioner's response to state's supplemental response regarding disclosure and state v. Clardy. So, the court asked the state at the June 14th, 2024 hearing if it provided in discovery documentation that Miss Bonnie Ham reported that what her friend Lisa Sanders told her. The state's subsequent written response was that it did not provide this in discovery. Mr. Adams thus submits the defendant was without error in not finding this evidence. The Tennessee Court of Appeals, right? Yeah, okay. No, Tennessee Code Annex. Yeah. Code Annotation. I don't like the way they call their rule book. I don't like that name. It's Tennessee Code. The state argues that Dr. Katie Spirko's interview is not properly dated, which it was not. However, Dr. Spirko states that she began her work after August of 2023. Thus, it was within 1 year of the filing on January 22nd, 2024. Under the new Clardy standard announced therein, this ground of the writ of error quorum nobis is considered timely, filed, and as grounds for relief, provided the disclosure is new evidence of actual innocence. So now they're going to address the Clardy holdings. So for the case, State v. Clardy, this case helps tremendously the contention that Mr. Adams is entitled to a new trial under the writ of error quorum nobis pursuant to Tennessee Code 40-26-105. The Clardy procedural history is important. So first here, Mr. Clardy was convicted of first-degree murder and 2 counts of attempted first-degree murder. Prior to his trial, his defense counsel did not ask for a ballistic testing on 3 different caliber casings found at the crime scene. Oh, I feel like I know where Bates is going. So 3 different caliber casings are found at the crime scene in Clardy. You've got a 40 Smith & Wesson, a 40 Smith & Wesson, a 9mm, and a .380 auto that were found at the scene of the crime. Investigators did not recover any of the weapons believed to be used by the assailants in the shooting. In a post-conviction proceeding, though, the .40 Smith & Wesson casings were matched to a Glock 23 that was used in a crime some 11 months after Mr. Clardy's crime and owned by a man named D'Antoine Collier. The 9mm cartridge casings were matched to other casings found at the scene of a homicide that involved Collier's cousin some 6 months after the underlying crime. Finally, the .380 auto cartridge case found at the scene was matched to a subsequent crime. The Clardy post-conviction relief court denied the request for a new trial. The trial court did not believe that the ballistics match to a firearm used in subsequent crimes by other individuals was sufficient grounds for a new trial. Uh-oh! In explaining its decision, the court opined, it is far from unusual for handguns to pass from person to person with no record of sale. There were 2 other individuals not apprehended in this case. Further, a handgun may be handed off or sold. The use of a handgun in a murder might only incentivize such a sale. So very important. They're saying that the jury might not have reached a different conclusion, that this evidence might not change the storyline of what the jury was considering at the time of the incident. On appeal, the Court of Criminal Appeals summarized the situation further. This evidence, while certainly exculpatory, does not prove Clardy's innocence by clear and convincing evidence. There were 3 individuals who participated in the shooting in this case. This newly discovered evidence suggested that Collier Thomas Collier is entering the picture, may have been involved. However, it does not mean that Clardy was not one of the 3 men. However, it is possible that Clardy possessed one of the firearms before D'Antoine or Thomas Collier. So even though the evidence is exculpatory, it does not prove Clardy's innocence by the clear and convincing standard. Clardy B. Adventure Aaron says, I'm glad you brought up Clardy because I've been dying to talk about it in my Cardi B voice. Oh, goodness. Oh, yeah, I see some Kathy emojis being dropped. Heck yeah. Let me pull it up on the screen here. We'll have Kathy come join us. All right, so we've got not one to give up. Mr. Clardy then procured an affidavit from Mr. Collier stating that he was not friends with or knew Thomas Clardy. 1 year later, Mr. Clardy filed a writ of error citing Mr. Collier's affidavit. In essence, the Supreme Court found Mr. Collier's statement, even if credited by the trial court, which, importantly, the trial court was instructed to do so at this stage, did not prove that Mr. Clardy was innocent of the crime. The Supreme Court, though, added 2 prongs for the statute of limitations test, both of which helped Mr. Adams. First, a petitioner who files his writ of error coram nobis after the 1-year statute of limitations period may only be told if the petitioner produces new discovered evidence that would, if true, establish clearly and convincingly that the petitioner is actually innocent of the underlying crime of which he was convicted. They have a footnote that says this point cannot be belabored enough to this court, and counsel apologizes for its repetitiveness. The Clardy court continues, if the petition is filed within 1 year of discovering the new evidence, the coram nobis court should assume arguendo the veracity of the new evidence cited in the coram nobis petition for the purposes of assessing whether to troll. There's a typo, it says troll instead of toll the statute of limitations. That's great. Troll the statute of limitations. So remember now at the beginning of this, Doug is saying, hey, we're actually within the 1 year time frame. So now Doug is adding that you have to assume arguendo that this new evidence is true, just for the purpose of, whether you're going to have an evidentiary hearing. We can move forward with this writ of error coram nobis. Second, and perhaps conspicuously absent from state's reply, is that the petitioner is required to file the writ of error Petitioner is required to file the writ of error no more than 1 year after it discovers the new evidence of actual innocence. It is helpful to acknowledge that Justice Kirby reminded all that the writ of error criminal cases in Tennessee are considered extraordinary relief, and as can be seen from the above statute, it comes with stringent statutory requirements, with a footnote. Mr. Clardy suggested that the tolling analysis was an abrogation of the statute, and the court should keep in place the lower standard of may have resulted a different judgment analysis. His argument ran out of steam, though, with Justice Kirby reminding the petitioner that the exception to the statute of limitations was judge-made, and thus the courts, not the legislature, was to define such parameters. And they say, see Clardy footnote at 11, in case Aaron's gonna go and look. So we've got, let's see, Lisa Sanders. Miss Sanders' statement was provided to the defendant through his agents, as they were after Dr. Spirko began work in August of 2023. Thus, the second prong of Clardy is easily satisfied. The first prong, evidence of actual innocence, is the main issue facing the court. With Miss Sanders, the issue is succinctly stated. Assume it is true that Miss Sanders saw Terry Britt wearing camouflage. Mr. Clint Bobo saw the abductor wearing camouflage. So assume that Lisa Sanders saw Terry Britt in camouflage driving in a way to conceal and trying to hide something in the northern Decatur County area on the morning the victim was abducted from her home. Assume further that the same man was driving around his four-wheeler with a white box on it. See, generally, they're saying the Exhibit 3 and paragraph 7 and 8. Thus, at this stage where the court has to assume the credibility of the submitted evidence, this evidence proves Terry Britt committed the crime against Miss Bobo and not Mr. Adams. This is evidence of actual innocence. And again, this is because he's arguing that the tolling is under a year. Jason Autry. By the state's failure to argue to the contrary, it seems established that the recantation to Dr. Spirko on December 22nd, 2023. Hey, that's 2 years ago. And a day. As recorded in Exhibit 2A, B12, and C are outlined in paragraph 10A through E, was within 1 year of Mr. Adams discovering the same. The issue is whether Mr. Autry's credible memory of April 13th, 2011 proves Mr. Adams is innocent, and his statement that Mr. Adams was an innocent man, taken as true, is clear and convincing evidence of Mr. Adams' actual innocence. The petitioner ended its amendment to the petition, stating that Mr. Adams is actually innocent of the charges for which I am convicted, and this new evidence proves it, or at least that I may have received a different result. And we've got a footnote. Oh my god, we're going to get a quote from Jennifer Nichols. The footnote says, clearly under Clardy, the latter portion of this paragraph pled in the alternative is not applicable. So then Doug says, here are the words of Jennifer Nichols in closing to the jury. I'm no rocket scientist. It doesn't take a rocket scientist to figure out how it happened. How do we know it happened like that? How do you know it happened at the hands of that man? How do you know? I'm not going to go back over everything you heard. Every single one of you was taking notes and listening the last 2 weeks. Jason Autry, number 1, told you what he witnessed with his own eyes. He told you what he did. He confessed multiple crimes under oath to you. And they cite the transcript there. Thus, for this analysis, we have to assume that the pled allegations are true, and that was a complete and total falsehood. General Nichols began outlining the ways in which Mr. Adams was guilty to the jury. Further, here is how General Hagerman summarized the state's vetting of what we now have to believe at this stage in the procedure of this case was totally false. Mr. Hagerman, actually, yeah, twofold. As soon as there was made a proffer, Mr. Scholl, the attorney for Mr. Autry, made all the counsels aware that his client had proffered with the state, and that we don't need a trial date. Also, Mr. Autry took agents of the TBI, along with prosecutors, along the route that he and Zach Adams drove that day, the location where Zach Adams shot her in the head, and other places of interest that he testified about. That trip, when Mr. Autry did that, was memorialized in TBI supplements, reports, and turned over to the defense counsel. Are they talking about... When was that memorialized? Did they do that like they did that one proffer session where they waited 2 months to memorialize it? Perhaps Mr. Adams' conviction stemming from fabricated and perjured testimony does not automatically make Mr. Adams actually innocent for the pleadings. However, Mr. Autry not only lied about Mr. Adams' whereabouts at trial, but his recantation, taken as true now procedurally per Clardy's guidance, accounted for both Mr. Adams' whereabouts and innocence. So on Exhibit 2A, Mr. Autry stated that I think me and Zach and were at the river that morning. I'm pretty sure that I met him down there getting high. My phone records had me in that area. And the only thing I was doing in that area was down at the bar or inaudible. He continues, we had to add Holly to that story. We already had a story. All we had to do is just add something. It is clear from the entire recantation that it was not that Mr. Autry was unaware of Zach's guilt or innocence, but rather he knew he was innocent. He summarized, it was the worst I ever felt in my life, coming back knowing that I just put an innocent man in prison. Exhibit 2B1, Mr. Autry's taped confession to perjury is presumed true arguendo, and as eyewitness, important in the state's mind, at least in 2017, recollection, establishes that Mr. Adams was and is an innocent man. The state argued he had knowledge of Adams' guilt because he was together with him during that day. Thus, for procedural posture, we are in now. They cannot credibly argue that Mr. Autry cannot definitively prove his innocence. Right, because the state's insisting they were together. Mr. Adams further incorporates all of its arguments, in its initial response to, we didn't fix the template, to the state's motion to dismiss into this brief. Their Clardy case is quite helpful to Mr. Adams' request for an evidentiary hearing on this writ. Clardy makes it clear that the court's job now is not to discredit the other inculpatory trial testimony, but assume the newly proffered evidence is true and determine if that is true. Does that prove actual evidence? Innocence? Actual evidence. It is difficult to even envision a scenario where it does not, with great respect to the state of Tennessee, who clearly do not want to concede that their well-respected, dedicated, and abled prosecutors were just completely lied to and deceived by the man, Mr. Autry, they were trying to kill for a crime he did not commit, with an investigation left open otherwise. So they're referencing Paul Hagerman speaking at the 2020 plea colloquy for Mr. Autry. It is to any admirer of justice, a morass of regret. Oh, that's great. No regrets. The state continues to point towards other evidence and asking the court to weigh both sets of evidence at this state, which is not the proper analysis now. At the evidentiary hearing, the court will first focus on what one can expect will be intense cross-examination from the state, aided by the very prosecutors who apparently vetted this story. The state further asked the court to discredit entirely Mr. Autry's statement that his story was fabricated, while relying almost exclusively on so-called confessions from various inmates and then drug addicts. It is respectfully disingenuous to say that those inmates and former drug users' statements, standing alone, justify guilt beyond reasonable doubt, but an eyewitness's alibi statements to Dr. Spirko can somehow not rise to the lesser, clear, and convincing evidence standard of innocence. This case needs an evidentiary hearing on the writ of error. Clardy guides us to further the conclusion. So that is from Doug. Okay, and they just attach here what we read from the state, where the state says, here, look at the Clardy case. Why is this repeating itself? I think they just uploaded it twice. Right? 8 pages and 8 pages. Yeah, I think they just uploaded this twice. All right, so now we get the order. Now we get the order. All right, so 10th of September. 10th of September. And also, let's see, we've got... Aaron says the clear and convincing standard irritates me to no end because what do you mean my client's DNA is nowhere at a crime scene with a ton of DNA? But who even cares because we don't know whose DNA it really is. All right, so this is now Bradbury. Order granting state's motion to dismiss and order dismissing petition. So this is happening in September of last year. The parties filed pleadings related to the issue of equitable tolling and presented oral argument on this issue. After argument, however, the Tennessee Supreme Court issued an opinion in Clardy v. State, clarifying the standards related to the equitable tolling of the statute of limitations on a writ of error quorum nobis petition. Accordingly, this court permitted the parties to file additional written arguments based upon the Clardy precedent. Having received and reviewed the additional arguments, the state's motion to dismiss is ripe for disposition. So, introduction here. Zachary Wright Adams seeks a writ of error quorum nobis from his 2017 convictions on first-degree murder. And this is like the first time we're seeing like lengthy writing from Bradbury, right? I think so. They've got the first-degree murder, the kidnapping, aggravated rape. He gets this agreed upon sentence of life without parole plus 50 years with a footnote that says at trial, the state sought the death penalty. After the jury returned its verdicts, petitioner and the state negotiated an agreed upon sentence in exchange for the withdrawal of the state's notice seeking the death penalty. So he's making sure he gets this recitation correct. Mr. Adams' motion for a new trial was denied on August 11th, 2020, and his appeal was denied on September 9th, 2022 by the Tennessee Court of Criminal Appeals. On January 22nd, 2024, Mr. Adams filed the above-styled petition for writ of error quorum nobis based on newly discovered evidence. The evidence that we relied on is the video statements of Jason Autry and Lisa Sanders. In these statements, Jason Autry recanted, and Lisa Sanders spoke of having seen a suspicious male in a truck on April 13th, 2011, who she later identified as Terry Britt. At trial, the defense argued that Terry Britt was responsible for the offenses. Affidavits of investigator Katie Spirko and attorney Jennifer Thompson were also submitted in support of this petition. The footnote here says, Attorney Thompson's affidavit was submitted in the April 2024 amendment to the petition for writ of error quorum nobis. Okay. The state argues that the evidence relied upon by Mr. Adams fails to allege facts that warrant equitable tolling of the statute of limitations. And even if tolling the statute of limitations is warranted, the petition is not supported by proper affidavits and is insufficient to establish actual innocence. Thus, this matter should be dismissed without a hearing. Mr. Adams contends that he is entitled to equitable tolling of the statute of limitations and a hearing on the merits of this petition. So, let's get to the writs of error quorum nobis. So, it's an extraordinary procedural remedy in which few cases fall. Tennessee General Assembly has limited the relief available through writ. It's got to be proper time, newly discovered evidence. If it's cumulative, it can't just be simply cumulative or serves no other purpose. I think this is new, Payne v. State. I don't know if I remember that name. It says, quoting the concurrence in Harris v. State, and there's a footnote, which was overruled on other grounds. The court indicated that the petitioner... Okay, this is where we get they're reusing this one. It has to be particular. It has to demonstrate that it's newly discovered. All of that stuff. Why it would have changed the trial. Why the petitioner couldn't have discovered it sooner. In Clardy, the Tennessee Supreme Court addressed issues involving only the standard to toll the statute of limitations for petitions for error quorum nobis, and not the standard for a determination on the merits of quorum nobis petitions. The court noted that the analysis for relief on the merits of the petition is separate and distinct from the analysis for whether the statute of limitations may be tolled. The Clardy case further stated that writs of error quorum nobis are no longer governed by the common law. Rather, in Tennessee, the availability of error quorum nobis relief is governed solely by statute. And consequently, relief must be determined by reference to the statutes. Error quorum nobis, and we're citing here, let's see. We get this extra part that says, however, owing to the civil heritage of the writ of error quorum nobis in Tennessee, the general statutes governing procedures for the writ remain codified in a section of the code pertaining to civil actions. These include the 1-year statute of limitations applicable to petitions for quorum nobis relief. In Nunley, this court clarified that, in Tennessee, Petitions for a writ of error coram nobis may be dismissed on the face of the petition without discovery, an evidentiary hearing, or notification to the opposing party. In keeping with the extraordinary nature of the writ, the petition must be pled with specificity. And we have a footnote, a long one, that says in Nunley, the court stated as follows. If the coram nobis petition does not show on its face that it is filed within the 1-year statute of limitations, the petition must set forth with particularity facts demonstrating that the prisoner is entitled to equitable tolling. So, again, it's got to be later arising grounds, and that with strict application of the statute of limitations would effectively deny the prisoner a reasonable opportunity to present his or her claims, though a prisoner is not entitled to equitable tolling to pursue a patently non-meritorious ground for relief. Trial courts need to conduct evidentiary hearings only when they are essential. This is consistent with the history of coram nobis and aligns with the abuse of discretion standard of appellate review of the trial judge's decision on whether to grant coram nobis relief. Timeliness under the statute of limitations in Tennessee Code annotated section 27-7-103 is not an affirmative defense. Rather, it is one of the essential elements of a coram nobis claim. Thus, a coram nobis petition must show on its face that it's timely filed. So, timeliness. So, pursuant to Tennessee Code, I always want to say annex, but it's annotated, 27-7-103, a petition for writ of error coram nobis must be filed within 1 year after the challenge judgment becomes final. Here, the parties agree that Petitioner Adams' petition for writ of error is untimely, as it was filed beyond the 1-year statute of limitations. Accordingly, the question this court must answer is whether Petitioner Adams is entitled to a tolling of the statute of limitations. And they're going to go through clarity again. So, let's see. The court discussed and clarified the standards related to equitable tolling. We looked at some of that. Here, the coram nobis court concluded, this is back to Clardy, that newly discovered evidence did not show he was actually innocent of the crime of which he was convicted. Let's see. We've got some emphasis, so let's read what they're emphasizing here. The tolling exception adopted in Workman is strictly limited to situations in which the petitioner brings to the coram nobis court new evidence that would, if considered credible, show he is actually innocent of the underlying crime. So we've got that bolded here. Now we're back to Bradbury's arguments. The Clardy court then proceeded to discuss the definition to apply the evidence of actual innocence for purposes of tolling and the statute of limitations. After discussing the parties' respective positions, the Clardy court held that actual innocence simply means nothing other than that the person did not commit the crime. The Clardy court next addressed the standard of proof required for newly discovered evidence of actual innocence to toll the statute of limitations in a coram nobis petition. Let's see. And this is some new stuff. So, to determine the appropriate standard for proof of actual innocence, we look at Workman's balancing process. Under the tolling analysis adopted in Workman, the coram nobis court must weigh the state's interest against the petitioner's private interests. This balance changes at different stages of criminal proceedings. Before the trial and at trial, the accused's liberty's interest is weighty indeed. He is entitled to a presumption of innocence and has many constitutional protections to ensure against the risk of convicting an innocent person. Once the jury returns a guilty verdict and the verdict is approved by the trial court, this has the effect of crediting the testimony of the witnesses for the state, resolving all conflicts in favor of the state, and replacing the presumption of innocence the defendant had at trial with a presumption of guilt. The old cloak. The convicted defendant, however, still has many avenues for relief, including a motion for a new trial, direct appeal, statutory post-conviction proceedings, and a coram nobis petition timely filed. In weighing the petitioner's liberty interest against the state's interest in preventing the litigation of stale and fraudulent claims, as time goes on, the convicted defendant exhausts the many remedies available to him. The state's interest in finality of the conviction becomes weightier. The administration of justice and the integrity of our court system demand, in addition to fair treatment under the law, a certain degree of finality to criminal judgments. Moreover, since 1998, Tennessee's Constitution gives victims of crime the right to a prompt and final conclusion of the case after the conviction or sentence. Under the implementing statute to this constitutional provision, all parties affected by a criminal offense, including the victim, survivors of the victim, and witnesses to the offense, shall be able to expect that the operation of the criminal justice system will not be unnecessarily delayed, and that they will be able to return to normal lives as soon as possible. For this reason, the tolling exception to the statute of limitations for writs of error coram nobis should be no broader than is needed to accommodate the requirements of due process. After all, the relief sought by a writ of error coram nobis is the setting aside of the conviction and the granting of a new trial. And for a petition that seeks tolling of the statute of limitations, this may be many years down the road. We know that the passage of time only diminishes the reliability of criminal adjudications, because of the very disruptive effect that litigating claims of actual innocence would have on the need for finality in criminal cases, and the enormous burden that having to retry cases based on often stale evidence would place on the state. The threshold for tolling the coram nobis statute of limitations should be high. And we're going to have some emphasis here. So balancing the interests of the state and victims against those of the error coram nobis petitioner. Bolded. We hold that the coram nobis statute of limitations may be tolled only if the petitioner produces newly discovered evidence that would, if true, establish clearly and convincingly that the petitioner is actually innocent of the underlying crime of which he was convicted. This court has explained the clear and convincing standard. To meet the clear and convincing standard, the trial court must determine that the evidence offered is not vague and uncertain. The clear and convincing evidence standard is more exacting than preponderance of the evidence, but less exacting than beyond a reasonable doubt, and it requires that there be no serious or substantial doubt about the correctness of the conclusions drawn from the evidence. Let's see. Thus, to toll the coram nobis statute of limitations, the new evidence of actual innocence, if credited, should leave the court with no serious or substantial doubt that the petitioner is actually innocent. In assessing a request to toll the statute of limitations, the coram nobis court should first assume arguendo that the new evidence cited in the coram nobis petition is credible, and then determine whether it would clearly and convincingly show that the petitioner did not commit the crime. So then the Clardy court summarizes as follows. In sum, if a petition for writ of error coram nobis is not timely filed, and the petition seeks tolling of the 1-year statute of limitations, the coram nobis court should first ascertain whether the petition cites new evidence discovered after expiration of the limits period, and whether the coram nobis petition shows it was filed no more than 1 year after petitioner discovered that new evidence. If so, the coram nobis court should assume arguendo the veracity of the new evidence cited in the coram nobis petition for the purpose of assessing whether to toll the statute of limitations. To grant, coram nobis gotta find new evidence, if credited, clearly and convincingly. Oh, it's like the 10th time reading this one. I think I get it now. That the petitioner is actually innocent of the underlying crime. That the petitioner did not commit the crime. If tolling is granted, the coram nobis court may then proceed to address the merits of the coram nobis petition under the standards in the coram nobis statute. So here's the analysis. In its motion to dismiss, the state asserts that Mr. Adams is not entitled to a tolling of the statute because he failed to allege sufficient facts to support equitable tolling through the unsworn statements of Jason Autry and Lisa Sanders, or the affidavits of investigator Katie Spirko and attorney Jennifer Thompson. In addition, the state alleges that the petition is not supported by proper affidavits and is insufficient to establish actual innocence. Because you can't credit something that's not sworn, really, is... Mr. Adams, on the other hand, alleges that equitable tolling applies because the relied upon evidence was not available to him previously, and the petition was filed less than the year from discovery of that evidence. So it would move the standard. We have to assume the veracity. Specifically, Mr. Adams alleged in his April 2024 amended petition that he first became aware of Mr. Autry's recantation of his trial testimony on December 19th, 2023. Relative to Ms. Sanders' testimony, Mr. Adams provided no clear statement of when he discovered this evidence, but he asserts in his pleadings that the investigator, Katie Spirko, was hired in August of 2023. Ms. Spirko was the person who interviewed Ms. Sanders and videoed her statement. Neither the record nor the pleadings suggest how or when Mr. Adams or Ms. Spirko became aware of Ms. Sanders. Applying the Clardy standards to the petition filed here, the court must first determine whether the petition cites new evidence. Based on the information contained in the petition as discussed above by the agreement of Mr. Adams, this court finds that the evidence was discovered after the limitations period. Next, the court must determine whether the quorum nobis petition shows it was filed no more than 1 year after the petitioner discovered the new evidence. Here, as discussed above, the petition was filed in January of 2024. Petitioner asserts that the video recantation of Jason Autry was discovered in December 2023. This assertion is supported by federal court pleadings in October of 2023, in which Mr. Autry relied upon the truthfulness of his trial testimony in consideration of his then upcoming federal sentencing. The statement of Lisa Sanders is not as straightforward. Mr. Adams provides no direct statement concerning the exact date of discovery of this evidence. However, the affidavit of the investigator indicates that she began working on the case in August of 2023. And Ms. Spirko took the statement of Ms. Sanders. For purposes of this court's ruling on the tolling issues, this court will assume the credibility of the information in the petition and the affidavits concerning the discovery of the evidence. Therefore, the court finds that the petition was filed no more than 1 year after Mr. Adams discovered the new evidence of the statements of both Mr. Autry and Ms. Sanders. Pursuant to Clardy, the court must now assume arguendo the veracity of the new evidence cited in the quorum nobis petition and determine if the new evidence, if credited, clearly and convincingly shows Mr. Adams is actually innocent. So first, the new evidence from Jason Autry. So first, we're going to consider the statement. Mr. Autry certainly provided testimony beneficial to the state's case at trial. Then, in December 2023, Mr. Autry recanted his trial testimony and stated that he made the story up to fit the evidence that he was provided through discovery by his attorneys in order to get a deal. In the video recantation, Mr. Autry did not provide Mr. Adams with a clear alibi. Mr. Autry first stated he could not recall what he was doing the day the victim went missing, other than what the phone records show. He indicated he heard about the victim going missing when he was in a bar. He also stated he may have been at the river getting high with the defendant. Then he said he was pretty sure he met him down there. None of these statements provide Petitioner Adams with a clear and convincing alibi to support actual innocence. Mr. Autry did not provide evidence of the guilt of another person in the offenses. Mr. Autry made nothing more than an unsubstantiated statement about the possibility of the victim's family or Terry Britt having been the actual offenders. In fact, at one point, Mr. Autry even stated there was a time when he believed Shane Austin and the others had committed the crimes. Mr. Autry certainly did not confess to the offenses himself. In sum, Mr. Autry merely stated that his trial testimony implicating Petitioner Adams was false. Also, as clearly argued by the state, Mr. Autry's testimony at trial was not the only evidence of guilt of Mr. Adams. Numerous witnesses at trial testified to Mr. Adams' inculpatory statements of his involvement in the offenses. Other physical evidence was introduced at trial. So you got scratches, the recovered pistol, the fight between Adams and Shane Austin, the Nissan truck, cell phone data, and the victim's autopsy. To this court, false testimony does not equate to actual innocence here. Mr. Autry's new statements do not leave this court without serious or substantial doubt that Mr. Adams is actually innocent. Accordingly, this court finds that Jason Autry's recantation does not clearly and convincingly establish that Mr. Adams is actually innocent of the offenses for which he was convicted. So next, they're going to look at Sanders. The remaining new evidence is the video statement of Lisa Sanders. Ms. Sanders stated that she saw a person, who she now identifies as Terry Britt, in camouflage clothing, acting suspiciously at about 7:45 in the morning on the date the victim went missing, and in the general area from where the victim was taken. While she stated it appeared that Mr. Britt was hiding something, she did not see the victim in the small, older model, gold/tan truck. Ms. Sanders saw the same individual in camouflage about 4 days later, riding a four-wheeler with a white box on the back, and again a couple months later at a store. She stated she did not know who the person was until she saw him testify during Petitioner's trial. Assuming what Ms. Sanders stated is credible, This does not clearly and convincingly establish petitioner is actually innocent of the offenses for which he was convicted. Mr. Britt's presence in the area does not establish petitioner's lack of guilt. Ms. Sanders' new statements do not leave this court without serious or substantial doubt that Mr. Adams is actually innocent. I know we had a bunch of Kathy emojis in the chat, so I just put it up. Let me take it down in case it's blocking things. And then conclusion, for the reasons set forth herein, this court does not find petitioner has carried his burden to toll the statute of limitations in this matter. Accordingly, the state's motion to dismiss without an evidentiary hearing is granted. And petitioner Zachary Wright Adams' petition for writ of error quorum nobis is dismissed. 10th day of December, signed by Brent Bradbury. So, there we go. That is probably had to be really disheartening to read. And we can't end there. We can't end there. So what do we have? What do we have going on in these follow-up days? Because I'm curious. So we've got a petitioner's motion to continue December trial date. Comes now that petitioner, by and through counsel. Let me make this bigger. Moves this court to remove the matter from the December trial date. For cause the petitioner would show unto the court. The defendant, through counsel, agreed to set this matter in both December of 2024 and January of 2025. At the time of this setting, the writ of error was pending and set for oral argument on June 14th, 2024. The ruling from this court was issued in September, and the delay, counsel respectfully suggests, was based in large part from the Clardy opinion from our Supreme Court. On September 11th, 2024, the court conferred with all involved regarding the scheduling of this case. The court required the parties to confer with their witnesses regarding the previously set trial dates. Counsel for the defendant secured one of the two main attorneys involved. However, perhaps the most important attorney on the ineffective assistance of counsel, Ms. Jennifer Thompson, advised she had a jury trial and could not be present in the December hearing. The defendant would be greatly prejudiced having to try this case without the main witness testifying during this trial. Further, it is logically too difficult to try this case in December without Ms. Thompson's presence, and then return later at a date for her testimony. It is anticipated that if she were to go last, then there would be considerable rebuttal testimony from both sides to address her testimony. Counsel for the defendant has agreed to virtually every procedural request from the state. Counsel for the defendant will soon file further motions to address other issues and does not want to waive such issues by filing this motion. The purpose of this motion is only to reset the pending PCR matter of the January dates per the scheduling order. All right, and then this is the order from October 9th granting this motion. So they're going to continue the hearing from the original date, December 2nd, 2024 to January 13th, 2025. They think it'll last 5 days. All hearings will be held in the Circuit Court of Hardin County. Yeah, there we go. Yeah, I'm not sure how we jumped. I'm not sure. I don't know if like something happened like between this time frame. All right, now I've got so many tabs open. Let me close some. All right, so State of Tennessee's motion regarding information filed under seal by the trial court. So, State of Tennessee wants this court to review in camera a document filed under seal by the trial court judge, the Honorable Creed McKinley. Furthermore, the state requests this honorable court schedule an in-chambers hearing regarding the contents of the sealed exhibit, and the state's request that said information remain under seal moving forward. So, is this why we're getting Is this like Dylan Adams stuff? So, in support thereof, the state submits the following. During the trial of State of Tennessee v. Zachary Adams, Judge McGinley conducted an in-chambers hearing regarding information shared with the court and defense attorneys by the State of Tennessee. Following said hearing, Judge McGinley ordered the transcript be filed and kept under seal with the criminal court clerk's office and included with the records in State of Tennessee v. Zachary Adams. The judge further barred all attorneys from mentioning the information shared during the in-chambers hearing. I have no idea, Aaron. I thought when I saw the order granting the motion to dismiss, I was like, oh. And I didn't really look beyond that. I just assumed that something after it would obviously have to reverse, right? Because there's so many more filings under it. We know this stuff is still going on. But then, I'm not even sharing the right screen. But then the filings kept going and they don't address how we're still here. So I don't know. That I don't actually know. The judge further barred all attorneys from mentioning the information shared during the in-chambers hearing. The same reasons that prompted the state's action at trial level exist for the post-conviction litigation, and the state is requesting to be heard on such. So, they want this court to review the thing that was sealed. And again, this is now moving us towards the end of November. So, let's see. So the state of Tennessee on November 7th of 2024, they file a motion to access defense counsel's client file and interview all defense trial counsel. So in Tennessee, when a petitioner in a post-conviction proceeding challenges their attorney's representation, it can result in an implied waiver of the attorney-client privilege. This waiver allows the state of Tennessee to access information from the defense attorney that is vital to its defense in the post-conviction action. Specifically, the state of Tennessee needs to interview Petitioner Adams' trial attorneys about the advice given to the Petitioner Adams regarding his rights, as this information is material to the issues raised by Petitioner Adams in his post-conviction allegations. So I'm thinking here, right to testify, the guidance of maybe don't take the stand. If the client attacks the competency of his attorney, the privilege is viewed as waived regarding the representation in issue. Petitioner Adams filed a petition for post-conviction relief on August 18, 2023, in which he attacks, on multiple grounds, the competency of his trial attorneys. Furthermore, Petitioner Adams filed an amended petition for post-conviction relief on January 22, 2024, in which he raised additional grounds attacking the competency of his trial attorneys. The state of Tennessee seeks an order from this court allowing us to review Jennifer Lynn Thompson, James Simmons, and Jerry Gonzalez's trial file for Petitioner Adams. The state also requested this court order that Jennifer Thompson, James Simmons, and Jerry Gonzalez speak with the state of Tennessee in preparation for the post-conviction claims no later than November 30th, 2024. So wherefore, premises considered, they want this court to order that Petitioner Adams' attorney-client privilege with his trial attorneys, being Jennifer Lynn Thompson, James Simmons, and Jerry Gonzalez, are waived as a result of Petitioner Adams filing his post-conviction relief claims. Just broad stroke. That undersigned counsel shall be allowed to review Jennifer Lynn Thompson, James Simmons, and Jerry Gonzalez's trial file. That Jennifer Lynn Thompson, James Simmons, and Jerry Gonzalez speak with the state in preparation for the post-conviction relief claims and any other general of specific relief the state of Tennessee may be entitled to. So you've got Amy Wyrick. Well, signed by permission by Boyano. All right, and then, November. In November, we have this. Motion to conduct Zoom hearing, in-person hearing with Jason Autry to determine if he waives attorney-client privilege. So the petitioner is asking, can we do a short hearing over Zoom with the prison facility in which Jason Autry is housed to determine if he waives all client privilege and private background privilege so that Mr. Scholl, Flanagan, and Chapman may testify in this case. All right, then we've got petitioner wants to subpoena to testify by deposition Michael Scholl and Michael Flanagan, and then also ADA Paul Hagerman. A drafted copy of the subpoena ducis tecum is attached to this motion. All three attorneys are being sent this motion and the drafted subpoena. Should they wish to participate in any hearing on this motion, then petitioner welcomes their presence. These witnesses are necessary to test. Oh, this is a long one, you guys. Unless, hold on, maybe the subpoenas are really long. Okay. These witnesses are necessary to testify regarding the perjured testimony that Mr. Autry presented to this court and the ways in which he became a state agent in doing so, and other issues, all of which are addressed in the petition and amended petition for post-conviction relief filed by Mr. Adams. The three attorneys are exempt from a subpoena for the hearing, but are obligated to stand for a deposition pursuant to 24-9-101A. The Tennessee Supreme Court states that the court can allow affidavit or deposition testimony, and they cite a statute that governs situations in which the petitioner is incarcerated out of state. However, 28 Section C3 states that each party shall have the right to subpoena witnesses for appearance at the evidentiary hearing. Initially, it would appear that the attorneys involved would be subject to subpoena powers of this court to appear in person. However, under TCA 24-9-101, the attorneys may, and probably will, rely upon their ability to stand for deposition instead of appear in person at the evidentiary hearing. Well, interestingly, because I think they all showed up, right? Counsel would further request the depositions take place via Zoom if petitioner or the state-elect wish to have their appearance through Zoom. Though if in person, it is understood that the attorneys will be deposed in either their home office or an agreeable place in the county of their employment. I really don't remember anyone referencing... Do you remember anyone representing a deposition during the PCRs? The hearings? To the extent there is any logistical issue scheduling these depositions, then the petitioner requests such deposition testimony be reserved and the court reserve ruling until such time can be finalized. Further, much of the evidence, the information regarding Mr. Flanagan and Scholl's testimony will be potentially protected attorney-client privilege, but such can be waived by the holder of the privilege, Mr. Jason Autry. Thus, the petitioner would request the court schedule these depositions after a hearing to determine if Autry waives the attorney-client privilege and private investigator privilege. So, there we go. They want all of those things. Is the state going to say no? All right, so the state has an 8-page response. Oh. Wait, this is from Doug. Maybe we'll stop here. Because this one's a bit long and they're attaching the Board of Professional Responsibility formal ethics opinion. So maybe we'll kick off with that next stream. So we've made it through. We are in almost December 2024. I have no idea. That's true. Okay, so it might be sealed. So, and maybe they're all just not referencing it. Yeah, I still don't know how we got from, and hey, Emily, I still have no idea how we got from dismissal to still going. I don't know. Maybe I'll try to like Google and see if there's a news article that covered it, but really there aren't that many news articles covering these proceedings. A lot of the updates are like video articles from Law and Crime or Court TV. So, but I'll look and see what I can find. It is 4 o'clock. I read a lot and I lose my voice easily. I've lost my voice like 3 times. So let's see who's live. I'll set up a quick redirect. And I will be back with Miss Janet Demeanor. I think she's starting at 7 p.m. Eastern. But I'll be on with her at 7:30 Eastern, airing up my grievance. Probably just going to talk about this case. I don't even think we have time to throw Courtney Clinny in the mix. So that will be in 3.5 hours. We've got, who is live right now? All right, so we've got whoever wants to load. All right, Defense Diaries is live talking about Kelsey Fitzsimmons. So, since I kind of like gave a guess of what happened, I'm going to defer to them to explain what actually happened with Kelsey Fitzsimmons. And, you know, I think she's released now. She was granted bail. But they'll have in-depth knowledge on that issue. I just had like a cursory overview of what was going on. So that's where we'll redirect here. Again, in a few hours, I'll be live with Miss Janet Demeanor, so come hang out. I'm sure they're going to have Nurse Kim on, so I'm sure they're going to talk about some Karen Reed grievances as well. Yeah, it's just going to be a good time, I think. It's just a little Festivus celebration. Yes, let me drop the link. And you'll notice it's like they created this page just to upload. I don't know. And it stops in July. So that's where it ends. Ending here, we got a free Zach Adams and free Zachariah Anderson. Y'all. So, gotta add the y'all. So that's how we're gonna close out. Thank you so much, you guys, for sitting here for like a million hours reading all these filings. This was a lot of reading. Tomorrow, if I do a stream, will be much shorter. Or we'll be watching videos. So, lots going on. I hope to see you guys over at Defense Diaries and at Miss Janet Demeanor's. And you still can't access that? I'm scared to refresh. Oh, snap. Okay, I'm downloading all of these right now. Because I'm getting the same thing. Okay, well, guys, I'm going to redirect you. Say hi to Defense Diaries for me. Since I can still open these while I'm in here in the other browser, I'm going to sit here. And it's crazy because I was like, this morning I'm going to download them. And I kept telling myself, well, I have until January 1st. So I put it off. I'm going to sit here and I'm going to download all of these and hope I don't accidentally close the browser. So before I screw something up, I'm going to end the stream. See you guys soon. I'm going to create a drive folder. Yeah, what the heck? Maybe they did it before the court closes for the holiday? Yeah, that's up here. But still, they said January 1st. So maybe the court is closed all the way through January 1st, and they said shut it down before end of business day today. Yeah, I don't know. But still. All right, I'm going to go and download these guys. How annoying. I'll make a drive folder and share with you guys. Give me some time, though, because I want to make sure I name everything correctly. Other than that, thank you for noticing that, Aaron, because I would have closed all my tabs as soon as ending this. So, thank you, everybody. See you guys soon. Everybody take care, and if I don't see you, have a great holiday. Bye, guys.